Section 19 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1 by James Kent. Of Judicial Constructions of the Powers of Congress, Part 1. I proceed to consider the cases in which the powers of Congress have been made the subject of judicial investigation. Priority of the United States as a creditor. 1. Congress have declared by law that the United States were entitled to priority of payment over private creditors in cases of insolvency and in the distribution of the estates of deceased debtors. The Act of Congress of 31st July 1789, Section 21, confined the priority to Custom House bonds. The Act of 4th August 1790, Chapter 35, Section 45, limited the priority in the same manner. The Act of 2nd May 1792 placed the surety in a Custom House bond, who paid the debt on the same footing in respect to priority as the United States, and it confined the cases of insolvency mentioned in the former law to those of a voluntary assignment and of attachments against absconding, concealed, or absent debtors. The Act of 3rd March 1797, Chapter 74, Section 5, went further and gave the United States a preference in all cases whatsoever, whoever might be the debtor, or however he might be indebted, in case the debtor became insolvent, or the assets in the hands of his representatives after his death were insufficient to pay his debts. This priority was declared to extend to cases in which the insolvent debtor had made a voluntary assignment of all his property, or in which his effects had been attached as an absconding, concealed, or absent debtor, or in which an act of legal bankruptcy had been committed. The Act of March 2, 1799, Chapter 128, Section 65, provided that in the like cases of insolvency, or where any estate in the hands of executors, administrators, or assignees should be insufficient, debts due to the United States on bonds taken under the Collection Act should have preference, and sureties in such bonds on paying the same had the same preference as was reserved to the United States. Those were the legislative provisions giving preference to debts due to the United States, and in Fisher v. Blight, the authority of Congress to pass such laws was drawn in question. The point discussed in that case was whether the United States, as holders of a protested bill of exchange, negotiated in the ordinary course of trade, were to be preferred to the general creditors when the debtor becomes bankrupt. The Supreme Court decided that the acts of Congress giving that general priority to the United States were constitutional. It was a power founded on the authority to make all laws which should be necessary and proper to carry into effect the powers vested by the Constitution in the government of the United States. Where the end was within the lawful powers of the government, Congress possessed the choice of the means, and were empowered to use any means which were in fact conducive to the exercise of the powers granted. The government is to pay the debts of the Union, and must be authorized to use the means most eligible to effect that object. It has a right to make remittance by bills or otherwise, and to take those precautions which will render the transaction safe. If this claim of priority interferes with the right of the state's sovereignties respecting the dignity of debts, and defeats the measures which they would otherwise have a right to adopt to secure themselves, it is a necessary consequence of the supremacy of the laws of the Union on all subjects to which the legislative power of Congress extends. The principle was here settled that the United States are entitled to secure to themselves the exclusive privilege are being preferred as creditors to private citizens, and even to the state authorities, in all cases of the insolvency or bankruptcy of their debtor. But the court observed that no lien was created by the statutes giving the preference. No bona fide transfer of property in the ordinary course of business was overreached. It was only a priority of payment, which under different modifications was regulation in common use, and a bona fide alienation of property before the right of priority attached was admitted to be good. The next case that brought into discussion this question of priority was that of the United States v. Holy. It was there held that the priority to which the United States were entitled did not partake of the character of a lien on the property of public debtors. The United States, in the mere character of creditor, have no lien on the real estate of their debtor. If the priority existed from the time the debt was contracted, and the debtor should continue to transact business with the world, the inconvenience would be immense. The priority only applied to cases where the debtor had become actually and notoriously insolvent, and, being unable to pay his debts, had made a voluntary assignment of all his property, or, having absconded or absented himself, his property had been attached by process of law. A bona fide conveyance of part of the property of the debtor, not for the fraudulent purpose of evading the law, but to secure a fair creditor, is not a case within the Act of Congress giving priority. In this case of the United States versus Huey, a collector of the revenue had mortgaged part of his property to his surety in his official bond to indemnify him from his responsibility as surety, and to secure him from his existing and future endorsements for the mortgager at bank. And the mortgage was held valid against the claim of the United States, although the collector was, in point of fact, unable to pay all his debts at the time the mortgage was given, and although the mortgagee knew, when he took the mortgage, that the mortgagor was largely indebted to the United States. Afterwards, in Harrison v. Sterry, it was held that in the distribution of a bankrupt's effects, the United States was entitled to their preference, although the debt was contracted by a foreigner in a foreign country, and the United States had proved their debt under a commission of bankruptcy. Though the law of the place where the contract is made be, generally speaking, the law of the contract, yet the right of priority forms no part of the contract. The insolvency which was to entitle the United States to a preference was declared in Prince v. Bartlett to mean a legal and known insolvency, manifested by some notorious act of the debtor, pursuant to law. This was giving to the world some reasonable and definite test by which to ascertain the existence of the latent and dangerous preference given by law to the United States. In this last case, the effects of an insolvent debtor, duly attached in June, were considered not to be liable to the claim of the United States on a custom house bond given prior to the attachment, and put in suit in August following. The private creditor had acquired a lien by his attachment which could not be divested by process on the part of the United States subsequently issued. Nor will the lien of a judgment creditor, duly perfected, be displaced by the mere priority of the United States. The word insolvency in the Acts of Congress of 1790, 1797, and 1799 means a legal insolvency, and a mere state of insolvency or inability in a debtor to pay all his debts gives no right of preference to the United States, unless it be accompanied by a voluntary assignment of all the property for the benefit of creditors, or by some legal act of insolvency. If before the right of preference has accrued, the debtor has made a bona fide conveyance of his estate to a third person, or has mortgaged the same to secure a debt, or if the property has been seized under an execution, the property is divested from this debtor and cannot be made liable to the United States. The United States have, accordingly, a preference as creditors to the extent above declared in 4 cases, viz. 1. In the case of the death of the debtor without sufficient assets. 2. Bankruptcy of legal insolvency manifested by some act pursuant to law. 3. A voluntary assignment by the insolvent of all his property to pay his debts. 4. In the case of an absent, concealed, or absconding debtor whose effects are attached by process of law. The priority was intended to operate only where by law or by the act of the debtor his property was sequestered for the use of his creditors, and it is proper that this prerogative right of the United States should be strictly construed and precisely defined, for it is in derogation of the general rights of creditors. The government was a privileged creditor under the Roman law and entitled to priority in the payment of debts. The cessio bonorum was made subject to this priority. This is generally the case in all modern bankrupt and insolvent laws. In England, the king's claim is preferred to that of a subject, provided the king's process was commenced before the subject had obtained judgment. As to the fiscal lien of the government of the United States, it was held in Harris v. Denny that the government had a lien on goods imported for the payment of duties accruing on them, and not secured by bond, and that the United States were entitled to the custody of the goods until the duties were paid or secured, and any attachment of the goods under state process during such custody was void. On the other hand, it was held that the government had no general lien on the goods of the importer for duties due by him upon other importations. Congress may create a bank. 2. The next case, which called forth the construction from every part of the government as to the implied powers of Congress, was whether Congress had power to incorporate a bank. In the year 1791, the Secretary of the Treasury had recommended the institution of a national bank as being of primary importance to the prosperous administration of the finances and of the greatest utility in the operations connected with the support of public credit. But the bill for establishing a bank was opposed in the House of Representatives as not authorized by the Constitution. It was contended that the government of the United States was limited to the exercise of the enumerated powers, and that the power to incorporate a bank was not one of them, and if vested in the government, it must be an implied power, and it was contended that the power given to Congress to pass all laws necessary and proper to execute the specified powers must be limited to means necessary to the end, and incident to the nature of the specified powers. On the other hand, it was urged in favor of the bill that incidental as well as express powers necessarily belonged to every government, and that when a power was delegated to affect particular objects, all the known and usual means of effecting them passed as incidental to them, and it was insisted that a bank was a known and usual instrument by which several of the enumerated powers of the government were exercised. After the bill had passed the 2 houses of Congress, the question touching its constitutionality was agitated with equal ability and ardor in the executive cabinet. The Secretary of State and the Attorney General conceived that Congress had transcended their power, but the Secretary of the Treasury maintained the opposite opinion. Their respective opinions were founded on a train of reasoning, denoting great investigation of all the leading and fundamental principles of the Constitution, and they were submitted to the consideration of the President of the United States. It was argued against the constitutionality of the Act that the power to incorporate a bank was not among the enumerated powers, and take a single step beyond the boundaries specially drawn around the powers of Congress would be to take possession of an undefined an undefinable field of power, that though Congress were authorized to make all laws necessary and proper for carrying into execution the enumerated powers, they were confined to those means which were necessary and not merely convenient. It meant those means without which the grant of the power would be nugatory, and that if such a latitude of construction was allowed as to give Congress any implied power on the ground of convenience, it would swallow up all the list of enumerated powers and reduce the whole to one phrase. On the other hand, it was contended that every power vested in the government was, in its nature, sovereign, and gave a right to employ all the means fairly applicable to the attainment of the end of the power, and not specially precluded by specified exceptions, nor contrary to the essential ends of political society. That though the government of the United States was one of limited and specified powers, it was sovereign with regard to its proper objects and to its declared purposes and trusts, that it was incident to sovereign power to erect corporations, and consequently, it was incident to the United States to erect one in relation to the objects entrusted to its management, that implied powers are as completely delegated as those which are expressed, and the power of erecting a corporation may as well be implied as any other instrument or means of carrying into execution any of the specified powers, that the exercise of the power in that case had a natural relation to the lawful ends of the government, and it was incident to the sovereign power to regulate and to employ all the means which apply with the best advantage to that regulation, that the word necessary in the Constitution ought not to be confined to those means, without which the grant of power would be nugatory, and it often means no more than needful, requisite, useful, or conducive to. And that was the true sense in which the word was used in the Constitution. The relation between the measure and the end was the criterion of constitutionality, and not whether there was a greater or less necessity or utility. The infinite variety, extent, and complexity of national exigencies necessarily required great latitude of discretion in the selection and application of means, and the authority entrusted to government ought and must be exercised on principles of liberal construction. President Washington gave those arguments to his cabinet a deliberate and profound consideration, and it terminated in a conviction that the incorporation of a bank was a measure authorized by the Constitution, and the bill passed into law. This same question came before the Supreme Court of the United States in 1819, in the case of McCulloch v. the State of Maryland, in reference to the Bank of the United States, which was incorporated in 1816, and upon which the legislature of Maryland had imposed a tax. Notwithstanding the question arising of the construction of the powers of Congress had been settled, so far as an act of Congress could settle it, in 1791, and again in 1816, it was thought worthy of a renewed discussion in that case. The Chief Justice, in delivering the opinion of the court, observed that the question could scarcely be considered as an open one, after the principle had been so early introduced and recognized by many successive legislatures, and had been acted upon by the Judicial Department as a law of undoubted obligation. He admitted that it belonged to the Supreme Court alone to make a final decision in the case, and that the question involved a consideration of the Constitution in its most interesting vital parts. It was admitted that the government of the United States was one of enumerated powers, and that it could exercise only the powers granted to it. But though limited in its powers, it was supreme with its sphere of action. It was the government of the people of the United States, and emanated from them. Its powers were delegated by all, and it represented all, and acted for all. In respect to those subjects on which it can act, it must necessarily bind its component parts, and this was the express language of the Constitution, when it declared that the Constitution and the laws made in pursuance thereof were the supreme law of the land, and required all the officers of the state governments to take an oath of fidelity to it. There was nothing in the Constitution which excluded incidental or implied powers. The Articles of the Confederation gave nothing to the United States but what was expressly granted. But the new Constitution dropped the word expressly and left the question whether a particular power was granted to depend on a fair construction of the whole instrument. No Constitution can contain an accurate detail of all the subdivisions of its powers, and of all the means by which they might be carried into execution. It would render it too prolix. Its nature requires that only the great outlines should be marked, and its important objects designated, and all the minor ingredients left to be deduced from the nature of those objects. The sword and the purse, all the external relations, and no inconsiderable portion of the industry of the nation were entrusted to the general government, and a government entrusted with such ample powers, on the due execution of which the happiness and prosperity of the nation vitally depended, must also be entrusted with ample means for their execution. Unless the words imperiously require it, we ought not to adopt a construction which would impute to the framers of the Constitution, when granting great powers for the public good, the intention of impeding their exercise by withholding a choice of means. The powers given to the government imply the ordinary means of execution, and the government, in all sound reason and fair interpretation, must have the choice of the means which it deems the most convenient and appropriate to the execution of the power. The power of creating a corporation, though appertaining to sovereignty, was not a great, substantive, and independent power, but merely a means by which other objects were accomplished, in like manner as no seminary of learning is instituted in order to be incorporated, but the corporate charter is conferred to subserve the purposes of education. The power of creating a corporation is never used for its own sake, but for the purpose of effecting something. It is nothing but ordinary means to attain some public and useful end. The Constitution has not left the right of Congress to employ the necessary means for the execution of its powers to general reasoning. It is expressly authorized to employ such means, and necessary means, in the sense of the Constitution, does not import an absolute physical necessity, so strong that one thing cannot exist without the other. It stands for any means calculated to produce the end. The word necessary admits of all degrees of comparison. A thing may be necessary, or very necessary, or absolutely and indispensably necessary. The word is used in various senses, and in its construction the subject, the context, the intention, are all to be taken into view. The powers of the government were given for the welfare of the nation. They were intended to endure for ages to come, and to be adapted to the various crises of human affairs. To prescribe the specific means by which government should in all future time execute its power, and to confine the choice of means to such narrow limits as should not leave it in the power of Congress to adopt any which might be appropriate and conducive to the end, would be most unwise and pernicious, because it would be an attempt to provide by immutable rules for exigencies which, if foreseen at all, must have been seen dimly, and would deprive the legislature of the capacity to avail itself of experience, or to exercise its reason, and accommodate its legislation to circumstances. If the end be legitimate, and within the scope of the Constitution, all means which are appropriate and plainly adapted to this end, and which are not prohibited, are lawful. and a corporation was a means not less usual, nor of higher dignity, no more requiring a particular specification than other means. A national bank was a convenient, a useful and essential instrument in the prosecution of the fiscal operations of the government. It was clearly an appropriate measure, and while the Supreme Court declared it to be within its power and its duty to maintain that an act of Congress exceeding its power was not the law of the land, yet if a law was not prohibited by the Constitution and was really calculated to effect an object entrusted to the government, the court did not pretend to the power to inquire into the degree of its necessity. That would be passing the line which circumscribes the judicial department and be treading on legislative ground. The court therefore decided that the law creating the Bank of the United States was one made in pursuance of the Constitution, and that the branches of the national bank proceeding from the same stock and being conducive to the complete accomplishment of the object were equally constitutional. The Supreme Court were afterward led in some degree to review this decision in the case of Osborne v. the United States Bank, and they there admitted that Congress could not create a corporation for its own sake or for private purposes. The whole opinion of the court in the case of McCulloch v. the State of Maryland was founded on and sustained by the idea that the bank was an instrument which was necessary and proper for carrying into effect the powers vested in the government. It was created for national purposes only, though it was undoubtedly capable of transacting private as well as public business. And while it was the great instrument by which the fiscal operations of the government were effected, it was also trading with individuals for its own advantage. The bank, on any rational calculation, could not effect its object unless it was endowed with the faculty of lending and dealing in money. This faculty was necessary to render the bank competent to the purposes of government, and, therefore, it was constitutionally and rightfully engrafted in the institution. Rules of taxation. 3. The construction of the powers of Congress relative to taxation was brought before the Supreme Court in 1796 in the case of Hilton v. the United States. By the Act of 5th June 1794, Congress laid a duty upon carriages for the conveyance of persons, and the question was whether this was a direct tax within the meaning of the Constitution. If it was not a direct tax, it was admitted to be rightly laid under that part of the Constitution which declares that all duties, imposts, and excises shall be uniform throughout the United States. But if it was a direct tax, it was not constitutionally laid, for it must then be laid according to the census, under that part of the Constitution which declares that direct taxes shall be apportioned among the several states according to numbers. The Circuit Court in Virginia was divided in opinion on the question, but on appeal to the Supreme Court, it was decided that the tax on carriages was not a direct tax within the letter of meaning of the Constitution, and was therefore constitutionally laid. The question was deemed of very great importance and was elaborately argued. It was held that a general power was given to Congress to lay and collect taxes of every kind or nature without any restraint. They had plenary power over every species of taxable property except exports. But there were two rules prescribed for their government, the rules of uniformity and the rule of apportionment. 3 kinds of taxes, viz., duties, imposts, and excises, were to be laid by the first rule, and capitation and other direct taxes by the second rule. If there were any other species of taxes, as the court seemed to suppose there might be, that were not direct and not included within the words duties, imposts, or excises, they were to be laid by the rule of uniformity or not, as Congress should think proper and reasonable. The Constitution contemplated no taxes as direct taxes, but such as Congress could lay in proportion to the census, and the rule of apportionment could not reasonably apply to a tax on carriages, nor could the tax on carriages be laid by that rule, without very great inequality and injustice. If two states equal in census were each to pay $8,000 by a tax on carriages, and in one state there were 100 carriages, and in another 1,000, the tax on each carriage would be 10 times as much in one state as in the other. While A in the one state would pay for his carriage $8, B in the other state would pay for his carriage $80. In this way, it was shown by the court that the notion that a tax on carriages was a direct tax within the purview of the Constitution, and to be apportioned according to the census would lead to the grossest abuse and oppression. This argument was conclusive against the construction set up, and the tax on carriages was considered as included within the power to lay duties, and the better opinion seemed to be that the direct taxes contemplated by the Constitution were only two, viz., a capitation or poll tax and a tax on land. The court concluded that the tax on carriages was an indirect tax on expense or consumption, and therefore properly laid pursuant to the rule of uniformity. In Loughborough v. Blake, the power of taxation was again brought under judicial discussion. The question was immediately of a local nature, and it was whether Congress had the right to impose a direct tax upon the unrepresented District of Columbia. But there were principles involved in the decision, which had an extensive and important relation to the whole United States. It was declared that the power to tax extended equally to all places over which the government extended. It extended as well to the District of Columbia and to the territories which were not represented in Congress, as to the rest of the United States. Though duties were to be uniform and taxes were to be apportioned according to numbers, the power was coextensive with the empire. The inhabitants of the territories of Michigan and of Florida and Arkansas, for instance, as well as the District of Columbia, though without any representation in Congress, was subject to the full operation of the power of taxation, equally as the people of New York or Massachusetts. But the court held that Congress are not bound, though they may, in their discretion, extend a direct tax to the territories as well as to the states. A direct tax, if laid at all, must be laid on every state conformably to the census, and therefore Congress has no power to exempt any state from its due share of the burden. But it was understood that Congress were under no necessity of extending a tax to the unrepresented District of Columbia and to the territories, though if they be taxed, then the Constitution gives the rule of assessment. This construction was admitted to be most convenient, for the expense of assessing and collecting a tax in a territory, as the Northwest Territory, for instance, might exceed the amount of the tax. Here was an anomalous case in our government, in which representation and taxation are not inseparable, though the principle that the power of taxation could not rightfully exist without representation was a fundamental ground of our revolution. The court did not consider a departure from a general principle in this case to be very material or important, because the case was that of territories which were in a state of infancy, advancing to manhood and looking forward to complete equality as soon as that state of manhood should be attained. It was the case also of the District of Columbia, which had voluntarily relinquished the right of representation and adopted the whole body of Congress for its legitimate government. End of section 19. Section 20 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1 by James Kent. Of Judicial Constructions of the Powers of Congress, Part 2. Right of domain as to Indian lands. 4. Congress have the exclusive right of preemption to all Indian lands lying within the territories of the United States. This was so decided in the case of Johnson v. McIntosh. Upon the doctrine of the court in that case, and in that of Fletcher v. Peck, the United States owned the soil as well as the jurisdiction of the immense tracts of unpatented land included within their territories, and of all the productive funds which those lands may hereafter create. The title is in the United States by the Treaty of Peace with Great Britain, and by subsequent cessions from France and Spain, and by cessions from the individual states, and the Indians only have a right of occupancy, and the United States possess the legal title subject to that occupancy, and with an absolute and exclusive right to extinguish the Indian title of occupancy either by conquest or purchase. The title of the European nations, and which passed to the United States, to this immense territorial empire, was founded on discovery and conquest, and by the European customary law of nations. Prior discovery gave this title to the soil, subject to the possessory right of the natives, and which occupancy was all the right that European conquerors and discoverers, and which the United States is succeeding to their title, would admit to reside in the native Indians. The principle is that the Indians are to be considered merely as occupants, to be protected while in peace in the possession of their lands, but to be deemed incapable of transferring the absolute title to any other than the sovereign of the country. The Constitution gave to Congress the power to dispose of and to make all needful rules and regulations respecting the territory or other property belonging to the United States, and to admit new states into the Union. Since the Constitution was formed, the value and efficacy of this power have been magnified to an incalculable extent by the purchase of Louisiana and Florida, and under the doctrine contained in the cases I have referred to, Congress have a large and magnificent portion of territory under their absolute control and disposal. This immense property has become national and productive stock, and Congress, in the administration of this stock, have erected temporary governments under the provisions of the ordinance of the Congress under the Confederation, and they have appointed the officers to each territory and allowed delegates in Congress to be chosen by the inhabitants every second year, and with the right to debate but not to vote in the House of Representatives. The unpatented lands belonging to the United States within the states of Ohio, Indiana, Illinois, Michigan, and the territory of Wisconsin arose from cessions from the states of Virginia, Massachusetts, Connecticut, and New York before the adoption of the present Constitution of the United States. North Carolina, South Carolina, and Georgia made similar cessions of their unpatented lands, and which now compose the states of Tennessee, Alabama, and Mississippi. The lands so ceded were intended to be and were considered as constituting a common fund for the benefit of the Union, and when the states in which the lands are now situated were admitted into the Union, the proprietary right of the United States to those unimproved and unsold lands was recognized. Those lands belonged to the United States as part of their public domain, subject to the Indian right and title of occupancy, in all cases in which the same has not been lawfully extinguished. It is not to be concealed, however, that the title of the United States to the unappropriated lands, lying within the limits of the separate states, has been seriously questioned by some of them, as by Mississippi, Illinois, and Indiana. The latter state, in January 1829, advanced a claim to the exclusive right to the soil and eminent domain of all the unappropriated lands within her acknowledged boundaries. And in 1830, Mississippi put forth a similar claim. But the cessions of the territorial claims of the separate states to the Western country were called for by the resolutions of Congress of the 6th of September and 10th of October, 1780, and were made upon the basis that they were to be disposed of for the common benefit of the United States. It was stipulated by Congress in the last resolution that the lands to be ceded should be disposed of for the common benefit of the United States, be settled and formed into distinct republican states with a suitable extent of territory, become members of the American Union, and have the same rights of sovereignty, freedom, and independence as the other states. It was likewise provided by the Ordinance of July 13, 1787, for the government of the territory of the United States northwest of the River Ohio, that the legislators of the districts or new states to be erected therein should never interfere with the primary disposal of the soil by the United States in Congress assembled, nor with any regulations Congress may find necessary for securing the title in such soil to the bona fide purchaser. Effect of public records. 5. By the Constitution of the United States, Congress were, by general laws, to prescribe the manner in which the public acts, records, and judicial proceedings of every state should be proved, and the effect thereof in every other state. In pursuance of this power, Congress, by the Act of May 26, 1790, provided the mode by which records and judicial proceedings should be authenticated, and then declared that they should have such faith and credit given to them in every court within the United States, as they had by law or usage in the courts of the state from whence the records were taken. Under this act it was decided in the case of Mills v. Durkee that if a judgment duly authenticated had, in the state court from whence it was taken, the faith and credit of the highest nature, viz., record evidence, it must have the same faith and credit in every other court. It was declaring the effect of the record to declare the faith and credit that were to be given to it. The Constitution intended something more than to make the judgments of state courts prima facie evidence only. It contemplated a power in Congress to give a conclusive effect to such judgments. A judgment is, therefore, conclusive in every other state, if a court of the particular state where it was rendered would hold it conclusive. Nil debet is not a good plea in a suit on a judgment in another state, because not a good plea in such state. Nul til record is the proper plea in such a case. The same decision was followed in Hampton v. McDonald, and the doctrine contained in it may now be considered as the settled law of the land. It is not, however, to be understood that nul til record is, in all cases, the necessary plea, but any special plea may be pleaded which would be good to avoid the judgment in the state where it was pronounced. And in Mayhew v. Thatcher, the court would seem to imply that a judgment in one state founded on an attachment in rem would not be conclusive evidence of the debt in other states if the defendant had not personal notice of the suit so as to have enabled him to defend it. Power of Congress over the militia. 6. Congress have authority to provide for calling forth the militia to execute the laws of the Union, suppress insurrections and repel invasions, and to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the state, respectively, the appointment of the officers and the authority of training the militia, according to the discipline prescribed by Congress. The President of the United States is to be the commander of the militia when called into actual service. The Act of 28th of February 1795 authorized the President in case of invasion or of imminent danger of it to call forth such number of militia most convenient to the scene of action as he might judge necessary. The militia so called out are made subject to the rules of war, and the law imposes a fine upon every delinquent to be adjudged by a court-martial composed of militia officers only. These militia court-martials are to be held and conducted in the manner prescribed by the Articles of War, and the Act of 18th of April, 1814, prescribes the manner of holding them. During the Act of 1812, the authority of the President of the United States over the militia became a subject of doubt and difficulty, and of a collision of opinion between the general government and the government of some of the states. It was the opinion of the government of Connecticut that the militia could not be called out upon the requisition of the general government, except in a case declared and founded upon the existence of one of the specified exigencies, that, when called out, they could not be taken from under the command of the officers duly appointed by the states, or placed under the immediate command of an officer of the Army of the United States, nor could the United States lawfully detach a portion of the privates from the body of the company to which they belonged, and which was organized with proper officers. This would, in the opinion of the government of Connecticut, impair and eventually destroy the state militia. When the militia are duly called into the service of the United States, they must be called as militia, furnished with proper officers by the state. Similar difficulties arose between the government of the United States and the state of Massachusetts on the power of the national government over the militia, but those states refused to furnish detachments of militia for the maritime frontier on an exposition of the Constitution, which they deemed sound and just. In Connecticut, the claim of the governor to judge whether the exigency existed, authorizing a call of the militia of that state, or any portion of it, into the service of the Union, and the claim on the part of that state to retain the command of the militia, when duly ordered out, as against any subordinate officer of the Army of the United States, were submitted to, and received the strong and decided sanction, not only of the governor and council of that state, but of the legislature itself. In Massachusetts, the governor consulted the judges of the Supreme Judicial Court as to the true construction of the Constitution on these very interesting points. The judges of the Supreme Court who were consulted were of the opinion that it belonged to the governors of the several states to determine when any of the exigencies contemplated by the Constitution of the United States existed, so as to require them to place the militia or any part of it in the service of the Union and under the command of the President. It was observed that the Constitution of the United States did not give that right by any express term to the President or Congress, and that the power to determine when the exigency existed was not prohibited to the states, and that it was, therefore, as of course, reserved to the states. A different construction would place all the militia in effect at the will of Congress, and produce a military consolidation of these states. The Act of 28th of February, 1795, vested in the President the power of calling forth the militia when any one of the exigencies existed, and if to that be superadded the power of determining when the casus foederis occurred, the militia would in fact be under the President's control. As to the question how the militia were to be commanded when duly called out, the judges were of opinion that the President alone of all the officers acting under the United States was authorized to command them, that he must command them as they were organized, under officers appointed by the states. The militia could not be placed under the command of any officer not of the militia, except that officer be the President of the United States. But the judges did not determine how the militia were to be commanded in case of the absence of the President and of a union of militia with troops of the United States, and whether they were to act under their separate officers and in concert as allied forces, or whether the officer present, who was highest in rank, be he of the militia or of the federal troops, was to command the whole, was a difficult and perplexing question, which the judges did not undertake to decide. The President of the United States declared that these constructions of the constitutional powers of the general government over the militia were novel and unfortunate, and he was evidently and decidedly of a different opinion. He observed in his message to Congress on the 4th November 1812 that if the authority of the United States to call into service and to command the militia could be thus frustrated, we were not one nation, for the purpose most of all requiring it. These embarrassing questions and the high authority by which each side of the argument was supported remained unsettled by the proper and final decision of the tribunal that is competent to put them to rest, until the case of Martin v. Mott in 1827. In that case, it was decided and settled by the Supreme Court of the United States that it belonged exclusively to the President to judge when the exigency arises in which he had authority under the Constitution to call forth the militia, and that his decision was conclusive upon all other persons. The case of Houston v. Moore settled some important questions arising upon the national authority over the militia. The acts of Congress already referred to in the Act of 8th March, 1792, for establishing a uniform militia were considered as covering the whole ground of congressional legislation over the subject. The manner in which the militia were to be organized, armed, disciplined, and governed was fully prescribed. Provision was made for drafting, detaching, and calling forth the state quotas when requested by the President. His orders were to be given to the chief executive magistrate or to any militia officer he might think proper. Neglect or refusal to obey his orders was declared to be a public offense and subjected the offender to trial and punishment, to be adjudged by a court-martial, and the mode of proceeding was perspicuously detailed. The question before the Supreme Court of the United States was whether it was competent for a court-martial, deriving its jurisdiction under state authority, to try and punish militiamen, drafted, detached, and called forth by the President into the service of the United States, and who had refused or neglected to obey the call. The court decided that the militia, when called into the service of the United States, were not to be considered as being in that service, or in the character of national militia, until they were mustered at the place of rendezvous, and that until then the state retained a right, concurrent with the government of the United States, to punish their delinquency. But after the militia had been called forth and had entered into the service of the United States, their character changed from state to national militia, and the authority of the general government over such detachments was exclusive. Actual service was considered by Congress as the criterion of national militia, and the place of rendezvous was the terminus quo. The service, the pay, the subjection to the Articles of War were to commence, and if the militia, when called into the service of the United States, refused to obey the order, they remain within the military jurisdiction of the state, and it is competent for the state to provide for trying and punishing them by a state court-martial, to the extent and in the manner prescribed by the Act of Congress. The Act of Pennsylvania of 1814 provided for punishing by a state court-martial delinquent militiamen who were called into the service of the United States and neglected or refused to serve, and they were to be punished by the infliction of the penalties prescribed by the Acts of Congress, and such an act was held not to be repugnant to the Constitution and laws of the United States. It was the lawful exercise of concurrent power, and could be concurrently exercised by the national and state courts-martial, as it was authorized by the laws of the state and not prohibited by those of the United States. It would remain to be so exercised until Congress should vest the power exclusively elsewhere, or until the states should divest their courts-martial of such a jurisdiction. This was the decision, in the first instance, of the Supreme Court of Pennsylvania, and it was affirmed on appeal by the majority of the Supreme Court of the United States. Powers of Congress as to internal improvements. 7. The authority of Congress to appropriate public monies for internal improvements has been much discussed on public occasions and between the legislative and executive branches of the government, but the point has never been brought under judicial consideration. It has been contended that, under the power to establish post offices and post roads, and to raise monies to provide for the general welfare, and as incident thereto, Congress had the power to set apart funds for internal improvements in the states, with their assent by means of roads and canals. Such a power has been exercised to a certain extent. It has been the constant practice to allow to the new states a certain proportion of the proceeds arising from the sale of public lands to be laid out in the construction of roads and canals within those states, or leading thereto. In 1806, Congress authorized a road to be opened from Nashville in Tennessee to Natchez, and in 1809 they authorized the canal at Carondelet, leading from Lake Pontchartrain to be extended to the River Mississippi. The Cumberland Road was constructed under the Act of March 29, 1806, and this road had been made under a covenant with the state of Ohio by the Act of April 30, 1802, that a portion of the proceeds of lands lying within that state should be applied to the opening of the roads leading to that state, with the consent of the states through which the road might pass. But the expenditures on that road far exceeded the proceeds of sales of public lands in Ohio, and in 1817, the President of the United States objected to a bill on the ground that the Constitution did not extend to making roads and canals and improving watercourses through the different states, nor could the assent of those states confer the power. Afterwards, in 1822, the President objected to a bill appropriating money for repairing Cumberland Road and establishing gates and tolls on it. On these and other occasions, there has been a great and decided difference of opinion between Congress and the President on the constitutional question. President Jefferson, in his message of December 2, 1806, and President Madison in his message of December 3, 1816, equally denied any such power in Congress. On the other hand, it appears that Congress claimed the power to lay out, construct, and improve post roads, with the assent of the states through which they pass. They also claimed the power to open, construct, and improve military roads on the like terms, and the right to cut canals through the several states with their assent for promoting and securing internal commerce, and for the more safe and economical transportation of military stores in time of war, and leaving in all these cases the jurisdictional right over the soil in the respective states. In the inaugural address of President Adams on the 4th of March, 1825, he alluded to this question, and his opinion seemed to be in favor of the constitutional right and of the policy and wisdom of the liberal application of the national resources to the internal improvement of the country. He intimated that speculative scruples on this subject would probably be solved by the practical blessings resulting from the application of the power, and the extent and limitations of the general government in relation to this important interest, settled and acknowledged to the satisfaction of all. This declaration may be considered as withdrawing the influence of the official authority of the President from the side on which it has hitherto pressed, and adding it to the support of the preponderating opinion in favor of the competency of the power claimed by Congress. End of section 20.
Section 21 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1, by James Kent. Of the President, Part 1. The title of the present lecture may conveniently be examined in the following order. 1. The unity of this department. 2. The qualifications required by the Constitution for the office of President. 3. The mode of his appointment. 4. His duration. 5. His support. 6. His powers. 1. By the Constitution, it is ordained that the executive power shall be invested in a president. Unity of the executive power. The object of this department is the execution of the law, and good policy dictates that it should be organized in the mode best calculated to attain that end with precision and fidelity. Consultation is necessary in the making of laws. The defect or grievance they are intended to remove must be distinctly perceived, and the operation of the remedy upon the interests, the morals, and the opinion of the community profoundly considered. A comprehensive knowledge of the great interests of the nation in all their complicated relations and practical details seems to be required in sound legislation, and it shows the necessity of a free, full, and perfect representation of the people in the body entrusted with the legislative power. But when laws are duly made and promulgated, they only remain to be executed. No discretion is submitted to the executive officer. It is not for him to deliberate and decide upon the wisdom or expediency of the law. What has been once declared to be law, under all the cautious forms of deliberation prescribed by the Constitution, ought to receive prompt obedience. The characteristical qualities required in the executive department are promptitude, decision, and force, and these qualities are most likely to exist when the executive authority is limited to a single person, moving by the unity of a single will. Division, indecision, and delay are exceedingly unfavorable to that steady and vigorous administration of the law, which is necessary to secure tranquility at home and command the confidence of foreign nations. Every government, ancient and modern, which has been constituted on different principles and adopted a compound executive, has suffered the evils of it, and the public interest has been sacrificed, or it has languished under the inconveniences of an imbecile or irregular administration. In those states which have tried the project of executive councils, the weakness of them has been strongly felt and strikingly displayed, and in some instances in which they have been tried, as in Pennsylvania and Georgia, they were soon abandoned and a single executive magistrate created, in accordance with the light afforded by their own experience, as well as by the institutions of their neighbors. Unity increases not only the efficacy, but the responsibility of the executive power. Every act can be immediately traced and brought home to the proper agent. There can be no concealment of the real author, nor, generally, of the motives of public measures when there are no associates to divide or to mask responsibility. There will be much less temptation to depart from duty and much greater solicitude for reputation when there are no partners to share the odium or to communicate confidence by their example. The eyes of the people will be constantly directed to a single conspicuous object, and, for these reasons, Delhomme considered it to be a sound axiom of policy that the executive power was more easily confined when it was one. Quote, "If the execution of laws," he observes, "be entrusted to a number of hands, the true cause of public evils is hidden. Tyranny in such states does not always beat down the fences that are set around it, but it leaps over them. It mocks the efforts of the people, not because it is invincible, but because it is unknown." End quote. The justness of these reflections might be illustrated and confirmed by a review of the proceedings of the formal council of appointment in New York. All efficient responsibility was there lost by reason of the constant change of the members and the difficulty of ascertaining the individual to whom the origin of a bad appointment was to be attributed. Qualifications for President. 2. The Constitution requires that the President should be a natural-born citizen, or a citizen of the United States at the time of the adoption of the Constitution, and that he have attained to the age of 35 years and have been 14 years a resident within the United States. Considering the greatness of the trust, and that this department is the ultimately efficient executive power in government, these restrictions will not appear altogether useless or unimportant. As the President is required to be a native citizen of the United States, ambitious foreigners cannot intrigue for the office, and the qualification of birth cuts off all those inducements from abroad to corruption, negotiation, and war, which have frequently and fatally harassed the elective monarchies of Germany and Poland, as well as the pontificate at Rome. The age of the President is sufficient to have formed his public and private character, and his previous domestic residence is intended to afford to his fellow citizens the opportunity to attain a correct knowledge of his principles and capacity, and to have enabled him to acquire habits of attachment and obedience to the laws and of devotion to the public welfare. Mode of appointment. 3. The mode of his appointment presented one of the most difficult and momentous questions that occupied the deliberations of the Assembly which framed the Constitution, and if ever the tranquility of this nation is to be disturbed, and its liberties endangered by a struggle for power, it will be upon this very subject of the choice of a president. This is the question that is eventually to test the goodness and try the strength of the Constitution, and if we shall be able, for half a century hereafter, to continue to elect the Chief Magistrate of the Union with discretion, moderation, and integrity, we shall undoubtedly stamp the highest value on our national character, and recommend our republican institutions, if not to the imitation, yet certainly to the esteem and admiration of the more enlightened part of mankind. The experience of ancient and modern Europe has been unfavorable to the practicability of a fair and peaceable popular election of the executive head of a great nation. It has been found impossible to guard the election from the mischiefs of foreign intrigue and domestic turbulence, from violence or corruption, and mankind have generally taken refuge from the evils of popular elections in hereditary executives as being the least evil of the two. The most recent and remarkable change of this kind occurred in France in 1804, when the legislative body changed their elective into a hereditary monarchy on the avowed ground that the competition of popular elections led to corruption and violence. And it is a curious fact that in European history, that on the first partition of Poland in 1773, when the partitioning powers thought it expedient to foster and confirm all the defects of its wretched government, they sagaciously demanded of the Polish Diet that the crown should continue elective. This was done for the very purpose of keeping the door open for foreign intrigue and influence. Mr. Paley condemns all elective monarchies, and he thinks nothing is gained by a popular choice worth the dissensions, tumults, and interruptions of regular industry, with which it is inseparably attended. I am not called upon to question the wisdom or policy of preferring hereditary to elective monarchies among the great nations of Europe, where different orders and ranks of society are established, and large masses of property accumulated in the hands of single individuals, and where ignorance and poverty are widely diffused, and standing armies are necessary to preserve the stability of the government. The state of society and of property in this country, and our moral and political habits have enabled us to adopt the republican principle, and to maintain it hitherto with illustrious success. It remains to be seen whether the checks which the Constitution has provided against the dangerous propensities of our system will ultimately prove effectual. The election of a supreme executive magistrate for a whole nation affects so many interests, addresses itself so strongly to popular passions, and holds out such powerful temptations to ambition that it necessarily becomes a strong trial to public virtue and even hazardous to the public tranquility. The Constitution, from an enlightened view of all the difficulties that attend the subject, has not thought it safe or prudent to refer the election of a president directly and immediately to the people, but it has confided the power to a small body of electors, appointed in each state, under the direction of the legislature, and to close the opportunity as much as possible against negotiation, intrigue, and corruption, it has declared that Congress may determine the time of choosing the electors and the day on which they shall vote, and that the day of election shall be the same in every state. This security has been still further extended by the Act of Congress directing the electors to be appointed in each state within 34 days of the day of election. The Constitution directs that the number of electors in each state shall be equal to the whole number of senators and representatives which the state is entitled to send Congress, and, according to the apportionment of Congress in 1832, the president is elected by 281 electors. And to prevent the person in office at the time of the election from having any improper influence on his re-election by his ordinary agency in the government, it is provided that no member of Congress nor any person holding an office of trust or profit under the United States shall be an elector. And the Constitution has in no other respect defined the qualifications of the electors. These electors, having been chosen on the Tuesday next after the first Monday in November, meet in their respective states at a place appointed by the legislature thereof, on the first Wednesday in December, in every fourth year succeeding the last election, and vote by ballot for president and vice president. For this last officer is elected in the same manner and for the same period as the president, and one of whom, at least, shall not be an inhabitant of the same state with the electors. They name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they sign, and certify, and transmit, sealed, to the seat of the government of the United States, directed to the President of the Senate. The Act of Congress of 1st of March, 1792, Section 2, directs that the certificate of the vote shall be delivered to the President of the Senate before the first Wednesday of January next ensuing the election. The President of the Senate, on the second Wednesday in February succeeding every meeting of the electors, in the presence of both houses of Congress, opens all the certificates, and the votes are then to be counted. The Constitution does not expressly declare by whom the votes are to be counted, and the result declared. In the case of questionable votes in a closely contested election, this power may be all-important, and I presume, in the absence of all legislative provision on the subject, that the President of the Senate counts the votes and determines the result, and that the two houses are present only as spectators to witness the fairness and accuracy of the transaction, and to act only if no choice be made by the electors. The House of Representatives, in such case, are to choose immediately, though the Constitution holds their choice to be valid if made before the 4th day of March following, and in the cases of these elections in 1801 and 1824, as no choice was made, the House of Representatives retired and voted, and the Senate were admitted to be present as spectators. The person having the greatest number of votes of the electors for president is president, if such number be a majority of the whole number of electors appointed. But if no person have such majority, then, from the persons having the highest number, not exceeding 3, on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the vote shall be taken by states, the representation from each state having one vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. If the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the Vice President shall act as President, as in the case of the death or constitutional disability of the President. The person having the greatest number of votes as Vice President is Vice President, if such number be a majority of the whole number of electors appointed. And if no person have a majority, then, from the 2 highest numbers on the list, the Senate shall choose the Vice President. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number is necessary to a choice, and no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States. The Constitution does not specifically prescribe when or where the Senate is to choose a Vice President, if no choice be made by the electors, and, I presume, the Senate may elect by themselves at any time before the 4th day of March following. The President and Vice President are equally to be chosen for the same term of 4 years, and it is provided by law that the term shall, in all cases, commence on the 4th day of March next, succeeding the day on which the votes of the electors shall have been given. In case of the removal of the President from office, or of his death, resignation, or inability to discharge the powers and duties of the office, the same devolve on the Vice President, and except in cases in which the President is enabled to reassume the office, the Vice President acts as President during the remainder of the term for which the President was elected. Congress are authorized to provide, by law, for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer should then act as President, and the officer so designated is to act until the disability be removed, or a President shall be elected, and who is in that case to be elected on the first Wednesday of the ensuing December, if time will admit of it, and if not, then on the same day in the ensuing year. In pursuance of this constitutional provision, the Act of Congress of March 1st, 1792, Section 9, declared that in case of a vacancy in the office, both of President and Vice President, the President of the Senate pro tempore, and in case there should be no President of the Senate, then the Speaker of the House of Representatives for the time being should act as President until the vacancy was supplied. The evidence of a refusal to accept or of a resignation of the office of President and Vice President is declared by the same Act of Congress, Section 11, to be a declaration in writing, filed in the office of the Secretary of State. And if the office should, by the course of events, devolve on the Speaker, after the Congress for which the last Speaker was chosen had expired, and before the next meeting of Congress, it might be a question who is to serve, and whether the Speaker of the House of Representatives, then extinct, could be deemed the person intended. The mode of electing the President appears to be well calculated to secure a discreet choice and to avoid all those evils which the partisans of monarchy have described, and the experience of other nations and past ages have too clearly shown to be the consequence of popular elections. Had the choice of President been referred at once and directly to the people at large as one single community, there might have been reason to apprehend, and such no doubt was the sense of the convention, that it would have produced too violent a contest, and have been trying the experiment on too extended a scale for the public virtue, tranquility, and happiness. Had we imitated the practice of most of the Southern states in respect to their state executives, and referred the choice of President to Congress, this would have rendered him too dependent upon the immediate authors of his elevation to comport with the requisite energy of his own department, and it would have laid him under temptation to indulge in improper intrigue or to form a dangerous coalition with the legislative body in order to secure his continuance in office. All elections by the representative body are peculiarly liable to produce combinations for sinister purposes. The Constitution has avoided all these objections by confiding the power of election to a small number of select individuals in each state, chosen only a few days before the election and solely for that purpose. This would seem prima facie to be as wise a provision as the wisdom of man could have devised to avoid all opportunity for foreign or domestic intrigue. These electors assemble in separate and distantly detached bodies, and they are constituted in a manner best calculated to preserve them free from all inducements to disorder, bias, or corruption. There is no other mode of appointing the chief magistrate under all the circumstances peculiar to our political condition, which appears to unite itself in so many unalloyed advantages. It must not be pronounced to be a perfect scheme of election, for it has not been sufficiently tried. The election of 1801 threatened the tranquility of the nation, and the difficulty that occurred in that case in producing a constitutional choice led to the amendment of the Constitution on this very subject. But whether the amendment be for the better or for the worse may well be doubted, and remains yet to be settled by the lights of experience. The Constitution says that each state is to appoint electors in such manner as the legislature may direct, and in some of the states the electors have been chosen by the legislature itself in the mode prescribed by law. But it is to be presumed that there would be less opportunity for dangerous coalitions and combinations for party or ambitious or selfish purposes if the choice of electors was referred to the people at large, and this seems now to be the sense and expression of public opinion and the general practice. His term of office. 4. The President, thus elected, holds his office for the term of 4 years, a period perhaps reasonably long for the purpose of making him feel firm and independent in the discharge of his trust, and to give stability and some degree of maturity to his system of administration. It is certainly short enough to place him under a due sense of dependence on the public approbation. The President is re-eligible for successive terms, but in practice he has never consented to be a candidate for a third election, and this usage has indirectly established, by the force of public opinion, a salutary limitation to his capacity of continuance in office. His salary. 5. The support of the President is secured by a provision in the Constitution which declares that he shall, at stated times, receive for his services a compensation that shall neither be increased nor diminished during the period for which he shall have been elected, and that he shall not receive within that time any other emolument from the United States or any of them. This provision is intended to preserve the due independence and energy of the executive department. It would be in vain to declare that the different departments of government should be kept separate and distinct, while the legislature possessed discretionary control over the salaries of the executive and judicial officers. This would be to disregard the voice of experience and the operation of invariable principles of human conduct. A control over a man's living is, in most cases, a control over his actions. The Constitution of Virginia considered it as a fundamental axiom of government that the three great and primary departments should be kept separate and distinct, so that neither of them exercised the powers properly belonging to the other. But without taking any precautions to preserve this principle in practice, it made the governor dependent on the legislature for his annual existence and his annual support. The result was, as Mr. Jefferson has told us, that during the whole session of the legislature, the direction of the executive was habitual and familiar. The Constitution of Massachusetts discovered more wisdom, and it set the first example in this country of a constitutional provision for the support of the executive magistrate by declaring that the governor should have a salary of a fixed and permanent value, amply sufficient, and established by standing laws. Those state constitutions, which have been made or amended since the establishment of the Constitution of the United States, have generally followed the example which it has happily set them, in this and in many other instances, and we may consider it as one of the most signal blessings bestowed on this country that we have such a wise fabric of government as the Constitution of the United States constantly before our eyes, not only for our national protection and obedience, but for our local imitation and example. End of section 21. Read by Victoria Temple, Anchorage, November 9th, 2024.
Section 22 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jddykst, Farragut, Iowa. Commentaries on American Law, Volume 1, by James Kent. Of the President, Part 2. Powers of the President. Having thus considered the manner in which the President is constituted, it only remains for us to review the powers with which he is invested. He is Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the service of the Union. Footnote. Article 2, Section 2. End of footnote. The command and application of the public forces to execute the law, maintain peace, and resist foreign invasion are powers so obviously of an executive nature and require the exercise of qualities so characteristical of this department that they have always been exclusively appropriated to it in every well-organized government upon earth. In no instance, perhaps, did the enlightened understanding of Hume discover less acquaintance with the practical science of government than when he gave the direction of the Army and Navy, as well as all the other executive powers, to 100 senators in his plan of a perfect commonwealth. Footnote. Hume's Essays, Volume 1, page 526. End of footnote. That of Milton was equally chimerical and absurd, when, in his ready and easy way to establish a free commonwealth, he deposited the whole executive as well as legislative power in a single and permanent council of senators. That of Locke was equally unwise, for in his plan of legislation for Carolina, he gave the whole authority, legislative and executive, to a small oligarchical assembly. Footnote. Mr. Locke's very complicated scheme of government, under the title of Fundamental Constitutions of Carolina, is inserted at large in Locke's Works, Volume 3, page 665 through 678. Those legislative labors of that great and excellent man perished unheeded and unregretted by all parties, after an experience of 23 years had proved them to be, in the words of Mr. Graham, the historian, utterly worthless and impracticable. End of footnote. Such specimens as these well justify the observation of President Adams. Footnote. Defense of the American Constitutions, Volume 1, Letter 54. End of footnote. That a philosopher may be perfect master of Descartes and Leibniz, may pursue his own inquiries into metaphysics to any length he please, may enter into the inmost recesses of the human mind, and make the noblest discoveries for the benefit of his species. Nay, he may defend the principles of liberty and the rights of mankind with great abilities and success, and after all, when called upon to produce a plan of legislation, he may astonish the world with a signal absurdity. The President also has the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. The Marquis Beccaria has contended that the power of pardon does not exist under a perfect administration of law, and that the admission of the power is a tacit acknowledgment of the infirmity of the course of justice. And where is the administration of justice, it may be asked, that is free from infirmity? Were it possible in every instance to maintain a just proportion between the crime and the penalty, and were the rules of testimony and the mode of trial so perfect as to preclude every possibility of mistake or injustice, there would be some color for the admission of this plausible theory. But even in that case, policy would sometimes require a remission of a punishment strictly due for a crime certainly ascertained. The very notion of mercy implies the accuracy of the claims of justice. An inexorable government, says Mr. York, in his Considerations on the Law of Forfeiture, footnote, page 101, end of footnote, will not only carry justice in some instances to the height of injury, but with respect to itself it will be dangerously just. The clemency of Massachusetts in 1786, after an unprovoked and wanton rebellion, in not inflicting a single capital punishment, contributed, by the judicious manner in which its clemency was applied, to the more firm establishment of their government. And this power of pardon will appear to be more essential when we consider that under the most correct administration of the law, men will sometimes fall a prey to the vindictiveness of accusers, the inaccuracy of testimony, and the fallibility of jurors. Notwithstanding this power is clearly supported on principles of policy, if not of justice, English lawyers of the first class and highest reputation, footnote, York on Forfeiture, 100, Black's Commentaries, Volume 4, page 390, end of footnote, has strangely concluded that it cannot exist in a republic because nothing higher is acknowledged than the magistrate. Instead of falling into such an erroneous conclusion, it might fairly be insisted that the power may exist with greater safety in free states than in any other forms of government, because abuses of the discretion unavoidably confided to the magistrate in granting pardons are much better guarded against by the sense of responsibility under which he acts. The power of pardon vested in the President is without any limitation, except in the single case of impeachments. He is checked in that case from screening public officers with whom he might possibly have formed a dangerous or corrupt coalition, or who might be his particular favorites and dependents. Treaty power. The President has also the power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. Footnote, Article 2, Section 2, end of footnote. Writers on government have differed in opinion as to the nature of this power, and whether it be properly, in the natural distribution of power, of legislative or executive cognizance. As treaties are declared by the Constitution to be the supreme law of the land, and as, by means of them, new relations are formed, and obligations contracted, it might seem to be more consonant to the principles of republican government to consider the right of concluding specific terms of peace as of legislative jurisdiction. This has generally been the case in free governments. The determinations respecting peace, as well as war, were made in the public assemblies of the nation at Athens and Rome, and in all the Gothic governments of Europe, when they first arose out of the rude institutions of the ancient Germans. On the other hand, the preliminary negotiations which may be required, the secrecy and dispatch, proper to take advantage of the sudden and favorable turn of public affairs, seem to render it expedient to place this power in the hands of the executive department. The Constitution of the United States has been influenced by the latter more than by the former considerations, for it has placed this power with the President, under the advice and control of the Senate, who are to be considered, for this purpose, in the light of an executive council. The President is the constitutional organ of communication with foreign powers, and the efficient agent in the conclusion of treaties. But the consent of 2/3 of the senators present is essential to give validity to his negotiations. To have required the acquiescence of a more numerous body would have been productive of delay, disorder, imbecility, and probably, in the end, a direct breach of the Constitution. The history of Holland shows the danger and folly of placing too much limitation on the exercise of the treaty-making power. By the fundamental charter of the United Provinces, peace could not be made without the unanimous consent of the provinces, and yet, without multiplying instances, it is sufficient to observe that the immensely important and fundamental Treaty of Munster in 1648 was made when Zeeland was opposed to it, and the Peace of 1661 when Utrecht was opposed. So feeble are mere limitations upon paper, mere parchment barriers when standing in opposition to the strong force of public exigency. The Senate of the United States is a body of men most wisely selected for the deposit of this power. They are easily assembled, are governed by steady, systematic views, feel a due sense of national character, and can act with promptitude and firmness. The question whether a treaty constitutionally made was obligatory upon Congress equally as any other national engagement would be, if fairly made by the competent authority, or whether Congress had any discretionary power to carry into effect a treaty requiring the appropriation of money or other act to be done on their part, or to refuse it their sanction, was greatly discussed in Congress in the year 1796 and again in 1816. The House of Representatives at the former period declared by resolution that when a treaty depended for the execution of any of its stipulations on an act of Congress, it was the right and duty of the House to deliberate on the expediency or inexpediency of carrying such treaty into effect. It cannot be mentioned at this day without equal regret and astonishment that such a resolution passed the House of Representatives on the 7th of April, 1796. But it was a naked, abstract claim of right, never acted upon, and Congress shortly afterwards passed a law to carry into effect the very treaty with Great Britain which gave rise to that resolution. President Washington, in his message to the House of Representatives on the 30th of March, 1796, explicitly denied the existence of any such power in Congress, and he insisted that every treaty duly made by the President and Senate and promulgated thenceforward became the law of the land. If a treaty be the law of the land, it is as much obligatory upon Congress as upon any other branch of the government or upon the people at large, so long as it continues in force and unrepealed. The House of Representatives are not above the law, and they have no dispensing power. They have a right to make and repeal laws, provided the Senate and President concur. But without such concurrence, a law in the shape of a treaty is as binding upon them as if it were in the shape of an act of Congress, or of an article of the Constitution, or of a contract made by authority of law. The argument in favor of the binding and conclusive efficacy of every treaty made by the President and Senate is so clear and palpable that it has probably carried very general conviction throughout the community, and this may be now considered as the decided sense of public opinion. This was the sense of the House of Representatives in 1816, and the resolution of 1796 would not now be repeated. Footnote: notwithstanding the force of the author's reasoning and the weight of his authority, his views above expressed may ultimately meet with rejection. History has taught, and the Constitution seems to have followed, the lesson of vesting in the immediate representatives of those whose contributions fill the national purse the power to prevent others from opening it for public expenditure. The postulate that a treaty is the supreme law of the land is an assumption of the conclusion in dispute. Deeding legislation, is it, on its municipal side, a treaty? Is it a law to Congress? These are the questions to be primarily discussed. Says McLean, J., in Turner v. American Baptist Missionary Union, 5 McLean, 344-347, 1852. A treaty under the federal Constitution is declared to be the supreme law of the land. This unquestionably applies to all treaties, where the treaty-making power, without the aid of Congress, can carry it into effect. It is not, however, and cannot be the supreme law of the land, where the concurrence of Congress is necessary to give it effect. Until this power is exercised, as where the appropriation of money is required, the treaty is not perfect. It is not operative in the sense of the Constitution, as money cannot be appropriated by the treaty-making power. This results from the limitations of our government. The action of no department of the government can be regarded as a law until it shall have all the sanctions required by the Constitution to make it such. As well might it be contended that an ordinary act of Congress, without the signatures of the President, was a law, as that a treaty which engages to pay a sum of money is in itself a law. Aside from the question of formal completeness, in what way does a treaty operate as the supreme law of the land? Besides the Constitution itself, the laws made pursuant thereto, as well as the treaties made under the authority thereof, are declared to be the supreme law of the land, meaning the law supreme over that made by the states. The declaration has no relevancy to the comparative dignity of treaties and congressional enactments. It in no way indicates that one part of the supreme law is superior to another. They are to be coordinated by restricting each to its proper sphere. As, on the one hand, treaty cannot supply the place of the Constitution, so, on the other hand, it cannot regulate the functions expressly conferred upon the legislative department. Treaty cannot raise a law that Congress shall pass an ancillary law, any more than an act of Congress can impose upon the President and Senate an obligation to enter into a specified treaty. The expression which is cited to show the superiority of treaties, being used with regard to acts of Congress as well, might in turn be cited to show the superiority of these. Indeed, it sometimes happens that Congress makes enactments which work a violation of treaty engagements with foreign powers. In Bartram v. Robertson, 15 Federal, Representative 212-214, 1883, which presents an instance of this kind, Wallace, J., citing Taylor v. Morton, 2 Curt, G.C. 451, 1855, Gray v. Clinton Bridge, Woolwa, 150, 1867, Cherokee Tobacco, 11 Wall, 616, 1870, Ropes v. Clinch, 8 Blatchford, 304, 1871, says, both treaties and acts of Congress are, under the Constitution, the supreme law of the land, and each, they, are of equal authority within the sphere of the constitutional power of the respective departments of the government by which they are adopted. Therefore, the treaty or the act of Congress is paramount, according as it is the latest expression of the will of the lawmaking power. The same view is thus lucidly expounded by Judge Hare in his recent work on American constitutional law. An act regulating commerce is not necessarily invalid because it is at variance with a commercial or other treaty, because treaties, so far as they affect private rights or have a domestic operation, are essentially legislative, and may, like other laws, be abrogated by a statute which lays down a different rule, or, to state the proposition somewhat differently, what the President and Senate do under the treaty-making power, the President, Senate, and House of Representatives may undo by virtue of the lawmaking power, both powers springing from the same source, the people of the United States, and each standing at the same level, so that neither can claim precedence, and whichever speaks last will prevail. Page 439, Taylor v. Morton, 2 Curtis 454, 459, 1855. Head money cases, 112 U.S. 580, 597, 1884. Chu Hong v. U.S. 536, 562, 1884. Again, on page 502, 503, the same author says, "The power of Congress to regulate commerce and the power of the President and Senate over the same subject matter through the treaties made with foreign nations may obviously clash, and it seems to be well settled that, when such a result ensues, the act of Congress will, if subsequent, prevail. A treaty is a law, but it has, so far as the courts are concerned, no higher claim, and may, as concluded by two branches of the government, have less weight than a statute to which all have given their consent. It consequently falls within the rule that, as between two opposite enactments, that which is the latest declaration of the national will shall prevail. Whether the compact is or is not broken by such a course is a political question beyond the scope of the judiciary, and must be left to other departments of the government for settlement by negotiation or through a recourse to arms. It seems fair to infer that if Congress can violate a treaty by positive enactment, it can do so by refusing to take any action whatever. The consideration that thereby the public faith may be broken is met by the practical observation just cited, that the injured parties have a means of redress beyond the cognizance of municipal law. It is also met by the theoretical principle that every foreign government may be presumed to know that so far the treaty stipulates to pay money, the legislative sanction is required. Turner v. American Baptist Missionary Union, Supra 348, and therefore has secured no binding contract for the payment of money by our government until it has obtained such sanction. As a matter of politics, the question has been much discussed. In 1796, Mr. Gallatin, addressing the House of Representatives on the subject of Jay's Treaty, argued that if the treaty-making power is not limited by existing laws, or if it repeals laws that clash with it, or if the legislature is obliged to repeal the law so clashing, then the legislative power, in fact, resides in the President and Senate, and they can, by employing an Indian tribe, pass any law under the color of treaty. Discussing the same question in a letter to Monroe, Jefferson wrote as follows: "On the precedent now to be set will depend the future construction of our Constitution, and whether the powers of legislation shall be transferred from the President, Senate, and House of Representatives to the President, Senate, and Piamingo, or any other Indian, Algerine, or other chief." To the same point, a German author has devoted the following masterly exposition: "Congress has, under the Constitution, the right to lay taxes and imposts, as well as to regulate foreign trade. But the President and Senate, if the treaty-making power be regarded as absolute, would be able to evade this limitation by adopting treaties which would compel Congress to destroy its whole tariff system. According to the Constitution, Congress has the right to determine questions of naturalization, of patents, and of copyright. Yet, according to the view here contested, the President and Senate, by a treaty, could on these important questions utterly destroy the legislative capacity of the House of Representatives. The Constitution gives Congress the control of the Army. Participation in this control would be snatched from the House of Representatives by a treaty with a foreign power by which the United States would bind itself to keep in the field an army of a particular size. The Constitution gives Congress the right of declaring war. This right would be illusory if the President and Senate could, by a treaty, launch the country into a foreign war. The power of borrowing money on the credit of the United States resides in Congress. This power would cease to exist if the President and Senate could, by treaty, bind the country to the borrowing of foreign funds. By the Constitution, no money shall be drawn from the Treasury, but in consequence of appropriations made by law. But this limitation would cease to exist if, by a treaty, the United States could be bound to pay money to a foreign power. Congress would cease to be the lawmaking power as is prescribed by the Constitution. The lawmaking power would be the President and the Senate. Such a condition would become the more dangerous from the fact that treaties so adopted, being on this particular hypothesis superior to legislation, would continue in force until superseded by other treaties. Not only, therefore, would a Congress consisting of two houses be made to give way to an oligarchy of President and Senate, but the decrees of this oligarchy, when once made, could only be changed by concurrence of President and of senatorial majority of 2/3. When, in 1867, the appropriation needed to carry out our treaty with Russia for the cession of Alaska came into discussion, the House took the position that the subjects embraced in the stipulations of the treaty were among the subjects by which the Constitution of the United States are submitted to the power of Congress, and over which Congress has jurisdiction, and that it was for such reason necessary that the consent of Congress should be given to the treaty before it should have full force and effect. The Senate, of course, took an opposite view. But as there was no real disagreement between the two houses as to the propriety of the appropriation, they finally united upon a bill wherein a settlement of the dispute was avoided by the non-committal declaration that said stipulations cannot be carried into full force and effect except by legislation to which the consent of both houses of Congress is necessary. Thus the question stands, awaiting decision. Yet two positions may be regarded as accepted in the practical working of our government. One is that, without a congressional vote, there can be no appropriation of money which a treaty requires to be paid. The other is that it should require a very strong case to justify Congress in refusing to pass an appropriation which is called for by a treaty duly ratified. Wharton, Digg, International Law, Volume 2, 131, page 23. See Act of January 16, 1883, Circa 2722, Statute at L. 403, to regulate and improve the civil service of the United States. It provides, inter alia, for the appointment of a civil service commission, the open and competitive examinations of applicants for public service, the filling of offices by selection based on such examination and proportioned to the population of the several states and territories. End of footnote. President's power of nomination to office. The President is the efficient power in the appointment of the officers of government. He is to nominate and, with the advice and consent of the Senate, to appoint ambassadors or public ministers and consuls, the judges of the Supreme Court, and all other officers whose appointments are not otherwise provided for in the Constitution. But Congress may vest the appointment of inferior officers in the President alone, in the courts of law, or in the heads of departments. The appointment of the subordinate officers of government concerned in the administration of the law belongs with great propriety to the President, who is bound to see that the laws are faithfully executed, and who is generally charged with the powers and responsibility of the executive department. The association of the Senate with the President in the exercise of this power is an exception to the general delegation of executive authority, and if he were not expressly invested with the exclusive right of nomination in the instances before us, the organization of this department would be very unskillful, and the government degenerate into a system of cabal, favoritism, and intrigue. But the power of nomination is, for all the useful purposes of restraint, equivalent to the power of appointment. It imposes upon the President the same lively sense of responsibility and the same indispensable necessity of meeting the public approbation or censure. This indeed forms the ultimate security that men in public stations will dismiss interested considerations and act with a steady, zealous, and undivided regard for the public welfare. The advice and consent of the Senate, which are requisite to render the nomination effectual, cannot be attended, in the nature of the case, with very mischievous effects. Having no agency in the nomination, nothing but simply consent or refusal, the spirit of personal intrigue and personal attachment must be pretty much extinguished from a want of means to gratify it. On the other hand, the advice of so respectable a body of men will add still further inducements to a coolly reflected conduct in the President, and will be at all times a check on his own misinformation or error. Footnote: It was settled in the case of Marbury v. Madison, 1 Cranch 137, that when a person has been nominated to the Senate for office by the President, and the President has received the advice and consent of the Senate to the appointment, and has signed the commission, the appointment is final and complete, and the person appointed is entitled to the possession of the commission and to hold the office until constitutionally removed. The principle settled in that case was that the official acts of the heads of the executive department as organs of the President, which are of a political nature and rest under the Constitution and laws in executive discretion, are not within judicial cognizance. But when duties are imposed upon such heads affecting the rights of individuals, and which the President cannot lawfully forbid, as for instance to record a patent or furnish the copy of a record, the person in that case is the officer of the law, and amenable thereto in the ordinary course of justice. Ibid 170, 171. End of footnote. The remaining duties of the President consist in giving information to the Congress of the state of the Union, and in recommending to their consideration such measures as he shall judge necessary or expedient. He is to convene both houses of Congress, or either of them, on extraordinary occasions, and he may adjourn them in case of disagreement. He is to fill up all vacancies that happen during the recess of the Senate by granting commissions, which shall expire at the end of their next session. He is to receive ambassadors and other public ministers, to commission all the officers of the United States, and to take care that the laws be faithfully executed. Footnote: Article 2, Section 2, 3. It was considered in the message of President Jackson to Congress of the 21st December, 1836, in relation to Texas, to be an unsettled question to whom, under the government of the United States, strictly belonged the power of originally recognizing a new state. It was either necessarily involved in some of the great powers given to Congress, or in that given to the President and Senate to form treaties with foreign powers, and to appoint ambassadors and other public ministers, or in that conferred upon the President to receive ministers from foreign nations. It was admitted to be most expedient that the recognition of the independence of a newly assumed state should be left to the decision of Congress, and especially when the exercise of the power would probably lead to war. End of footnote. The propriety and simplicity of these duties speak for themselves. The power of receiving foreign ministers includes in it the power to dismiss them, since he alone is the organ of communication with them, the representative of the people in all diplomatic negotiations, and accountable to the community, not only for the execution of the law, but for the competent qualifications and conduct of foreign agents. May be impeached. In addition to all the precautions which have been mentioned to prevent abuse of the executive trust in the mode of the President's appointment, his term of office, and the precise and definite limitations imposed upon the exercise of his power. The Constitution has also rendered him directly amenable by law for maladministration. The inviolability of any officer of government is incompatible with the Republican theory, as well as with the principles of retributive justice. The President, Vice President, and all civil officers of the United States may be impeached by the House of Representatives for treason, bribery, and other high crimes and misdemeanors, and upon conviction by the Senate, removed from office. Footnote. Article 2, Section 4. End of footnote. If, then, neither the sense of duty, the force of public opinion, nor the transitory nature of the seat are sufficient to secure a faithful discharge of the executive trust, but the President will use the authority of his station to violate the Constitution or law of the land, the House of Representatives can arrest him in his career by resorting to the power of impeachment. I have now finished a general survey of the office of President of the United States, and considering the nature and extent of the powers necessarily incident to that station, it was difficult to constitute the office in such a manner as to render it equally safe and useful by combining in the structure of its powers a due proportion of energy and responsibility. The first is necessary to maintain a firm administration of the law. The second is equally requisite to preserve inviolate the liberties of the people. The authors of the Constitution appear to have surveyed the two objects with profound discernment, and to have organized the executive department with consummate skill. End of section 22.
Section 23 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by disillusionedjimson. Commentaries on American Law, Volume 1, by James Kent, of the Judiciary Department. Lecture 14, of the Judiciary Department. As the judiciary power is entrusted with the administration of justice, it interferes more visibly and uniformly than any other part of government, with all the interesting concerns of social life. Personal security and private property rest entirely upon the wisdom, the stability, and the integrity of the courts of justice. In the survey which is to be taken of the judiciary establishment of the United States, we will in the present lecture consider 1. The judges in relation to their appointment, the tenure of their office, and their support and responsibility. 2. The structure, powers, and officers of the several courts. 1. The Constitution declares that, quote, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish, end quote. In this respect, it is mandatory upon the legislature to establish courts of justice commensurate with the judicial power of the Union. Congress have no discretion in the case. They were bound to vest the whole judicial power, in an original or appellate form, in the courts mentioned and contemplated in the Constitution, and to provide courts inferior to the Supreme Court, in which the judicial power, unabsorbed by the Supreme Court, might be placed. The judicial power of the United States is, in point of origin and title, equal with the other powers of the government, and is as exclusively vested in the courts created by, or in pursuance of, the Constitution, as the legislative power is vested in Congress, or the executive power in the President. The President is to nominate, and by and with the advice and consent of the Senate, to appoint, quote, judges of the Supreme Court, and all other officers whose appointments are not therein otherwise provided for, and which shall be established by law. But Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments." End quote. It has never been judicially settled, but it has been very authoritatively and very wisely settled by the uniform practice of the government, that the judges of the circuit and district courts are not inferior officers, whose appointments might be withdrawn by law from the President and Senate, and placed in other hands. Judicial independence. The advantages of the mode of appointment of public officers by the President and Senate have been already considered. This mode is peculiarly fit and proper in respect to the Judiciary Department. The just and vigorous investigation and punishment of every species of fraud and violence, and the exercise of the power of compelling every man to the punctual performance of his contracts, are grave duties, not of the most popular character, though the faithful discharge of them will certainly command the calm approbation of the judicious observer. The fittest men would probably have too much reservedness of manners and severity of morals to secure an election resting on universal suffrage. Nor can the mode of appointment by a large deliberative assembly be entitled to unqualified approbation. There are too many occasions and too much temptation for intrigue, party prejudice, and local interests to permit such a body of men to act, in respect to such appointments, with a sufficiently single and steady regard for the general welfare. In ancient Rome, the praetor was chosen annually by the people, but it was in the comitia by centuries, and the choice was confined to persons belonging to the patrician order, until the close of the 4th century of the city, when the office was rendered accessible to the plebeians. And when they became licentious, says Montesquieu, the office became corrupt. The popular elections did very well, as he observes, so long as the people were free, and magnanimous, and virtuous, and the public was without corruption. But all plans of government which suppose the people will always act with wisdom and integrity are plainly utopian, and contrary to uniform experience. Government must be framed for man as he is, and not for man as he would be if he were free from vice. Without referring to those cases in our own country, where judges have been annually elected by a popular assembly, we may take the less invidious case of Sweden. During the diets which preceded the revolution in 1772, the states of the kingdom sometimes appointed commissioners to act as judges. The strongest party, says Cottieu, prevailed in the trials that came before them, and persons condemned by one tribunal were acquitted by another. By the Constitution of the United States, quote, "The judges both of the Supreme and inferior courts are to hold their offices during good behavior, and they are, at stated times, to receive for their services a compensation which shall not be diminished during their continuance in office." End quote. The tenure of the office, by rendering the judges independent, both of the government and the people, is admirably fitted to produce the free exercise of judgment in the discharge of their trust. This principle, which has been the subject of so much deserved eulogy, was derived from the English Constitution. The English judges anciently held their seats at the pleasure of the king, and so does the Lord Chancellor to this day. It is easy to perceive what a dangerous influence this must have given to the king in the administration of justice, in cases where the claims or pretensions of the crown were brought to bear upon the rights of a private individual. But, in the case of Lord Coke, the barons of the Exchequer were created during good behavior, and so ran the commissions of the common law judges at the restoration of Charles II. It was still, however, at the pleasure of the Crown to prescribe the form of commission, until the Act of Settlement of 12 and 13 William III, Chapter 2, which was in the nature of a fundamental charter, imposing further limitations upon the Crown, and adding fresh securities to the Protestant succession, and the rights and liberties of the subject. It established that the commissions of the judges be made quam dius et bene gesserint, though they were still to be removable upon the address of both houses of Parliament. The excellence of this provision has recommended the adoption of it by other nations of Europe. It was incorporated into one of the modern reforms of the Constitution of Sweden, and it was an article in the French Constitution of 1791 and in the French Constitution of 1795, and it was inserted in the Constitutional Charter of Louis XVIII. The same stable tenure of the judges is contained in a provision in the Dutch Constitution of 1814, and it is a principle which likewise prevails in most of our state constitutions, and in some of them under modifications more or less extensive and injurious. In monarchical governments, the independence of the judiciary is essential to guard the rights of the subject from the injustice of the crown. But in republics it is equally salutary, in protecting the constitution and laws from the encroachments and the tyranny of faction. Laws, however wholesome or necessary, are frequently the object of temporary aversion, and sometimes of popular resistance. It is requisite that the courts of justice should be able, at all times, to present a determined countenance against all licentious acts, and to deal impartially and truly according to law, between suitors of every description, or whether the cause, the question, or the party be popular or unpopular. To give them the courage and the firmness to do it, the judges ought to be confident of the security of their salaries and station. Nor is an independent judiciary less useful as a check upon the legislative power, which is sometimes disposed, from the force of passion or the temptations of interest, to make a sacrifice of constitutional rights. And it is a wise and necessary principle of our government, as will be shown hereafter in the course of these lectures, that legislative acts are subject to the severe scrutiny and impartial interpretation of the courts of justice, who are bound to regard the Constitution as the paramount law, and the highest evidence of the will of the people. The provision for the permanent support of the judges is well calculated, in addition to the tenure of their office, to give them the requisite independence. It tends also to secure a succession of learned men on the bench, who, in consequence of a certain undiminished support, are enabled and induced to quit the lucrative pursuits of private business for the duties of that important station. The Constitution of the United States on this subject was an improvement upon all our previously existing constitutions. By the English Act of Settlement of 12 and 13 William III, it was declared that the salaries of the judges should be ascertained and established. But by the statute of 1 George III, the salaries of the judges were absolutely secured to them during the continuance of their commissions. The Constitution of Massachusetts followed the declaration in the English statute of William, and provided that permanent and honorable salaries should be established by law for the judges. But this was not sufficiently precise and definite, and the more certain provision in the Constitution of the United States has been wisely followed in the subsequent constitutions of most of the individual states. The Constitution of New York, as amended in 1821, is an exception to this remark, and it left the Judiciary Department in a more dependent condition and under greater disabilities than it found it, and greater than in any of those states in the Union, or in any of those governments in Europe, whose constitutions had been recently reformed. But though the Constitution of the United States has rendered the courts of justice independent of undue influence from the other departments, it has made them amenable for any corrupt violation of their trust. The House of Representatives, as we have already seen, is invested with the power of impeachment, and the judges may, by that process, be held to answer before the Senate, and if convicted, they may be removed from office. Extent of the judicial power. 2. The federal judiciary being thus established on the principles which are essential to maintain that department in a proper state of independence, and to secure the pure and vigorous administration of the law, the Constitution proceeded to designate, with comprehensive precision, the objects of its jurisdiction. The judicial power extends to all cases in law and equity arising under the Constitution, the laws and treaties of the Union, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, to controversies being a state, one plaintiff, and citizens of another state, or foreign citizens or subjects, to controversies between citizens of different states and between citizens of the same state, claiming lands under grants of different states, and between a state, or citizens thereof, and foreign states, and between citizens and foreigners. The propriety and fitness of these judicial powers seem to result, as a necessary consequence, from the union of these states in one national government, and they may be considered as requisite to its existence. The judicial power in every government must be coextensive with the power of legislation. It follows, as a consequence, that the judicial department of the United States is, in the last resort, the final expositor of the Constitution, as to all questions of a judicial nature. Were there no power to interpret, pronounce, and execute the law, the government would either perish through its own imbecility, as was the case with the Articles of Confederation, or other powers must be assumed by the legislative body, to the destruction of liberty. That the interpretation of treaties and the cases of foreign ministers in maritime matters are properly confided to the federal courts appears from the close connection those cases have with the peace of the Union, the confusion that different proceedings in the separate states would tend to produce, and the responsibility which the United States are under to foreign nations for the conduct of all its members. The other cases of enumerated jurisdiction are evidently of a national concern, and they constitute one of the principal motives to union, and one of the principal cases of its necessity, which was the insurance of the domestic tranquillity. The want of a federal judiciary to embrace these important subjects was once severely felt in the German Confederacy, and disorder, license, and desolation reigned in that unhappy country, until the establishment of the imperial chamber by the Emperor Maximilian, near the close of the 15th century. And that jurisdiction was afterwards the greatest source of order and tranquillity in the Germanic body. The judicial power, as it originally stood, extended to suits prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. But the states were not willing to submit to be arraigned as defendants before the federal courts, at the instance of private persons, be the cause of action what it may. The decision of the Supreme Court of the United States in the case of Chisholm v. the State of Georgia decided that in 1793, and in which it was adjudged that a state was suable by citizens of another state, gave much dissatisfaction, and the legislature of Georgia carried their opposition to an open defiance of the judicial authority. The inexpediency of the power appeared so great that Congress, in 1794, proposed to the states an amendment to that part of the Constitution, and it was subsequently amended in this particular under the provision in the 5th article. It was declared by the amendment that the judicial power of the United States should not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. The inhibition applies only to citizens or subjects, and does not extend to suits by a state, or by foreign states or powers. They retain the capacity to sue a state as it was originally granted by the Constitution, and the Supreme Court has original jurisdiction in the case of suits by a foreign state against one of the members of the Union. With these general remarks on the constitutional principles of the Judiciary Department and the objects of its authority, we proceed to a particular examination of the several courts of the United States as ordained by law. Supreme Court. 1. The Supreme Court was instituted by the Constitution, which ordained that, quote, the judicial power of the United States should be vested in one Supreme Court, and in such inferior courts as Congress might, from time to time, ordain and establish, end quote. But it received its present organization from Congress, for the Constitution had only declared, in general terms, that there should be a Supreme Court, with certain original and appellate powers. It consists of a Chief Justice and 8 Associate Justices, any 5 of whom make a quorum, and it holds one term annually at the seat of government, commencing on the second Monday in January. But though 5, 6 of the judges are requisite for business in general, yet any one or more of them may make all necessary orders in a suit, preparatory to the hearing or trial, and continue the court from day to day in the absence of a quorum. And the judge of the 4th Circuit attends at the city of Washington on the first Monday of August annually for interlocutory matters. Having defined the judicial power to be exercised by the courts of the United States, and having created the court which is to be supreme among them, the Constitution proceeds to confer upon this Supreme Court, making a careful separation, distinct, original, and appellate jurisdiction. Quote, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. End quote. By way of supplying a provision omitted in the Constitution, Congress, we must firstly observe, dividing the Supreme Court's original jurisdiction into exclusive and not exclusive, defines each branch with reference to parties litigant. Quote, the Supreme Court shall have exclusive jurisdiction of all controversies of a civil nature where a state is a party, except between a state and its citizens, or between a state and citizens of other states, or aliens, in which latter cases it shall have original, but not exclusive, jurisdiction. End quote. Adapting these words to the changes introduced by the above-mentioned amendment, giving to each state immunity from arraignment at the suit of citizens of other states or of citizens or subjects of foreign states, they would read as in the sentence next to follow. The Supreme Court has exclusive jurisdiction of all controversies of a civil nature, where a state is a party, except in suits against the state by one or more of its citizens, or by a state against one or more of its citizens, and except, also, in suits against the state by citizens of other states or aliens, or by a state against citizens of other states or aliens, in which cases of suits against citizens of other states or aliens it has original, but not exclusive jurisdiction. It has also, by a similar legislative subdivision of its original jurisdiction of cases to which a state is not a party, exclusively, all such jurisdictions of suits, or proceedings against ambassadors, or other public ministers, or their domestics, or domestic servants, as a court of law can have or exercise consistently with the law of nations, and original but not exclusive jurisdiction of all suits brought by ambassadors, or other public ministers, or in which a consul or vice-consul shall be a party. The Supreme Court was, as said above, also clothed by the Constitution, quote, with appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress should make, end quote. And, by the Judiciary Act of 1789, appeals lie to this court from the circuit courts and the courts of the several states. Final judgments and decrees. In civil actions and suits in equity with the circuit courts of the United States, whether brought there by original process or removed there from the state courts, or by appeal from the district courts, in cases where the matter in dispute exceeds $2,000, exclusive of costs, may be re-examined, by writ of error, and reversed or affirmed, in the Supreme Court. Final judgments and decrees in the circuit courts, in cases of admiralty and maritime jurisdiction, and of prize or no prize, where the matter in dispute exceeds $2,000, exclusive of costs, may be reviewed on appeal in the Supreme Court. And in admiralty and prize cases, new evidence is admitted to be receivable on appeal in the Supreme Court. This admission is conformable to the doctrine and usage of appellate courts of admiralty, permitting the parties, upon the appeal, to introduce new allegations and new proofs, and to add new counts to the libel, So, also, a final judgment or decree in any suit from the highest court of law or equity of a state may be brought up on error in point of law to the Supreme Court of the United States, provided the validity of a treaty or statute of, or authority exercised under the United States was drawn in question in the state court, and the decision was against that validity, or provided the validity of any state authority was drawn in question, on the ground of its being repugnant to the Constitution, treaties, or laws of the United States, and the decision was in favor of its validity, or provided the construction of any clause of the Constitution, or of a treaty, or statute of, or commission held under the United States, was drawn in question, and the decision was against the title, right, privilege, or exemption specially claimed under the authority of the Union. Upon error of a decision in a state court, no other error can be assigned or regarded than such as appears upon the face of the record, and immediately respects the questions of validity or construction of the Constitution, treaties, statutes, commissions, or authorities in dispute. The Supreme Court is also armed with that superintending authority over the inferior courts, which ought to be deposited in the highest tribunal and dernier resort of the people of the United States. It has power to issue writs of prohibition to the district courts, when proceeding as courts of admiralty and maritime jurisdiction, and to issue writs of mandamus, in cases warranted by the principles and usages of law, to any courts appointed, or persons holding office under the authority of the United States, where a state, or an ambassador, or other public minister, or a consul or vice-consul is a party. This court and each of its judges have the power to grant writs of noexant and injunction, but the former writ cannot be granted unless a suit in equity be commenced, and satisfactory proof be made that the party designs quickly to leave the United States, and no injunction can be granted to stay proceedings in a state court, nor in any case, without reasonable notice to the adverse party. All the courts of the United States have power to issue writs of scire facias, habeas corpus, and all other writs not specially provided by statute, which may be necessary for the exercise of their respective jurisdictions, and agreeable to the principles and usages of law. So the judges of the Supreme Court, as well as the judges of the district courts, may, by habeas corpus, relieve the citizens from all manner of unjust imprisonment occurring under or by color of the authority of the United States. End of section 23. Section 24 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by disillusionedjimson. Commentaries on American Law, Volume 1, by James Kent. Of the Judiciary Department, Part 2. Circuit Courts. 2. The limits and jurisdiction of the circuit courts of the United States have been subject to frequent changes, and their number has been steadily increasing with the increase of states and districts, ever since the first organizations of the national courts under the Acts of Congress of the 24th of September, 1789. They are established in each district, with a few exceptions, of the 9 great circuits into which the United States are now divided. The First Circuit is composed of the districts of Maine, New Hampshire, Massachusetts, and Rhode Island. The Second Circuit, of the districts of Connecticut, Vermont, and New York. The Third Circuit, of the District of New Jersey, and the Eastern and Western Districts of Pennsylvania. The Fourth Circuit, of the Districts of Maryland and Delaware. The Fifth Circuit, of the Districts of Eastern Virginia and North Carolina. The Sixth Circuit, of the Districts of South Carolina and Georgia. The Seventh Circuit, of the Districts of Ohio, Indiana, Illinois, and Michigan. The Eighth Circuit, of the Districts of Kentucky, East and West Tennessee, and Missouri. And the Ninth Circuit, of the Districts of Southern Alabama, Eastern Louisiana, Mississippi, and Arkansas. In each district of these circuits, with the exception of Indiana, Illinois, and Michigan, where the circuit judge holds only one circuit. 2 circuit courts are annually held by one of the judges of the Supreme Court and the district judge of the district. But the Supreme Court may, in cases where special circumstances shall in their judgment render the same necessary, assign 2 of the judges of the Supreme Court to attend a circuit court. And when the district judge shall be absent, or shall have been counsel, or be interested in the cause, the circuit court may consist only of a judge of the Supreme Court. The power of circuit courts are granted to the district courts of Western Virginia and Northern Alabama. These circuit courts, thus organized, are vested with original cognizance, concurrent with the courts of the several states, of all suits of a civil nature at common law or in equity, where the matter in dispute exceeds $500, exclusive of costs, and the United States are plaintiffs, or an alien is a party, or the suit is between a citizen of the state where the suit is brought and a citizen of another state. They have likewise exclusive cognizance, except in certain cases, which will be hereafter mentioned, of all crimes and offenses cognizable under the authority of the United States, exceeding the degree of ordinary misdemeanors, and of them they have concurrent jurisdiction with the district courts. But no person can be arrested in one district for trial in another, and no civil suit can be brought against an inhabitant of the United States out of his district. And the Act of Congress provides against the assumption of federal jurisdiction to be created by the assignment of promissory notes, or other choses in action, except foreign bills of exchange. The circuit courts have also appellate jurisdiction from all final decrees, in causes of equity or of admiralty and maritime jurisdiction, except in prize cases, and judgments in civil actions in the district courts, where the matter in dispute, exclusive of costs, exceeds $50. If the remedy be on final decrees in the district courts, in cases of admiralty and maritime jurisdiction, and the matter in dispute exceeds $300, it is by appeal. And if on final judgments in civil actions, and the matter in dispute exceeds $50, it is by writ of error. And if any suit be commenced in a state court against an alien, or by a citizen of the state in which the suit is brought against a citizen of another state, or against a citizen of the same state claiming lands under a grant from another state, and the matter in dispute exceeds $500, exclusive of costs, the defendant, on giving it security, may remove the cause to the next circuit court. The circuit courts have also original cognizance in equity and at law of all suits arising under any law of the United States relative to copyrights and patent rights growing out of inventions and discoveries, and to protect such rights by injunction. The jurisdiction in cases of copyrights applies, without regard to the character of the parties, or the amount in controversy, and with respect to the jurisdiction of the circuit courts, it may be laid down as a settled doctrine that they are courts of limited, though not of inferior, jurisdiction. And it is necessary, therefore, that there should appear upon the record of a circuit court the facts or circumstances which give jurisdiction, either expressly or by necessary legal intendment. District Courts. 3. The district, as well as the circuit courts, are derived from the power granted to Congress by the Constitution of constituting tribunals inferior to the Supreme Court. The United States are at present divided into from 36 to 40 districts, which generally consist of an entire state. But in New York, Pennsylvania, Virginia, North Carolina, South Carolina, Tennessee, Louisiana, Mississippi, and Alabama, there are more districts than one. A court is established in each district, consisting of one judge, who holds annually, in most of them, 4 stated terms, and in some of them only 3 or 2 or 1. And he also holds special courts in his discretion. The district courts have, exclusive of the state courts, cognizance of all lesser crimes and offenses cognizable under the authority of the United States, and committed within their respective districts or upon the high seas, and which are punishable by fine not exceeding $100, by imprisonment not exceeding 6 months, or when corporal punishment not exceeding 30 stripes is to be inflicted. They have also exclusive original cognizance of all civil causes of admiralty and maritime jurisdiction, including all seizures under impost, navigation, or trade laws of the United States, where the seizures are made upon the high seas, or on waters within their districts navigable from the sea with vessels of 10 or more tons burthen, and also of all other seizures made under the laws of the United States, and also of all suits for penalties and forfeitures incurred under those laws. They have also cognizance, concurrent with the circuit courts and the state courts, of causes where an alien sues for a tort committed in violation of the law of nations or of a treaty of the United States, and of all suits at common law in which the United States are plaintiffs and the matter in dispute amounts, exclusive of costs, to $100. They have jurisdiction, likewise, exclusive of the courts of the several states, of all suits against consuls or vice-consuls, except for offenses above the magnitude which has been mentioned. They have also cognizance of complaints, by whomsoever instituted, in cases of captures made within the waters of the United States, or within a marine league of its coast, and to repeal patents unduly obtained. The judges of the district courts have also, in cases where the party has not had a reasonable time to apply the circuit court, as full power to grant writs of injunction, to operate within their respective districts, as is exercised by the judges of the Supreme Court, and to continue until the next circuit court. They may also grant injunctions in particular cases under the Act for the better organization of the Treasury Department. In addition to these general powers vested in the district courts, they have, in those cases where the districts are so situated as not to permit conveniently the presence of a judge of the Supreme Court, the powers of a circuit court superadded to their ordinary powers of a district court. To guard against the inconvenience of a difference of opinion between the circuit judge and the district judge, when holding together a circuit court, it is provided by law that in all cases of appeal or error, from the district to the circuit court, judgment is to be rendered in conformity to the opinion of the judge of the Supreme Court, presiding in such circuit court. And in all other cases of a disagreement of opinion between the circuit and district judges, the point may be certified into the Supreme Court for its decision. But in no case shall imprisonment be allowed, or punishment inflicted, where the judges of the circuit court are divided in opinion upon the question. The superior courts of the several territories of the United States, in which no district court is established, have the enlarged jurisdiction of circuit courts, subject to revision by writ of error and appeal to the Supreme Court. The district and territorial judges of the United States are required to reside within their respective jurisdictions, and no federal judge can act as counsel or be engaged in the practice of the law. Duties vested in state courts. 4. The state courts are, in some cases, invested, by acts of Congress, with the cognizance of cases arising under the laws of the United States. By the acts of March 8, 1806, and April 21, 1808, and March 3, 1815, the county courts within or adjoining the revenue districts in certain parts of the states of New York, Pennsylvania, and Ohio are authorized to take cognizance of prosecutions for fines, penalties, and forfeitures arising under the revenue laws of the United States. And the state or county courts adjoining any collection district, in relation to taxes or internal duties which may, at the time hereafter, be assessed, have cognizance of all suits for taxes, duties, fines, penalties, and forfeitures arising thereon. In attending to this general survey of the organization of the judiciary establishment of the United States, it will be perceived that all the great features of the system are to be found in the Act of Congress, which was passed in September 1789, at the first session of the first Congress under the present Constitution. That act has stood the test of experience since that time, with very little alteration or improvement, and this fact is no small evidence of the wisdom of the plan, and of its adaptation to the interests and convenience of the country. The Act of 1789 was the work of much profound reflection, and of great legal knowledge, and the system then formed and reduced to practice has been so successful and so beneficial in its operation that the administration of justice in the federal courts has been constantly rising in influence and reputation. The principal officers of the courts are attorneys and counselors, clerks, and marshals. Attorneys and counsel. 1. Attorneys and counsel are regularly admitted by the several courts to assist the parties in their pleadings and in the conduct of their causes in those cases in which the parties do not appear and manage their own causes personally, as they are expressly permitted to do. This privilege conceded to parties, though reasonable in itself, is, upon the whole, useless, and the necessity of a distinct profession to render the application of the law easy and certain to every individual case, has always been felt in every country under the government of written law. As property becomes secure, and the arts are cultivated, and commerce flourishes, and when wealth and luxury are introduced and create the infinite distinctions and refinements of civilized life, the law will gradually and necessarily assume the character of a complicated science, requiring for its application the skill and learning of a particular profession. After the publication of the 12 Tables, suitors at Rome were obliged to resort to the assistance of their patrons, and judicial proceedings became the study and practice of a distinct and learned body of men. The division of advocates into attorneys and counsel has been adopted from the prevailing usage in the English courts. The business of the former is to carry on the practical and more mechanical parts of the suit, and of the latter to draft or review and correct the special pleadings, to manage the cause at trial, and also during the whole course of the suit, to apply established principles of law to the exigencies of the case. In the Supreme Court of the United States, the 2 degrees of attorney and counsel are kept separate, and no person is permitted to practice both as attorney and counselor in that court. This was by a rule of the court in February 1790, and when, afterwards, in August 1801, the court declared that counselors might be admitted as attorneys, on taking the usual oath, this did not mean or imply that if a counselor was thus admitted as attorney, he could continue to act as counselor. He must make his election between the 2 degrees. In all the other courts of the United States, as well as in the courts of New York and the other states, the same person can be admitted to the 2 degrees of attorney and counsel, and exercise the powers of each. Besides the ordinary attorneys, the statute has directed that a meet person learned in the law be appointed to act as the Attorney General of the United States, and besides special and incidental duties, it is made generally his duty to prosecute and conduct all suits in the Supreme Court, in which the United States are concerned, and to give his advice and opinion upon questions of law when required by the President or the heads of the departments. Each judicial district has likewise a public officer to act as attorney for the United States in the district, and to prosecute all delinquents for crimes or offenses cognizable under the authority of the United States, and to prosecute all civil actions within his district in which the United States are concerned. Clerks. 2. Clerks are appointed by the several courts, except that the clerk of the district court is ex officio clerk of the circuit court in such district. They have the custody of the seal and records, and are bound to sign and seal all processes, and to record the proceedings and judgments of the court. And this is a trust of so much importance, that in addition to the ordinary oath of office, clerks are obliged to give security to the public for the faithful performance of their duty. To guard still further against abuse of office, all monies paid into the circuit or district courts, or received by the officers, in cases pending therein, are required to be immediately deposited in bank, and no money can be drawn out of bank, except by an order of a judge, to be signed by him, and certified of record by the clerk. The clerks are likewise bound, at every regular session of the courts, to exhibit an account of all the monies remaining in court. Marshals. 3. Marshals are analogous to sheriffs at common law. They are appointed for each judicial district by the President and Senate for the term of 4 years, but are removable at pleasure. And it is the duty of the marshal to attend the district and circuit courts, and to execute, within the district, all lawful precepts directed to him, and to command all requisite assistance in the execution of his duty. There are also various special duties assigned by statute to the marshals. The appointment of deputies is a power incidental to the office, and the marshal is responsible civiliter for their conduct, and they are removable not only at his pleasure, but they are also, by statute, made removable at the pleasure of the district or circuit courts. The Act says that the marshal shall be removable at pleasure, without saying by whom. And on the first organization of the government, it was made a question whether the power of removal, in case of officers appointed to hold at pleasure, resided anywhere but in the body which appointed, and of course whether the consent of the Senate was not requisite to remove. This was the construction given to the Constitution while it was pending for ratification before the state conventions, by the author of the Federalist. Quote, "The consent of the Senate," end quote, the Federalist observes, quote, "would be necessary to displace as well as to appoint," end quote. And he goes on to observe that, quote, "those who can best estimate the value of a steady administration will be most disposed to prize the provision which connects the official existence of public men with the approbation or disapprobation of that body, which, from the great permanency of its own composition, will in all probability be less subject to inconstancy than any other member of the government," end quote. But the construction which was given to the Constitution by Congress, after great consideration and discussion, was different. In the Act for establishing the Treasury Department, the Secretary was contemplated as being removable from office by the President. The words of the Act are, quote, "that whenever the Secretary shall be removed from office by the President of the United States, or in any other case of vacancy in the office, the assistant shall act," end quote. This amounted to a legislative construction of the Constitution, and it has ever since been acquiesced in and acted upon, as of decisive authority in the case. It applies equally to every other officer of government appointed by the President and Senate, whose term of duration is not specially declared. It is supported by the weighty reason that the subordinate officers in the executive department ought to hold at the pleasure of the head of that department, because he is invested generally with the executive authority, and every participation in that authority by the Senate was an exception to a general principle, and ought to be taken strictly. The President is the great responsible officer for the faithful execution of the law, and the power of removal was incidental to that duty, and might often be requisite to fulfill it. This subject has never been made the subject of judicial discussion, and the construction given to the Constitution in 1789 has continued to rest on this loose incidental declaratory opinion of Congress, and the sense and practice of government since that time. It may now be considered as firmly and definitively settled, and there is good sense and practical utility in the construction. It is, however, a striking fact in the constitutional history of our government, that a power so transcendent as that is, which places at the disposal of the President alone the tenure of every executive officer appointed by the President and Senate, should depend upon inference merely, and should have been gratuitously declared by the first Congress, in opposition to the high authority of the Federalist, and should have been supported or acquiesced in by some of these distinguished men who questioned or denied the power of Congress, even to incorporate a national bank. The Marshal is obliged to give security to the United States in $20,000 for the faithful performance of the duties of his office by himself and his deputies, and, together with his deputies, to take an oath of office. By the common law, the death of the principal is a virtual repeal of the authority of the substitute or deputy, but to guard against any inconvenience which might arise from the operation of this principle, and to prevent the mischiefs of a vacancy in office, the Act establishing the judicial courts has provided that in the case of death of the Marshal, his deputies shall continue in office, unless otherwise especially removed, and shall execute the same in the name of the deceased Marshal, until another Marshal be appointed and sworn. So, a Marshal, when removed from office, or his term of office expires, may still execute all process in his hands, and he remains responsible for his prisoners until they are duly delivered over to his successor. And with respect to the custody of the prisoners, under the laws of the United States, the marshal is directed to deliver his prisoners to the keeper of one of the jails of the state in which he is marshal, in cases where the legislature of the state, in conformity with the recommendation of Congress, have made it the duty of the jailers to receive them. But where they have not, the marshal, under the direction of the district judge, is to provide his own place of security. End of section 24.
Section 25 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information, or to volunteer, please visit LibriVox.org. Read by Verla Viera. Commentaries on American Law, Volume 1, by James Kent, of the original and appellate jurisdiction of the Supreme Court. Having taken a general view of the great departments of the government of the United States, I proceed to a more precise examination of its powers and duties, and of the degree of subordination under which the state governments are constitutionally placed. Test of constitutional power. The Constitution of the United States is an instrument containing the grant of specific powers, and the government of the Union cannot claim any powers but what are contained in the grant, and given either expressly or by necessary implication. The powers vested in the state governments by their respective constitutions, or remaining with the people of the several states prior to the establishment of the Constitution of the United States, continue unaltered and unimpaired, except so far as they are granted to the United States. We are to ascertain the true construction of the Constitution and the precise extent of the residuary authorities of the several states by the declared sense and practice of the governments respectively when there is no collision. And in all other cases, where the question is of a judicial nature, we are to ascertain it by the decisions of the Supreme Court of the United States. And those decisions ought to be studied and universally understood in respect to all the leading questions of constitutional law. The people of the United States have declared the Constitution to be the supreme law of the land, and it is entitled to universal and implicit obedience. Every act of Congress, and every act of the legislatures of the states, and every part of the Constitution of any state, which is repugnant to the Constitution of the United States, is necessarily void. This is a clear and settled principle of constitutional jurisprudence. The judicial power of the Union is declared to extend to all cases in law and equity arising under the Constitution, and to the judicial power it belongs, whenever a case is judicially before it, to determine what is the law of the land. The determination of the Supreme Court of the United States, in every such case, must be final and conclusive, because the Constitution gives to that tribunal the power to decide, and gives no appeal from the decision. With respect to the judicial power, it may be generally observed, as the Supreme Court declared in the case of Turner v. the Bank of North America, that the disposal of the judicial power, except in a few specified cases, belongs to Congress, and the courts cannot exercise jurisdiction in every case to which the judicial power extends without the intervention of Congress, who are not bound to enlarge the jurisdiction of the federal courts to every subject which the Constitution might warrant. So again, it has been decided that Congress have not delegated the exercise of judicial power to the circuit courts, but in certain specified cases. The 11th section of the Judiciary Act of 1789, giving jurisdiction to the circuit courts, has not covered the whole ground of the Constitution, and those courts cannot, for instance, issue a mandamus, but in those cases in which it may be necessary to the exercise of their jurisdiction. Original jurisdiction of the Supreme Court. The original jurisdiction of the Supreme Court is very limited, and it has been decided that Congress have no power to extend it. It is confined by the Constitution to those cases which affect ambassadors, other public ministers, and consuls, and to those in which a state is a party. And it has been made a question whether this original jurisdiction of the Supreme Court was intended by the Constitution to be exclusive. The Judiciary Act of 1789 seems to have considered it to be competent for Congress to vest concurrent jurisdiction in those specified cases in other courts, for it gave a concurrent jurisdiction in some of those cases to the circuit courts. In the case of the United States v. Viera, this point arose in the Circuit Court for Pennsylvania District, and it was held that Congress could vest a concurrent jurisdiction in other courts of those very cases over which the Supreme Court had original jurisdiction, and that the word original was not to be taken to imply exclusive cognizance of the cases enumerated. But the opinion of the Supreme Court of the United States in Marbury v. Madison goes far towards establishing the principle of exclusive jurisdiction in the Supreme Court in all those cases of original jurisdiction. This last case was considered, in Pennsylvania v. Kosloff, as shaking the decision in the case of Viera, and yet the question was still left in doubt by the Supreme Court in the case of the United States v. Ortega, and a decision upon it was purposely waived. Admitting this original jurisdiction of the Supreme Court may be shared by other courts in the discretion of Congress, it has been decided, as we shall presently see, that this original jurisdiction cannot be enlarged, and that the Supreme Court cannot be vested, even by Congress, with any original jurisdiction in other cases than those described in the Constitution. It is the appellate jurisdiction of the Supreme Court that clothes it with most of its dignity and efficacy, and renders it a constant object of attention and solicitude on the part of the governments and the people of the several states. Appellate jurisdiction. The Supreme Court has appellate jurisdiction, in certain cases, over final decisions in the state courts. We have seen that, by the Act of Congress of the 24th of September, 1789, Section 25, a final judgment or decree in any suit in the highest court of law or equity of a state, where is drawn in question the validity of a treaty and the decision is against its validity, or where is drawn in question the construction of a treaty and the decision is against the title, right, or privilege set up or claimed under it, may be re-examined and reversed or affirmed in the Supreme Court of the United States upon a writ of error. And upon reversal, the cause may be remanded for final decision, or the Supreme Court may, at their discretion, if the cause shall have been once remanded before, proceed to a final decision of the same and award execution. The word final, in the Judiciary Act, is understood to apply to all judgments and decrees which determine the particular cause. And it is not to be confined to those judgments and decrees which are so final as to terminate all further or renewed litigation, in a new suit, on the same right. Under this appellate authority, it was declared, in the case of Clerk v. Harwood, that if the highest court in a state reversed the judgment of a subordinate court, and, on appeal to the Supreme Court of the United States, the judgment of the highest state court be in its turn reversed, it becomes a mere nullity, and the mandate for execution may issue to the inferior state court. But, in the case of Fairfax v. Hunter, a writ of error from the Supreme Court of the United States was awarded to the Court of Appeals of Virginia, upon a judgment in that court, against the right claimed under a construction of the treaties made with Great Britain in 1783 and 1794, and the judgment of the Court of Appeals was reversed, and the cause remanded, and the Court of Appeals below were required to cause the original judgment, which had been reversed in that court, to be carried into due execution. The Court of Appeals, when the cause came back to them, resolved that the appellate power of the Supreme Court of the United States did not extend to that court, and that so much of the Act of Congress as extended the appellate jurisdiction of the Supreme Court to that court was not warranted by the Constitution, and that the proceedings in the Supreme Court were coram non judice in relation to that court, and they, consequently, declined obedience to its mandate. A writ of error was awarded upon this refusal, and the cause came up again before the Supreme Court of the United States, in a case in which the judgment of the court below drew in question and denied the validity of the statute of the United States authorizing an appeal from a state court. A graver question could scarcely have arisen in that court, or one involving considerations of higher importance and delicacy, or more deeply affecting the permanency and tranquility of the American Union. In the opinion which was delivered, the court observed that the Constitution unavoidably dealt in general language, and did not enter into a minute specification of powers, or declare the means by which those powers were to be carried into execution. This would have been a perilous and difficult, if not an impracticable, task, and the Constitution left it to Congress, from time to time, to adopt its own means to effectuate legitimate objects, and to mold and model the exercise of its powers as its own wisdom and the public interests should require. The judicial power of the United States is declared to extend to all cases arising under treaties made under the authority of the United States. It was an absolute grant of the judicial power in that case, and it was competent for the people of this country to invest the general government with that or with any other powers they might deem proper and necessary, and to prohibit the states from the exercise of any powers which were, in their judgment, incompatible with the objects of the general compact. Congress were bound, by the injunctions of the Constitution, to create inferior courts, in which to vest all that judicial jurisdiction which was exclusively vested in the United States, and of which the Supreme Court cannot take any other than an appellate cognizance. The whole judicial power must be at all times vested, either in an original or appellate form, in some courts created under the authority of the United States. The grant of the judicial power was absolute, and it was imperative upon Congress to provide for the appellate jurisdiction of the federal courts in all the cases in which judicial power was exclusively granted by the Constitution, and not given, by way of original jurisdiction, to the Supreme Court. The Court, in their examination of the judicial power, supposed that the Constitution took a distinction between two classes of enumerated cases. It intended that the judicial power, either in an original or appellate form, should extend absolutely to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made under their authority, and to all cases affecting ambassadors, other public ministers, and consuls, and to all cases of admiralty and maritime jurisdiction, because those cases were of vital importance to the sovereignty of the Union, and they entered into national policy and affected the national rights and the law and comity of nations. The original or appellate jurisdiction ought, therefore, to be commensurate with the mischiefs intended to be remedied and the policy in view. But, in respect to another class of cases, the Constitution seemed, ex industria, to drop the word all and to extend the jurisdiction of the Judiciary not to all controversies, but to controversies in which the United States were a party, or between two or more states, or between citizens of different states, etc., and to leave it to Congress to qualify the jurisdiction, original or appellate, in such manner as public policy might dictate. But whatever weight might be due to that distinction, it was held to be manifest that the judicial power was, unavoidably in some cases, exclusive of all state authority, and in all others might be made so at the election of Congress. The Judiciary Act, throughout every part of it, and particularly in the 9th, 11th, and 13th sections, assumed that in all cases to which the judicial powers of the United States extended, Congress might rightfully vest exclusive jurisdiction in their own courts. The criminal and the admiralty and maritime jurisdiction must be exclusive, and it was only in those cases where, previous to the Constitution, state tribunals possessed jurisdiction independent of national authority, that they could now constitutionally exercise a concurrent jurisdiction. The exercise of appellate jurisdiction was not limited by the Constitution to the Supreme Court. Congress might create a succession of inferior tribunals, in each of which it might vest appellate as well as original jurisdiction. The appellate jurisdiction of the Supreme Court, in cases where it had not original jurisdiction, was declared to be subject to such exceptions and regulations as Congress might prescribe. It remained, therefore, entirely in the discretion of Congress to cause the judicial power to be exercised in every variety of form of appellate jurisdiction, and the appellate power was not limited to cases pending in the courts of the United States. If it had been limited to cases in those courts, it would necessarily follow that the jurisdiction of the federal courts must have been exclusive of state courts in all the cases enumerated in the Constitution. If the judicial power of the United States extends to all cases arising under the Constitution, laws, and treaties of the Union, and to all cases of admiralty and maritime jurisdiction, the state courts could not, consistently with the express grant in the Constitution, entertain any jurisdiction in those cases without the right of appeal. If the state courts might entertain concurrent jurisdiction over any of those cases without control, then the appellate jurisdiction of the United States, as to such cases, would have no existence, which would be contrary to the manifest intent of the Constitution. The appellate power of the federal courts must extend to the state courts so long as the state courts entertain any concurrent jurisdiction over the cases which the Constitution has declared shall fall within the cognizance of the judicial power. It is very plain that the Constitution did contemplate that cases within the judicial cognizance of the United States would arise in the state courts in the exercise of their ordinary jurisdiction, and that the state courts would incidentally take cognizance of the cases arising under the Constitution, the laws, and the treaties of the United States, and as the judicial power of the United States extended to all such cases by the very terms of the Constitution, it followed as a necessary consequence that the appellate jurisdiction of the courts of the United States must and did extend to the state tribunals and attach upon every case within the cognizance of the judicial power. All the enumerated cases of federal cognizance are those which touch the safety, peace, and sovereignty of the nation, or which presume that state attachments, state prejudices, state jealousies, and state interests might somehow obstruct or control the regular administration of justice. The appellate power, in all these cases, is founded on the clearest principles of policy and wisdom, and is deemed requisite to fulfill effectually the great and beneficent ends of the Constitution. It is likewise necessary, in order to preserve uniformity of decision throughout the United States upon all subjects within the purview of the Constitution, and the mischiefs of opposite constructions and contradictory decisions in the different states on all these points of general concern would be deplorable. The right of removal of a cause from a state court by a defendant, who is entitled to try his rights and assert his privileges in the national forum, is also the exercise of appellate jurisdiction, and the right of removal of a cause may exist before or after judgment in the discretion of Congress. The Supreme Court, by a train of reasoning which appears to be unanswerable and conclusive, came to the decision that the appellate power of the United States did extend to cases pending in the state courts, and that the 25th section of the Judiciary Act of 1789, authorizing the exercise of this jurisdiction in the specified cases by a writ of error, was supported by the letter and spirit of the Constitution. The judgment of the Court of Appeals in Virginia, rendered on the mandate in the cause and denying the appellate jurisdiction of the Supreme Court, was consequently reversed, and the judgment of the District Court in Virginia, which the Court of Appeals in Virginia had reversed, was affirmed. Whether the Supreme Court had authority to issue the compulsory process of mandamus to the state courts to enforce the judgment of reversal was a question which the court did not think it necessary to discuss or decide, and one of the judges, in the separate opinion which he gave in the cause, seemed to think that the Supreme Court, in the exercise of its appellate jurisdiction, was supreme over the parties and over the case, but that it had no compulsory control over the state tribunals. The court itself gave no intimation of an opinion whether it could or could not lawfully resort to compulsory or restrictive process operating in personam upon the state tribunals, and it was no doubt deemed discreet not to assert more authority constitutionally vested in the court than was necessary for the occasion. If the appellate jurisdiction be founded, as it no doubt was in that case, on a solid basis, it would seem to carry with it, as of course, all the coercive power incident to every such jurisdiction and requisite to support it. Writ of mandamus. Another question, which was largely discussed and profoundly considered by the Supreme Court, was touching its authority to issue a mandamus when not arising in a case under its appellate jurisdiction, and when not required in the exercise of its original jurisdiction. In the case of Marbury v. Madison, the plaintiff had been nominated by the President, and, by and with the advice and consent of the Senate, had been appointed a Justice of the Peace for the District of Columbia, and the appointment had been made complete and absolute by the President's signature to the Commission, and the Commission had been made complete by affixing to it the seal of the United States. The Secretary of State, after all this, withheld the Commission, and the withholding of it was adjudged to be a violation of the vested legal right, for which the plaintiff was entitled to a remedy by mandamus, and the only question was whether the mandamus could constitutionally issue from the Supreme Court. The Judiciary Act, Section 13, authorized the Supreme Court to issue writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. There was no doubt that the Act applied to the case and gave the power if the law was constitutional. But the Court was of opinion that the Act, in this respect, was not warranted by the Constitution because the issuing of a mandamus in this case would be an exercise of original jurisdiction not within the Constitution, and Congress had not power to give original jurisdiction to the Supreme Court in other cases than those described in the Constitution. It had not authority to give to the Supreme Court appellate jurisdiction, where the Constitution had declared that its jurisdiction should be original, nor original jurisdiction, where the Constitution had declared it should be appellate. To enable the Court to issue a mandamus, it must be shown to be an exercise or necessary to an exercise of appellate jurisdiction. The Supreme Court may accordingly issue a mandamus to a circuit court of the United States, commanding it to sign a bill of exceptions, for this is an exercise of power warranted by the principles and usages of law. When a state is a party. The Constitution gives to the Supreme Court original jurisdiction in those cases in which a state shall be a party. And in Fowler v. Lindsay, the question arose when a state was to be considered a party. The parties in that suit claimed title to lands under grants from different states. The plaintiff brought his ejectment in the Circuit Court of Connecticut, claiming title under a grant from that state, and under a claim that the lands lay within the jurisdiction of that state. The defendant claimed title under a grant from New York, and on the ground that the lands lay within the rightful as well as actual jurisdiction of New York. The court laid down this rule on the subject of the jurisdiction of the Supreme Court, on account of the interest that a state has in the controversy, that it must be a case in which a state is either nominally or substantially the party, and that it is not sufficient that the state may be consequentially affected, as being bound to make retribution to her grantee upon the event of eviction. Though there may be a controversy relative to soil or jurisdiction between two states, yet if that controversy occurs in a suit between two individuals, to which neither of the states is a party upon the record, it is not a case within the original jurisdiction of the Supreme Court, because the states may contest the right of soil in the Supreme Court at any time, notwithstanding a decision in the suit between the individuals. Nor will a decision as to the right of soil between individuals affect the right of the state as to jurisdiction, and that jurisdiction may remain unimpaired, though the state may have parted with the right of soil. In such a case, the Supreme Court would not allow an injunction on a bill filed by the state of New York against the state of Connecticut to stay proceedings in the ejectment suit between individuals, though a general claim of soil and jurisdiction was involved in the private suit, because the state of New York was not a party to the suit in the circuit court, nor interested in the decision. Appellate jurisdiction depends on Congress. The appellate jurisdiction of the Supreme Court exists only in those cases in which it is affirmatively given. In the case of Wiscart v. Douchy, the Supreme Court considered that its whole appellate jurisdiction depended upon the regulations of Congress, as that jurisdiction was given by the Constitution in a qualified manner. The Supreme Court was to have appellate jurisdiction, quote, with such exceptions and under such regulations as Congress should make, end quote. And if Congress had not provided any rule to regulate the proceedings on appeal, the court could not exercise an appellate jurisdiction. And if a rule be provided, the court could not depart from it. In pursuance of this principle, the court decided in Clark v. Bazadone that a writ of error did not lie to that court from a court of the United States Territory northwest of the Ohio, because the act of Congress had not authorized an appeal or writ of error from such a court. It was urged that the judicial power extended to all cases arising under the Constitution, and that where the Supreme Court had not original, it had appellate jurisdiction, with such exceptions and under such regulations as Congress should make, and that the appellate power was derived from the Constitution, and must be full and complete in all cases appertaining to the federal judiciary, where Congress had not by law interfered and controlled it by exceptions and regulations. The court, however, adhered to the doctrine which they had before laid down, and proceeded upon the principle that though the appellate powers of the court were given by the Constitution, they were limited entirely by the judiciary statutes, which are to be understood as making exceptions to the appellate jurisdiction of the court, and to imply a negative on the exercise of such a power in every case but those in which it is affirmatively given and described by statute. This was the principle also explicitly declared in the case of the United States v. Moore, and in the case of Rousseau v. the United States. In the first of those cases, the rule of construction was carried to the extent of holding that no appeal or writ of error lay in a criminal case from the Circuit Court of the District of Columbia, because the appellate jurisdiction, as to that district, applied, by the terms of the statute, to civil cases only. The rule was afterwards, in Ex parte Kearney, laid down generally that the Supreme Court had no appellate jurisdiction from circuit courts in criminal cases confided to it by the laws of the United States. Nor has it any appellate jurisdiction over a judgment of the circuit courts in cases brought before it by writ of error from a district court, though it has over judgments and decrees of the circuit courts in suits brought before them by appeal from the district courts. Judicial power confined to cases arising under the Constitution, treaties, and laws. The Constitution says that the judicial power shall extend to all cases arising under the Constitution, laws, and treaties of the United States, and it has been made a question as to what was a case arising under a treaty. In Owings v. Norwood, there was an ejectment between two citizens of Maryland for lands in that state, and the defendant set up an outstanding title in a British subject, which he contended was protected by the British Treaty of 1794. The Court of Appeals decided against the title thus set up, and the Supreme Court of the United States held that not to be a case within the appellate jurisdiction of the court, because it was not a case arising under the treaty. The treaty itself was not drawn in question, either directly or incidentally. The title in question did not grow out of the treaty, and as the claim was not under the treaty, the title was not protected by it. And whether the treaty was an obstacle to the recovery was then a question exclusively for the state court. Appellate jurisdiction confined to matter on the record. The Judiciary Act of 1789 required, on error or appeal from a state court, that the error assigned appear on the face of the record, and immediately respect some question affecting the validity or construction of the Constitution, treaties, statutes, or authorities of the Union. Under this Act, it is not necessary that the record should state in terms the misconstruction of the authority of the Union, or that it was drawn in question, but it must show some act of Congress applicable to the case to give to the Supreme Court appellate jurisdiction. It will be sufficient if it be apparent that the case, in point of law, involved one of the questions on which the appellate jurisdiction is made to depend by the 25th section of the Judiciary Act of 1789, and that the state court must have virtually passed upon it. But the court has been so precise upon this point that in Miller v. Nichols, notwithstanding it was believed that an act of Congress, giving the United States priority in cases of insolvency, had been disregarded, yet, as the fact of insolvency did not appear upon record, the court decided that they could not take jurisdiction of the case. In the exercise of their appellate jurisdiction, the Supreme Court can only take notice of questions arising on matters of fact appearing upon the record. And in all cases where jurisdiction depends on the party, it is the party named in the record. It exists though a state be a party. The appellate jurisdiction may exist though a state be a party, and it extends to a final judgment in a state court on a case arising under the authority of the Union. The appellate powers of the federal judiciary over the state tribunals was again, and very largely discussed, in the case of Cohens v. Virginia, and the constitutional authority of the appellate jurisdiction of the Supreme Court was vindicated, with great strength of argument and clearness of illustration. The question arose under an act of Congress instituting a lottery in the District of Columbia, and the defendant below was criminally prosecuted for selling tickets in that lottery, contrary to an act of the legislature of Virginia. Judgment was rendered against him in the highest court of the state in which the cause was cognizable, though he claimed the protection of the act of Congress. A writ of error was brought upon that judgment into the Supreme Court of the United States on the ground that the prosecution drew in question the validity of the statute in Virginia as being repugnant to a law of the United States, and that the decision was in favor of the state law. It was made a great point in the case whether the Supreme Court had any jurisdiction. The court decided that its appellate jurisdiction was not excluded by the character of the parties, one of them being a state, and the other a citizen of the state. Jurisdiction was given to the courts of the Union in two classes of cases. In the first, their jurisdiction depended on the character of the cause, whoever might be the parties, and in the second, it depended entirely on the character of the parties, and it was unimportant what might be the subject of controversy. The general government, though limited as to its objects, was supreme with respect to those objects. It was supreme in all cases in which it was empowered to act. A case arising under the Constitution and laws of the Union was cognizable in the courts of the Union, whoever might be the parties to that case. The sovereignty of the states was limited, or surrendered in many cases, where there was no other power conferred on Congress than a constructive power to maintain the principles established in the Constitution. One of the instruments by which that duty might be peaceably performed was the Judicial Department. It was authorized to decide all cases of every description arising under the Constitution, laws, and treaties of the Union, and from this general grant of jurisdiction, no exception is made of those cases in which a state may be a party. It was likewise a political axiom that the judicial power of every well-constituted government must be coextensive with the legislative power, and must be capable of deciding every judicial question which grows out of the Constitution and laws. The most mischievous consequences would follow from the absence of appellate jurisdiction over a state court where a state was a party, for it would prostrate the government and laws of the Union at the feet of every state. The powers of the government could not be executed by its own means in any state disposed to resist its execution by a course of legislation. If the courts of the Union could not correct the judgments of the state courts, inflicting penalties under state laws upon individuals executing the laws of the Union, each member of the Confederacy would possess a veto on the will of the whole. No government ought to be so defective in its organization as not to contain within itself the means of securing the execution of its own laws. If each state was left at liberty to put its own construction upon the constitutional powers of Congress, and to legislate in conformity to its own opinion, and enforce its opinion by penalties, and to resist or defeat, in the form of law, the legitimate measures of the Union, it would destroy the Constitution, or reduce it to the imbecility of the old Confederation. To prevent such mischief and ruin, the Constitution of the United States, most wisely and most clearly, conferred on the Judicial Department the power of construing the Constitution and laws in every case, and of preserving them from all violation from every quarter, so far as judicial decisions could preserve them. The case before the court was one in which jurisdiction depended upon the character of the cause, as it was a case arising under the law of the Union. It was not an ordinary case of a controversy between a state and one of its citizens, for there the jurisdiction would depend upon the character of the parties. The court concluded that the appellate power did extend to the case, though a state was a party, because it was a case touching the validity of an act of Congress, and the decision of the state court was against its validity. And in all cases arising under the Constitution, laws, and treaties of the Union, the jurisdiction of the court may be exercised in an appellate form, though a state be a party. The court observed that the amendment to the Constitution, declaring that the judicial power was not to be construed to extend to any suit in law or equity commenced or prosecuted against a state by individuals, did not apply to a writ of error, which was not a suit against a state, within the meaning of the Constitution. And the jurisdiction of the Supreme Court, in cases arising under the Constitution, laws, and treaties of the Union, may be exercised by a writ of error brought upon the judgment of a state court. The United States are one nation and one people, as to all cases and powers given by the Constitution, and the judicial power must be competent not only to decide on the validity of the Constitution or law of a state, if it be repugnant to the Constitution or to a law of the United States, but also to decide on the judgment of a state tribunal enforcing such unconstitutional law. The federal courts must either possess exclusive jurisdiction in all cases affecting the Constitution and laws and treaties of the Union, or they must have power to revise the judgments rendered on them by the state tribunals. If the several state courts had final jurisdiction over the same cases arising upon the same laws, it would be a hydra in government, from which nothing but contradiction and confusion could proceed. Nothing can be plainer than the proposition that the Supreme Court of the nation must have power to revise the decisions of local tribunals on questions which affect the nation, or the most important ends of the government might be defeated, and we should be no longer one nation for any efficient purpose. The doctrine would go to destroy the great fundamental principles on which the fabric of the Union stands. We have now finished the review of the most important points that have arisen in the jurisprudence of the United States on the subject of the original and appellate jurisdiction of the Supreme Court. So far as the powers of that court, under the Constitution and under the 25th section of the Judiciary Act of 1789, have been drawn in question, they have been maintained with great success and with an equal display of dignity and discretion. End of Section 25.
Section 26 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by disillusionedjimson. Commentaries on American Law, Volume 1, by James Kent. Of the jurisdiction of the federal courts in respect to the common law and in respect to parties, Part 1. 1. It has been a subject of much discussion whether the courts of the United States have a common law jurisdiction, and, if any, to what extent. The U.S. courts have no common law jurisdiction in criminal cases. In the case of United States v. Worrell in the Circuit Court at Philadelphia, the defendant was indicted and convicted of an attempt to bribe the Commissioner of the Revenue, and it was contended, on the motion in arrest of judgment, that the court had no jurisdiction of the case, because all the judicial authority of the federal courts was derived, either from the Constitution or the acts of Congress made in pursuance of it, and an attempt to bribe the Commissioner of the Revenue was not a violation of any constitutional or legislative prohibition. Whenever Congress shall think any provision by law necessary to carry into effect the constitutional powers of the government, it was said, they may establish it, and then a violation of its sanctions will come within the jurisdiction of the circuit courts, which have exclusive cognizance of all crimes and offenses cognizable under the authority of the United States. Congress had provided by law for the punishment of various crimes, and even for the punishment of bribery itself, in the case of a judge, an officer of the customs, or an officer of the excise. But, in the case of the Commissioner of the Revenue, the act of Congress did not create or declare the offense. The question then fairly and directly presented itself. What was there to render it an offense arising under the Constitution or laws of the United States, and cognizable under their authority? A case arising under a law must mean a case depending on the exposition of a law, in respect to something which the law prohibits or enjoins. And if it were sufficient, in order to vest a jurisdiction to try a crime, or sustain an action, that a federal officer was concerned and affected by the act, a source of jurisdiction would be opened which would destroy all the barriers between the judicial authorities of the states and the general government. Though an attempt to bribe a public officer be an offense at common law, the Constitution of the United States contains no reference to a common law authority. Every power in the Constitution was matter of definite and positive grant, and the very powers that were granted could not take effect until they were exercised through the medium of a law. Though Congress had the power to make a law which would render it criminal to offer a bribe to the Commissioner of the Revenue, they had not done it, and the crime was not recognized either by the legislative or constitutional code of the Union. In answer to this view of the subject, it was observed that the offense was within the terms of the Constitution, for it arose under a law of the United States, and was an attempt by bribery to obstruct or prevent the execution of the laws of the Union. If the Commissioner of the Revenue had accepted the bribe, he would have been indictable in the courts of the United States, and, upon principles of analogy, the offense of the person who attempted it must be equally cognizable in those courts. The prosecution against Henfield for serving on board a French privateer against the Dutch was the exercise of a common law power, applied to an offense against the law of nations, and a breach of a treaty, which provided no specific penalty for such a case. The court were divided in opinion on this question. In the opinion of the circuit judge, an indictment at common law could not be sustained in the circuit court. It was admitted that Congress were authorized to define and punish the crime of bribery. But as the act charged as an offense in the indictment had not been declared by law to be criminal, the courts of the United States could not sustain a criminal prosecution for it. The United States, in their national capacity, have no common law, and their courts have not any common law jurisdiction in criminal cases, and Congress have not provided by law for the offense contained in the indictment, and until they defined the offense and prescribed the punishment, he thought the court had not jurisdiction of it. The district judge was of a different opinion, and he held that the United States were constitutionally possessed of a common law power to punish misdemeanors, and the power might have been exercised by Congress in the form of a law, or it might be enforced in a course of judicial proceeding. The offense in question was one against the well-being of the United States, and from its very nature cognizable under their authority. This case settled nothing, as the court were divided, but it contained some of the principal arguments on each side of this nice and interesting constitutional question. In the case of the United States v. Burr, which arose in the Circuit Court in Virginia in 1807, the Chief Justice of the United States declared that the law of the several states could not be regarded as rules of decision in trials for offenses against the United States, because no man could be condemned or prosecuted in the federal courts on a state law. The expression trials at common law, used in the 34th section of the Judiciary Act, was not applicable to prosecutions for crimes. It applied to civil suits, as contradistinguished from criminal prosecutions, and to suits at common law, as contradistinguished from those which came before the court sitting as a court of equity and admiralty. He admitted, however, that when the Judiciary Act, Section 14, authorized the courts to issue writs not specially provided for by statute, but which were agreeable to the principles and usages of law, it referred to that generally recognized and long-established law, which formed the substratum of the laws of every state. The case of the United States v. Hudson and Goodwin brought this great question in our national jurisprudence for the first time before the Supreme Court of the United States. The question there was whether the Circuit Court of the United States had a common law jurisdiction in cases of libel. The defendants had been indicted in the Circuit Court in Connecticut for a libel on the President of the United States, and the court was divided on the point of jurisdiction. A majority of the Supreme Court decided that the circuit courts could not exercise a common law jurisdiction in criminal cases. Of all the courts which the United States, under their general powers, might constitute, the Supreme Court was the only one that possessed jurisdiction derived immediately from the Constitution. All other courts created by the general government possessed no jurisdiction but what was given them by the power that created them, and could be vested with none but what the power ceded to the general government would authorize them to confer. And the jurisdiction claimed in that case has not been conferred by any legislative act. When a court is created and its operations confined to certain specific objects, it cannot assume a more extended jurisdiction. Certain implied powers must necessarily result to the courts of justice from the nature of their institution, but jurisdiction of crimes against the state was not one of them. To fine for contempt, to imprison for contumacy, to enforce the observance of orders, are powers necessary to the exercise of all other powers, and incident to the courts without the authority of a statute. But to exercise criminal jurisdiction in common law cases was not within their implied powers, and it was necessary for Congress to make the act a crime, to affix a punishment to it, and to declare the court which should have jurisdiction. The general question was afterwards brought into renewed discussion in the Circuit Court of the United States for Massachusetts, in the case of the United States v. Coolidge. Notwithstanding the decision in the case of the United States v. Hudson and Goodwin, the court in Massachusetts thought the question, in consequence of its vast importance, entitled to be reviewed and again discussed, especially as the case in the Supreme Court had been decided without argument, and by a majority only of the court. In this case, the defendant was indicted for an offense committed on the high seas, in forcibly rescuing a prize which had been captured by an American cruiser. The simple question was whether the Circuit Court had jurisdiction to punish offenses against the United States, which had not been previously defined, and a specific punishment affixed by statute. The judge who presided in that court did not think it necessary to consider the broad question, whether the United States, as a sovereign power, had entirely adopted the common law. He admitted that the courts of the United States were courts of limited jurisdiction, and could not exercise any authorities not confided to them by the Constitution and laws made in pursuance of it. But he insisted that when an authority was once lawfully given, the nature and extent of that authority, and the mode in which it should be exercised, must be regulated by the rules of the common law, and that if this distinction was kept in sight, it would dissipate the whole difficulty and obscurity of the subject. It was not to be doubted that the Constitution and laws of the United States were made in reference to the existence of the common law, whatever doubts might be entertained as to the question, whether the common law of England in its broadest sense, including equity and admiralty as well as legal doctrines, was the common law of the United States. In many cases, the language of the Constitution and laws would be inexplicable without reference to the common law, and the existence of the common law is not only supposed by the Constitution, but it is appealed to for the construction and interpretation of its powers. It was competent for Congress to confide to the Circuit Court's jurisdiction of all offenses against the United States, and they have given to it exclusive cognizance of most crimes and offenses cognizable under the authority of the United States. The words of the 11th section of the Judiciary Act of 1789 were that the Circuit Court should have exclusive cognizance of all crimes and offenses cognizable under the authority of the United States, except where this act otherwise provides, or that laws of the United States shall otherwise direct. This means all crimes and offenses to which, by the Constitution of the United States, the judicial power extends, and the jurisdiction could not be given in more broad and comprehensive terms. To ascertain what are crimes and offenses against the United States, recourse must be had to the principles of the common law, taken in connection with the Constitution. Thus, Congress had provided for the punishment of murder, manslaughter, and perjury under certain circumstances, but had not defined those crimes. The explanation of them must be sought in, and exclusively governed by, the common law, and upon any other supposition, the judicial power of the United States would be left in its exercise to arbitrary discretion. In a great variety of cases arising under the laws of the United States, the will of the legislature cannot be executed unless by the adoption of the common law. The interpretation and exercise of the vested jurisdiction of the courts of the United States, as, for instance, in suits in equity and in causes of admiralty and maritime jurisdiction, and in very many other cases, must, in the absence of positive law, be governed exclusively by the common law. There are many crimes and offenses, such as offenses against the sovereignty, the public rights, the public justice, the public peace, and the public police of the United States, which are cognizable under its authority, and in the exercise of the jurisdiction of the United States over them, the principles of the common law must be applied, in the absence of statute regulations. Treason, conspiracies to commit treason, embezzlement of public records, bribery, resistance to judicial process, riots, and misdemeanors on the high seas, frauds, and obstructions of the public laws of trade, and robbery and embezzlement of the mail of the United States are offenses at common law, and when directed against the United States, they are offenses against the United States. And being offenses, the circuit courts have cognizance of them, and can try and punish them upon the principles of the common law. The punishment must be fine and imprisonment, for it is a settled principle that where an offense exists, to which no specific punishment is affixed by statute, fine and imprisonment is the punishment. The common law is then to be referred to, not only as the rule of decision in criminal trials in the courts of the United States, but in the judgment or punishment. And by common law he meant the word in its largest sense, as including the whole system of English jurisprudence. It was accordingly concluded that the circuit courts had cognizance of all offenses against the United States, and what those offenses were depended upon the common law applied to the powers confided to the United States, and that the circuit courts, having such cognizance, might punish by fine and imprisonment, where no punishment was specially provided by statute. The Admiralty was a court of extensive criminal as well as civil jurisdiction, and offenses of Admiralty jurisdiction were exclusively cognizable by the United States, and were offenses against the United States, and punishable by fine and imprisonment, when no other punishment was specially prescribed. This case was brought up to the Supreme Court, but it was not argued. A difference of opinion still existed among the members of the court, and, under the circumstances, the court merely said that they did not choose to review their former decision in the case of the United States v. Hudson and Goodwin, or draw it in doubt. The decision was for the defendant, and, consequently, against the claim to any common law jurisdiction in criminal cases. These jarring opinions and decisions of the federal courts have not settled the general question as to the application and influence of the common law upon clear and definite principles, and it may still be considered, in civil cases, as open for further consideration. The case of Hudson and Goodwin decided that the United States courts had no jurisdiction given them by the Constitution or by statute over libels, and the case of Worrell decided that they had no jurisdiction in the case of an attempt to bribe a commissioner of the revenue. If that were so, the common law certainly could not give them any. The cases were therefore very correctly decided upon the principle assumed by the court. But the subsequent case of Coolidge did not fall within that principle, because the offense there charged was clearly a case of Admiralty jurisdiction, and the courts of the United States would seem to have had general and exclusive jurisdiction over the case. Mr. Duponceau, in his dissertation on the nature and extent of the jurisdiction of the courts of the United States, has ably examined the subject and shed strong light on this intricate and perplexed branch of the national jurisprudence. He pursues the distinction originally taken in the Circuit Court in Massachusetts, and maintains that we have not, under our federal government, any common law, considered as a source of jurisdiction, while on the other hand, the common law, considered merely as the mean or instrument of exercising the jurisdiction conferred by the Constitution and laws of the Union, does exist, and forms a safe and beneficial system of national jurisprudence. The courts cannot derive their right to act from the common law. They must look for that right to the Constitution and law of the United States. But when the general jurisdiction and authority is given, as in cases of admiralty and maritime jurisdiction, the rules of action under that jurisdiction, if not prescribed by statute, may and must be taken from the common law when they are applicable, because they are necessary to give effect to the jurisdiction. The principle assumed by the courts in the cases of Worrell and of Hudson and Goodwin is considered to be safe and sound principle. The mere circumstance that the party injured by the offense under prosecution was an officer of the government of the United States does not give jurisdiction, for neither the Constitution nor the judicial acts founded upon it gave the federal courts a general jurisdiction in criminal cases affecting the officers of government, as they have in cases affecting public ministers and consuls. Because an officer was appointed under the Constitution, that would not of itself render all cases in which they were concerned or might be affected cases arising under the Constitution and laws, and cognizable by the judiciary. Such a wide construction would be transferring legislative power to the judiciary, and vest it with almost unlimited jurisdiction. For where is the act that might not, in some distant manner, be connected with the Constitution or the laws of the United States? It rests alone in the discretion of Congress to throw over the persons and character of the officers of the government acting in their official stations a higher protection than that afforded by the laws of the states. And when laws are made for that purpose, the federal courts will be charged with the duty of executing them. This appears to be sound doctrine, and to be deduced from the cases which have been mentioned. There is much weight undoubtedly due to the argument of the Circuit Court in Massachusetts, and an attempt to bribe an officer of the government, or to libel an officer of the government in relation to his official acts, would seem to be an offense against that government. They tend directly to weaken or pervert the administration of it. And if it once be admitted that such acts amount to an offense against the United States, they must of course be cognizable under its authority and belong to the jurisdiction of the circuit courts. The great difficulty and the danger is in leaving it to the courts to say what is an offense against the United States, when the law has not specifically defined it. The safer course undoubtedly is to confine the jurisdiction in criminal cases to statute offenses duly defined, and to cases within the express jurisdiction given by the Constitution. The admiralty jurisdiction of the federal courts is derived expressly from the Constitution, and criminal cases belonging to that jurisdiction by the common law, and by the law of nations, might well have been supposed to be cognizable in the admiralty courts without any statute authority. If the common law be a rule of decision in the exercise of the lawful jurisdiction of the federal courts, why ought it not to apply to criminal as well as to civil cases, and upon the same principle, when jurisdiction is clearly vested? If Congress should by law authorize the district or circuit courts to take cognizance of attempts to bribe an officer of the government in the exercise of his official trust, and should make no further provision, the courts would, of course, in the description, definition, prosecution, and punishment of the offense, be bound to follow those general principles and usages, which are not repugnant to the Constitution and laws of the United States, and which constitute the common law of the land, and form the basis of all American jurisprudence. Though the judiciary power of the United States cannot take cognizance of offenses at common law, unless they have jurisdiction over the person or subject matter, given them by the Constitution or laws made in pursuance of it. Yet, when the jurisdiction is once granted, the common law, under the correction of the Constitution and statute law of the United States, would seem to be a necessary and safe guide, in all cases, civil and criminal, arising under the exercise of that jurisdiction, and not specially provided for by statute. Without such a guide, the courts would be left to a dangerous discretion, and to roam at large in the trackless field of their own imaginations. End of section 26.
Section 27 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of the jurisdiction of the federal courts in respect to the common law and in respect to parties, Part 2. Jurisdiction when an alien is a party. In Bingham v. Cabot, the Supreme Court held that it was necessary to set forth the citizenship of the respective parties or the alienage when a foreigner was concerned by positive averments in order to bring the case within the jurisdiction of the circuit court, and that if there was not a sufficient allegation for that purpose on record, no jurisdiction of the suit would be sustained. The same doctrine was maintained in Turner v. Enville and in Turner v. the Bank of North America. And it was declared that the circuit court was a court of limited jurisdiction and had cognizance only of a few cases specially circumstanced, and that the fair presumption was that a cause was without its jurisdiction till the contrary appeared. Upon that principle the rule was founded, making it necessary to set forth, upon the record of the circuit court, the facts or circumstances which gave jurisdiction either expressly or in such manner as to render them certain by legal intendment. It is necessary, therefore, where the defendant appears to be a citizen of one state, to show the averment that the plaintiff is a citizen of some other state or an alien, or if the suit be upon a promissory note by the endorsee, to show that the original payee was so, for it is his description as well as that of the endorsee which gives the jurisdiction. But an alien cannot sue a citizen in the Circuit Court of the United States if the latter be at the time a resident in a foreign country, notwithstanding he has property in the district which might be attached. No compulsory process under the Judiciary Act of 1789 lies against a person who is not at the time an inhabitant of or is not found in the district in which the process issues. Between citizens of different states. The Judiciary Act of 1789, Section 11, gives jurisdiction to the Circuit Court when an alien is a party, and it was decided in Mossman v. Higginson that the jurisdiction was confined to the case of suits between citizens and foreigners and did not extend to suits between alien and alien, and that if it appeared on record that the one party was an alien, it must likewise appear affirmatively that the other party was a citizen. So again, in Corse v. Stead, it was decided to the same effect. The principle is that it must appear upon the record that the character of the parties supports the jurisdiction, and the points in that case were reasserted in Montelet v. Murray, and in Hodgson v. Bowerbank, and in Sullivan v. the Fulton Steamboat Company. In Maxfield v. Levy, the question of jurisdiction arising from the character of the parties was discussed in the Circuit Court in Pennsylvania, and the court adverted severely upon an attempt to create a jurisdiction by fraud, contrary to the policy of the Constitution and the law. The suit was an ejectment between citizens of the same state to try title to land, and to give jurisdiction to the Circuit Court, a deed was given collusively and without any consideration to a citizen of another state for the sole purpose of making him a nominal plaintiff in order to give the federal court jurisdiction. The court dismissed the suit and observed that the Constitution and laws of the United States had been anxious to define by precise boundaries and preserve with great caution the line between the judicial authority of the Union and that of the individual states. No contrivance to defeat the law of the land and create jurisdiction by fraud could be tolerated. But if a citizen of one state thinks proper to change his domicile and remove with his family to another state, not colorably but permanently, and with a bona fide intention to reside there, even though his object was to avail himself of the jurisdiction of the federal courts, he becomes instantly a citizen of the other state and may sue as such in the courts of the United States. The doctrine in the original case of Bingham v. Cabot was again confirmed in Abercrombie v. Dupuy, with some symptoms of reluctance, and it would seem that the court was not entirely satisfied with the precise limits in which their jurisdiction had been circumscribed and embarrassed by their predecessors. But in Strawbridge v. Curtis, the limitation of the federal jurisdiction was considered as being still more close and precise. The Supreme Court declared that where the interest was joint and two or more persons were concerned in that interest as joint plaintiffs or joint defendants, each of them must be competent to sue or liable to be sued in the federal courts, and the suit was dismissed in that case, because some of the plaintiffs and defendants were citizens of the same state. The next case that arose on this subject was whether a corporation was a citizen within the meaning of the Constitution, and could sue in the federal courts in consequence of its legal character, and it was decided in the cases of the Hope Insurance Company v. Boardman and of the Bank of the United States v. Devereaux that a corporation aggregate was not in its corporate capacity a citizen, and that its right to litigate in the federal courts depended upon the character of the individuals who compose the body politic, and which character must appear by proper averments upon the record. But a corporation aggregate composed of citizens of one state may sue a citizen of another state in the Circuit Court of the United States. If any of the stockholders are citizens of the same state with a defendant, the federal courts have no jurisdiction. And the rule relative to suits originally instituted in the courts of the United States, requiring all the individuals composing the respective parties to possess the requisite character to give the court jurisdiction, applies equally to suits removed from the state courts. With respect to the question on the peculiar right of the Bank of the United States to sue in the federal courts, it was decided in reference to the First Bank of the United States that no right was conferred on that bank by its act of incorporation to sue in those courts. It had only the ordinary corporate capacity to sue and be sued, and being an invisible artificial being, a mere legal entity and not a citizen, its right to sue must depend upon the character of the individuals of which it is composed. The Constitution of the United States supposed apprehensions might exist that the tribunals of the states would not administer justice as impartially as those of the nation to parties of every description, and therefore it established national tribunals for the decision of controversies between aliens and a citizen, and between citizens of different states. The persons whom a corporation represents may be aliens or citizens, and the controversy is between persons suing by their corporate name for a corporate right and the individual dependent. Where the members of the corporation are aliens or citizens of a different state from the opposite party, they come within the reason and terms of the jurisdiction of the federal courts. The court can look beyond the corporate name and notice the character of the members who are not considered to every intent as placed out of view and merged in the corporation. Incorporated aliens may sue a citizen, or the incorporated citizens of one state may sue a citizen of another state in the federal courts by their corporate name, and the controversy is substantially between aliens and a citizen, or between the citizens of one state and those of another. In that case, the president, directors, and company of the Bank of the United States averred that they were citizens of Pennsylvania, and that the defendants were citizens of Georgia, and this averment, not traversed or denied, was sufficient to sustain the suit in the circuit court. In suits by the Bank of the United States of 1816, such an averment is not necessary because the act incorporating the bank authorizes it to sue and be sued in the circuit courts of the United States, as well as in the state courts. Without such an express provision, it would have been difficult for the Bank of the United States ever to have sued in the federal courts if the fact of citizenship of all the members was to be scrutinized, for there were probably few or no states which had not some stockholder of the bank a resident citizen. It was indispensable for Congress to have provided specially for a jurisdiction over suits in which the bank was concerned, or no jurisdiction could well have been sustained. It was truly observed by the Supreme Court that if the Bank of the United States could not sue a person who was a citizen of the same state with any one of its members in the circuit courts, this disability would defeat the power. A trustee who holds the legal interest is competent to sue in right of his own character as a citizen or alien, as the case may be, in the federal courts, and without reference to the character or domicile of his cestui qui trust, unless he was created trustee for the fraudulent purpose of giving jurisdiction. This rule equally applies to executors and administrators who are considered as the real parties in interest, but it does not apply to the case of a general assignee of an insolvent debtor, and he cannot sue in the federal courts if his assigner could not have sued there. The 11th section of the Judiciary Act will not permit jurisdiction to vest by the assignment of a chosen action, cases of foreign bills of exchanged accepted, unless the original holder was entitled to sue, and whether the assignment was made by the act of the party or by operations of the law makes no difference in the case. An executor or administrator is not an assignee within the meaning of the 11th section of the Judiciary Act. With respect to the District of Columbia and to the Territorial Districts of the United States, they are not states within the sense of the Constitution and of the Judiciary Act, so as to enable a citizen thereof to sue a citizen of one of the states in the federal courts. However extraordinary it might seem to be that the courts of the United States, which were open to aliens and to the citizens of every state, should be closed upon the inhabitants of those districts on the construction that they were not citizens of a state, yet, as the court observed, this was a subject for legislative and not for judicial consideration. If the jurisdiction of the circuit court between citizens of different states has once vested, it is not divested by a subsequent change of domicile of one of the parties, and his removal into the same state with the adverse party, prendente lite. The jurisdiction depends upon the state of things at the time the action is brought. So, an endorsee of a note who resides in one state may sue his immediate endorser who resides in another state, though that immediate endorser and the maker be residents of the same state. The endorsement is a new contract between the parties to the record, quite distinct from the original note. Jurisdiction where a state is interested and not a party on record. The case of Osborne versus the Bank of the United States brought into view important principles touching the constitutional jurisdiction of the federal courts, where a state claimed to be essentially a party. The court decided that the circuit courts had lawful jurisdiction under the Act of Congress incorporating the National Bank of a bill in equity brought by the bank for the purpose of protecting it in the exercise of its franchises, which were threatened to be invaded under a law of the state of Ohio. and that as the state itself could not be made a party defendant, the suit might be maintained against the officers and agents of the state who were entrusted with the execution of such laws. As the amendment to the Constitution prohibited a state to be made a party defendant by individuals of other states, the court felt the pressure and the difficulty of the objection that the state of Ohio was substantially a party defendant, inasmuch as the process of the court and the suit acted directly upon the state by restraining its officers from executing a law of the state. The direct interest of the state in the suit was admitted, but the objection, if it were valid, would go, in its consequences, completely to destroy the power of the Union. If the federal courts had no jurisdiction, then the agents of a state under an unconstitutional law of the state might arrest the execution of any law of the United States. A state might impose a fine or penalty on any person employed in the execution of any law of the Union and levy it by a ministerial officer without the sanction even of its own courts. All the various public officers of the United States, such as the carrier of the mail, the collector of the revenue, and the marshal of the district, might be inhibited under ruinous penalties from the performance of their respective duties. And if the courts of the United States cannot rightfully protect the agents who execute every law authorized by the Constitution from the direct action of state agents in the collection of penalties, they could not rightfully protect those who execute any law. The court insisted that there was no such deplorable failure of jurisdiction, and that the federal judiciary might rightfully protect those employed in carrying into execution the laws of the Union from the attempts of a particular state, by its agents, to resist the execution of those laws. It may use preventative proceedings by injunction or otherwise against the agents or officers of the state, and authorize proceedings against the very property seized by the agent. And the court concluded that a suit brought against individuals for any cause whatever was not a suit against a state in the sense of the Constitution. The Constitution contemplated a distinction between cases in which a state was interested and those in which it was a party, and to be a party for the purpose of jurisdiction it was necessary to be one upon record. The Constitution only intended a party on record, and to be shown in the first instance by the simple inspection of the record, and that is what it is intended in all cases where jurisdiction depends upon the party. The question of jurisdiction depending upon the character and residence of parties came again into discussion in the case of the Bank of the United States versus the Planters Bank of Georgia, and it was decided that the circuit courts had jurisdiction of suits brought by the Bank of the United States against a state bank, notwithstanding the state itself was a stockholder, together with private individuals who were citizens of the same state with some of the stockholders of the Bank of the United States. It was declared that the state of Georgia was not as a state to be deemed a party defendant, though interested as a stockholder in the defense. The state, so far as concerned that transaction, was divested of its sovereign character and took that of a private citizen, and this principle applies to every case in which the government becomes a partner in any trading company. We have seen how far the courts of the United States have a common law jurisdiction, and it appears to have been wholly disclaimed in criminal cases. And the true distinction would seem to be that all federal jurisdiction in civil and criminal cases must be derived from the Constitution and the laws made in pursuance of it, and that when the jurisdiction is vested, the principles of the common law are necessary to the due exercise of that jurisdiction. We have seen likewise with what caution and within what precise limits the federal courts have exercised jurisdiction in controversies between citizens and aliens, and between citizens of different states. In the next lecture, we shall enter upon a particular examination of the powers and claims of the federal courts relative to admiralty and maritime jurisdiction. End of section 27.
Section 28 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by ShrimpPhish. Commentaries on American Law, Volume 1, by James Kent. Of the District and Territorial Courts of the United States, Part 1. The district courts act as courts of common law and also as courts of admiralty. Admiralty jurisdiction of the district courts. A distinction is made in England between the instance and the prize court of admiralty. The former is the ordinary admiralty court, but the latter is a special and extraordinary jurisdiction, and although it be exercised by the same person, it is in no way connected with the former, either in its origin, its mode of proceeding, or the principles which govern it. To constitute the prize court, or to call it into action in time of war, a special commission issues, and the court proceeds summarily, and is governed by general principles of policy and the law of nations. This was the doctrine of the English Court of King's Bench, as declared by Lord Mansfield in Lindo v. Rodney. And though some parts of his learned and elaborate opinion in that case do not appear to be very clear and precise on the point concerning the difference in the foundation of the powers of the instance and of the prize court of admiralty, yet I should infer from it that the judge of the English admiralty requires a special commission, distinct from his ordinary commission, to enable him, in time of war, to assume the jurisdiction of prize. The practice continues to this day of issuing a special commission on the breaking out of hostilities to the commissioners for executing the office of Lord High Admiral, giving them jurisdiction in prize cases. The division of the Court of Admiralty into two courts is said not to have been generally known to the common lawyers of England before the case of Lindo v. Rodney, and yet it appears, from the research made in that case, that the prize jurisdiction was established from the earliest periods of the English judicial history. The instance court is the ordinary and appropriate court of admiralty, and takes cognizance of the general subjects of admiralty jurisdiction, and it proceeds according to the civil and maritime law. The prize court has exclusive cognizance of matters of prize and matters incidental thereto, and it proceeds to hear and determine according to the course of the admiralty and the law of nations. The distinction between these two courts, or rather between these two departments of the same court, is kept up throughout all the proceedings, and the appeals from the decrees of these two jurisdictions are distinct, and made to separate tribunals. The appeal from the instance court lies to delegates, but from the prize court it lies to the Lords Commissioners of Appeals in prize causes, and who are appointed for that special purpose. Such is the distinction in England between the instance and the prize court of admiralty, and in the case of Ex parte Lynch, it was held that the jurisdiction of the admiralty as a prize court did not cease with the war, but extended to all the incidents of prize, and to an indefinite period after the war. It remains to see how far that distinction is known or preserved in the jurisdiction of our district courts. It is said by a judge who must have been well acquainted with this subject, for he was a registrar of a colonial court of admiralty before our Revolution, that this distinction between the instance and the prize court was not known to our admiralty proceedings under the colony administrations. In the case of Jennings v. Carson, the District Court of Pennsylvania, in 1792, decided that prize jurisdiction was involved in the general delegation of admiralty and maritime powers, and that Congress, by the Judiciary Act of 1789, meant to convey to the district courts all the powers appertaining to admiralty and maritime jurisdiction, including that of prize. Prize jurisdiction was inherent in a court of admiralty, though it was of course a dormant power until called into activity by the occurrence of war. District courts are equally instance and prize courts. But notwithstanding this early decision in favor of the plenary jurisdiction of the district courts as courts of admiralty, there was great doubt entertained in this country about the year 1793, whether the district courts had jurisdiction under the Act of Congress of 1789 as prize courts. The District Court of Maryland decided against the jurisdiction, and that decree was affirmed on appeal to the Circuit Court on the ground that a prize cause was not a civil cause of admiralty jurisdiction, but rested on the jus belli, and that there was no prize court in existence in the United States. The same question was carried up to the Supreme Court of the United States in February 1794, in the case of Glass versus the sloop Betsy, and was ably discussed. The Supreme Court put an end at once to all these difficulties about jurisdiction by declaring that the district courts of the United States possessed all the powers of courts of admiralty, whether considered as instance or as prize courts. In the case of the emulous, the Circuit Court in Massachusetts was inclined to think that the admiralty, from time immemorial, had an inherent jurisdiction in prize, because, if we examine the most venerable relics of ancient maritime jurisprudence, we shall find the admiralty in possession of prize jurisdiction, independent of any known special commission. It seems to have always constituted an ordinary and not an extraordinary branch of the admiralty powers, and it is to be observed that Lord Mansfield leaves the point uncertain, whether the prize and the instance jurisdictions were coeval in antiquity, or whether the former was constituted by special commission. Be that as it may, the equal jurisdiction of the admiralty in this country, as an instance and as a prize court, is now definitively settled, and if the prize branch of the jurisdiction of the admiralty be not known in time of peace, it is merely because its powers lie dormant, from the want of business to call them into action. There is no pretense of claim on the part of courts of common law to any share in the prize jurisdiction of the courts of admiralty. It is necessary and completely exclusive, and we will first take a view of the jurisdiction and powers of the district courts in prize cases, and then of their ordinary admiralty jurisdiction. As prize questions are applicable to a state of war, and are governed chiefly by the rules of the law of nations, and the usages and practices of the maritime powers, I do not propose to enlarge on that subject. My object will be to ascertain the exact jurisdiction of the district court in all its various powers and complicated character. I shall consider 1. Its character as a prize court. 2. As a court of criminal jurisdiction in admiralty. 3. The division line between the admiralty and the courts of common law. 4. Its powers as an instance court of admiralty. 5. Its jurisdiction as a court of common law, and clothed also with special powers. Prize courts. 1. Jurisdiction of the prize courts. The ordinary prize jurisdiction of the admiralty extends to all captures in war, made on the high seas. I know of no other definition of prize goods, said Sir William Scott in the case of the two friends, than that they are goods taken on the high seas, jus belli, out of the hands of the enemy. The prize jurisdiction also extends to captures in foreign ports and harbors, and to captures made on land by naval forces, and upon surrenders to naval forces, either solely or by joint operation with land forces. It extends to captures made in rivers, ports, and harbors of the captor's own country. But as to plunder or booty in a mere continental land war, without the presence or intervention of any ships or their crews, Lord Mansfield admitted, in Lindo v. Rodney, there was no case, or authority, or principle to enable him to bring it within the cognizance of a prize court. The prize court extends also to all ransom bills upon captures at sea, and to money received as a ransom, or a commutation, on a capitulation to naval forces alone, or jointly with land forces. The federal courts have asserted for the prize courts in this country a jurisdiction equally as ample and extensive as any claimed for them in England, In the case of the emulous, though the court gave no opinion as to the right of the Admiralty to take cognizance of mere captures made on the land exclusively by land forces, yet it was declared to be very clear that its jurisdiction was not confined to captures at sea. It took cognizance of all captures in creeks, havens, and rivers, and also of all captures made on land, where the same had been made by a naval force, or by cooperation with a naval force. And this exercise of jurisdiction was settled by the most solemn adjudications. A seizure may therefore be made in port in our own country as a prize, if made while the property was water-borne. Had it been landed and remained on land, it would have deserved consideration, and no opinion was given whether it could have been proceeded against as prize under the Admiralty jurisdiction, or whether, if liable to seizure and condemnation in our courts, the remedy ought not to have been pursued by a process applicable to municipal confiscations. It is understood in England that the Admiralty, merely by its own inherent powers, never exercises jurisdiction as to captures or seizures as prize made on shore, without the cooperation of naval forces. In the case of the Ooster Eames, cited by Sir William Scott in the case of the Two Friends, and decided by the highest authority, that of the Lords Commissioners of Appeal in 1784, it was held that goods taken on shore as prize, where there had been no act of capture on the high seas, were not to be considered as prize, and that the prize courts had no jurisdiction in such a case. But it is admitted that if the jurisdiction has once attached, and the goods have been taken at sea, they may be followed on shore by the process of the prize court, and its jurisdiction over them still continues. In this respect, the prize court seems more extensive, and to hold a firmer jurisdiction than the instance court, for as to cases of wreck and derelict, if the goods are once on shore, or landed, the cognizance of the common law attaches. Though the prize be unwarrantably carried into a foreign port, and there delivered by the captors upon security, the prize court does not lose its jurisdiction over the capture, in the questions incident to it. So if the prize be lost at sea, the court may, notwithstanding, proceed to adjudication, and at the instance of the captors or the claimants. It has jurisdiction likewise, though the prize be actually lying within a foreign neutral territory. This is the settled law of the prize jurisdiction, both in England and in this country. The principle is that the possession of the captor, though in a neutral country, is considered to be possession of his sovereign and sub potestate curiae. But it is admitted that if possession of the thing seized be actually as well as constructively lost, as by recapture, escape, or voluntary discharge of the captured vessel, the jurisdiction of the prize court over the subject is lost. Though captured property be unjustifiably or illegally converted by the captors, the jurisdiction of the prize court over the case continues. But it rests in the sound discretion of the court, whether it will interfere in favor of the captors in such cases, and it is equally discretionary in all cases where the disposition of the captured vessel and crew has not been according to duty. The prize court may always proceed in rem whenever the prize, or the proceeds of the prize, can be traced to the hands of any person whatever, and this it may do, notwithstanding any stipulation in the nature of bail had been taken for the property. And it is a principle perfectly well settled, and constantly conceded and applied, that prize courts have exclusive jurisdiction and an enlarged discretion as to the allowance of freight, damages, expenses, and costs. In all cases of captures, and as to all torts, and personal injuries, and ill treatments, and abuse of power connected with captures, jure belli, and the courts will frequently award large and liberal damages in those cases. The prize courts may apply confiscation by way of penalty for fraud and misconduct in respect to property captured as prize and claimed by citizens or neutrals. They may decree a forfeiture of the rights or prize against captors guilty of gross irregularity or fraud or any criminal conduct, and in such cases the property is condemned to the government generally. Admiralty jurisdiction of the district courts in criminal matters. 2. Criminal jurisdiction of the Admiralty. The ordinary Admiralty and maritime jurisdiction, exclusive of prize cases, embraces all civil and criminal cases of a maritime nature, and though there does not seem to be any difficulty or doubt as to the proper jurisdiction of the prize courts, there is a great deal of unsettled discussion respecting the civil and criminal jurisdiction of the district court as an instance court, and possessing, under the Constitution and Judiciary Act of 1789, admiralty and maritime jurisdiction. The Act of Congress gives to the district courts, exclusive of the state courts, and concurrently with the circuit courts, cognizance of all crimes and offenses cognizable under the authority of the United States, and committed within their districts, or upon the high seas, where only a moderate corporal punishment, or fine, or imprisonment, is to be inflicted. This is the ground of the criminal jurisdiction of the district courts, and it is given to them as district courts. And as it includes the minor crimes and offenses committed on the high seas, and cognizable in the courts of admiralty under the English law, the district courts may be considered as exercising the criminal jurisdiction of a court of admiralty in those cases. The Constitution of the United States declares that the judicial power of the Union shall extend to all cases of admiralty and maritime jurisdiction, and it has been supposed that the federal courts might, without any statute, and under this general delegation of admiralty powers, have exercised criminal jurisdiction over maritime crimes and offenses. But the courts of the United States have been reluctant to assume the exercise of any criminal jurisdiction in admiralty cases, which was not specially conferred by an act of Congress. In the case of the United States versus McGill, the defendant was indicted and tried in the circuit court in Philadelphia for murder committed on the high seas, and the jurisdiction of the court was much discussed. One of the judges observed that he had often decided that the federal courts had a common law jurisdiction in criminal cases, but he considered that the crime charged, a mortal stroke having been given on the high seas, and the death in consequence of it happening on land, was not a case of admiralty and maritime jurisdiction within the meaning of the Constitution or of the English admiralty law, and the prisoner, on account of this defect of jurisdiction, was acquitted. The other judge of the court gave no opinion whether that case was one of admiralty and maritime jurisdiction upon the general principles of the admiralty and maritime law, and he confined himself to the 8th section of the Penal Act of Congress of April 30th, 1790, Chapter 9, and the case charged was not, by that act, within the jurisdiction of the circuit court. Afterwards, in the case of the United States versus Bevins, the Supreme Court, on a case certified from the Massachusetts Circuit, decided that, even admitting that the United States had exclusive jurisdiction of all cases of admiralty and maritime jurisdiction, and admitting that a murder committed on the waters of a state where the tide ebbs and flows was a case of admiralty and maritime jurisdiction, yet that Congress had not, by the 8th section of the Act of 1790, Chapter 9, for the punishment of certain crimes against the United States, conferred on the courts of the United States jurisdiction over such murder. The act confirmed the federal jurisdiction to murder and other crimes, and offenses committed on the high seas or in any river, harbor, basin, or bay, out of the jurisdiction of any particular state, and the murder in question was committed on board of a ship of war of the United States in Boston Harbor, and within the jurisdiction of Massachusetts. There was no doubt of the competency of the powers of Congress to confer such a jurisdiction in the case of a crime committed on board of a ship of war of the United States, wherever the ship might be. But no such power had, to that extent, been as yet exercised by Congress, and it must have followed, of course, in that case, that the state courts had jurisdiction of the crime at common law, for it was committed within the territory of the state. It was admitted to be a clear point that the state courts had cognizance of crimes and offenses committed upon tide waters, in the bays and harbors within their respective territorial jurisdictions. And in the case of the United States versus Wiltberger, it was decided that the courts of the United States had no jurisdiction of the crime of manslaughter committed by the master upon one of the seamen on board a merchant vessel of the United States, lying at anchor in the river Tigris within the Empire of China, because the Act of Congress of the 30th of April, 1790, Chapter 9, Section 12, did not reach such a case, and was confined to the crime committed on the high seas. Upon the principle of that decision, the offender could not be judicially punished, except by the Chinese government, and it was said, upon the argument of the case, that China disclaimed the jurisdiction. The law was defective upon this point, and a remedy was provided by the Act of Congress of 3rd March, 1825, Chapter 67, Section 5, which declared that if any offense shall be committed on board of any vessel belonging to a citizen of the United States while lying in a foreign port or place by any one of the crew or a passenger on any other person belonging to the ship, or on any other passenger, the offense shall be cognizable in the circuit courts of the United States, equally as if it had been committed on board of such vessel on the high seas, provided that if the offender shall be tried and acquitted or convicted in the foreign state, he shall not be subject to another trial here. The Act provided also for the punishment of many other crimes against the United States committed upon the high seas, or in any arm of the sea, or in any river, haven, creek, basin, or bay within the admiralty jurisdiction of the United States. But the crimes in any river, bay, etc., to be cognizable, must be committed out of the jurisdiction of any particular state, except it be conspiracies to defraud insurers, and it further provided that the act was not to deprive the state courts of jurisdiction over the same offenses. As the state courts have jurisdiction of offenses committed within arms of the sea, creeks, havens, basins, and bays, within the ebb and flow of the tide, and within the body of a county, the jurisdiction of the circuit courts of the United States was not extended by the statute to those cases. It appears from these cases, and though the general cognizance of all these cases of admiralty and maritime jurisdiction, as given by the Constitution, extends equally to the criminal and civil jurisdiction of the admiralty, as known to the English and maritime law when the Constitution was adopted. Yet that, without a particular legislative provision in the case, the federal courts do not exercise criminal jurisdiction as courts of admiralty over maritime offenses. In the case of the United States versus Coolidge, it was insisted that the Admiralty was a court of extensive criminal jurisdiction, and that offenses of Admiralty jurisdiction were exclusively cognizable by the United States, and that a marine tort on the high seas, as, for instance, the forcible rescue of a prize, was punishable by the Admiralty, in the absence of positive law, by fine and imprisonment. The decision of the Supreme Court was otherwise, and it seems now to be settled that the federal courts, as courts of admiralty, are to exercise such criminal jurisdiction as is conferred upon them expressly by acts of Congress, and that they are not to exercise any other. This limitation does not, however, apply to private prosecutions in the district court, as a court of admiralty or prize court, to recover damages for a marine tort. Such cases are cognizable in the Admiralty by virtue of its general Admiralty jurisdiction, and so it was held in the case of the amiable Nancy. The civil jurisdiction of the English Admiralty is according to the forms of the civil law, and before a single judge, but the criminal jurisdiction, in which all maritime felonies are tried, is in the Court of Admiralty Sessions, before commissioners of Oyer and Terminer, being the judge of the Court of Admiralty and 3 or 4 associates. It has cognizance of all crimes and offences committed at sea or on the coasts, out of the body of a county, and in that court the proceedings are by indictment and trial by jury, according to the course of the common law. The criminal jurisdiction of the English Admiralty received its present modification by the Act of 28, Henry VIII, c. 15, but it had a very extensive criminal jurisdiction, coeval with the first existence of the court. It proceeded by indictment and petit jury, before and independent of the statute of Henry VIII, and all criminal offences cognizable by the Admiralty, and not otherwise provided for by positive law, are punishable by fine and imprisonment. The better opinion, however, is that the ancient common law, or primitive criminal jurisdiction of the English Admiralty, has become obsolete, and has not been in exercise for the last 100 years, and that no offence of a criminal nature can be tried there which does not fall within the jurisdiction specially conferred by the statute of Henry VIII. There is, therefore, a very strong precedent for the doctrine of the Supreme Court of the United States, which refuses to the federal courts any criminal jurisdiction in admiralty cases, not derived from statute. And to whatever extent the criminal jurisdiction of the Admiralty may extend, the Judiciary Act of 1789 provides that the trial of all issues, in fact, in the district courts, in all causes except civil causes of admiralty and maritime jurisdiction, shall be by jury. End of section 28.
Section 29 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of the District and Territorial Courts of the United States, Part 2. Limits of Admiralty Jurisdiction. 3. Division line between the jurisdiction of the Admiralty and of courts of common law. There has existed a very contested question of ancient standing touching the proper division or boundary line between the jurisdiction of the courts of common law and the courts of admiralty. The admiralty jurisdiction in England originally extended to all crimes and offences committed upon the sea, and in all ports, rivers, and arms of the sea as far as the tide ebbed and flowed. Lord Coke's doctrine was A, that the sea did not include any navigable waters within the body of a county, and Sir Matthew Hale supposed, B, that prior to the statute of 35th Edward III, the common law and the Admiralty exercised jurisdiction concurrently in the narrow seas and in ports and havens within the ebb and flow of the tide. Under the statutes of 13R2 C5 and 15R2 C3, excluding the Admiralty jurisdiction in cases arising upon land or water within the body of a county, except in cases of murder and mayhem, there have been long and vexatious contentions between the Admiralty and the common law courts. On the seashore, the common law jurisdiction is bounded by low water mark, and between high and low water mark, where the sea ebbs and flows, the common law and the Admiralty have a divided or alternate jurisdiction. With respect to the Admiralty jurisdiction over arms of the sea and bays and navigable rivers, where the tide ebbs and flows, there has been great difference of opinion and great litigation in the progress of the English jurisprudence. On the part of Admiralty, it has been insisted that the Admiralty continued to possess jurisdiction in all ports, havens, and navigable rivers, where the sea ebbs and flows below the first bridges. This seemed also to be the opinion of 10 of the judges at Westminster, on a reference to them in 1713. On the part of the common law courts, it has been contended that the bodies of counties comprehended all navigable rivers, creeks, ports, harbors, and arms of the sea, which are so narrow as to permit a person to discern, and attest upon oath anything done on the other shore, and so as to enable an inquisition of facts to be taken. In the case of Bruce in 1812, all the judges agreed that the common law and the Admiralty had a concurrent jurisdiction in bays, havens, creeks, etc., where ships of war floated. The high seas means the waters of the ocean without the boundary of any county, and they are within the exclusive jurisdiction of the Admiralty up to the high water mark when the tide is full. The open ocean, which washes the sea-coast, is used in contradistinction to arms of the sea enclosed within the fosses terrae, or narrow headlands, and promontories. And under this head is included rivers, harbors, creeks, basins, bays, etc., where the tide ebbs and flows. They are within the Admiralty and Maritime jurisdiction of the United States. But if they are within the body of a county of any particular state, the state jurisdiction attaches. The extent of the jurisdiction of the district courts as courts of admiralty and maritime jurisdiction was very fully examined, and with great ability and research by the Circuit Court of the United States for Massachusetts. In the case of Delovio v. Boyd, it was maintained that in very early periods the admiralty jurisdiction in civil cases extended to all maritime causes and contracts, and in criminal cases to all torts and offenses, as well in ports and havens within the ebb and flow of the tide, as upon the high seas. And that the English Admiralty was formed upon the same common model, and was coextensive in point of jurisdiction with the maritime courts of the other commercial powers of Europe. It was shown by an exposition of the ancient cases that Lord Coke was mistaken in his attempt to confine the ancient jurisdiction of the Admiralty to the high seas, and to exclude it from the narrow tide waters, and from ports and havens. The court agreed with the Admiralty civilians that the statutes of 13R2 and 15R2 and 2H4 did not curtail this ancient and original jurisdiction of the Admiralty, and that, consistently with those statutes, the Admiralty might exercise jurisdiction over torts and injuries upon the high seas, and in ports within the ebb and flow of the tide, and in great streams below the first bridges, and also over all maritime contracts, as well as over matters of prize and its incidents. It appeared from a historical review of the progress of the controversy for jurisdiction, which lasted for 2 centuries, between the Admiralty and the courts of common law, that the latter, by a silent and steady march, gained ground and extended their limits, until they acquired concurrent jurisdiction over all maritime causes, except prize causes within the cognizance of the Admiralty. The common law doctrine was that the sea, ex vi termini, was without the body of any county, but that all ports and havens and all navigable tide waters, where one might see from one land to the other what was doing, were within the body of the county, and under the exclusive jurisdiction of the common law courts. On the seashore or coast, high and low water mark determined what was parcel of the sea and what was the line of division between the Admiralty and the courts of law. And it was held that it ought to be so considered by parity of reason where the tide ebbs and flows in ports and havens, and that the Admiralty jurisdiction extends to all tide waters in ports and havens and rivers beneath the first bridges. It was admitted, however, that the common law originally had jurisdiction on the high seas, concurrent with the Admiralty, and that in cases manifestly within the Admiralty jurisdiction, both civil and criminal, the common law now claimed concurrent jurisdiction. The result of the examination in that case was that the jurisdiction of the Admiralty under the statutes of Richard II extended to all maritime contracts and to all torts, injuries, and offenses on the high seas, and in ports and havens, as far as the ebb and flow of the tide, that the common law interpretation of those statutes abridged this jurisdiction to things wholly and exclusively done upon the sea, but that the interpretation was indefensible upon principle, and the decisions founded upon it inconsistent, that the Admiralty interpretation of those statutes did not abridge any of its ancient jurisdiction, and that interpretation was consistent with the language and intent of the statutes and analogous reasoning and public convenience. It was considered that the decisions at common law on this subject were not entitled to outweigh the decisions of the great civilians of the Admiralty. The vice-admiralty courts in this country under the colonial governments exercised a most ample jurisdiction to the extent now claimed over all maritime contracts, and over torts and injuries as well as in ports, as upon the high seas. And the Constitution of the United States, when it conferred not only admiralty but maritime jurisdiction, added that word ex industria to remove every latent doubt. This large and liberal construction of the admiralty powers of the district courts and their extension to all maritime contracts, torts, and injuries was recommended by the general equity and simplicity of admiralty proceedings and the policy and wisdom of that code of maritime law, which had embodied the enlightened reason of the civil law and the customs and usage of the maritime nations, and regulates by its decisions the commercial intercourse of mankind. This enlarged extension of the civil jurisdiction of the Admiralty, as declared in the Circuit Court of Massachusetts, remains to be discussed and definitively settled in the Supreme Court. It has been subsequently and frequently asserted in the Circuit and District Courts. Thus, in Plummer v. Webb, the jurisdiction of the Admiralty over all maritime contracts upon the doctrine of the case of Delovio v. Boit was declared, and it was considered that inasmuch as courts of admiralty act as courts of equity and administer justice upon the same principles and with equal safety, maritime contracts were suitable objects of such a jurisdiction, and especially as such contracts require a liberal interpretation, an enlarged good faith, and the application of a comprehensive equity. So, in Steele v. Thatcher, and in Drinkwater v. the Brig Spartan, in the District Court for Maine, the doctrine in Delovio v. Boit was explicitly recognized as sound. It was declared to have been before the public for 12 years without having its reasoning met or its conclusions shaken, and it was adjudged that the Admiralty had a general jurisdiction over maritime contracts. And the circumstance that the contract was under seal did not affect the jurisdiction, though it admitted that in England the courts of law would grant a prohibition in such a case. The broad jurisdiction of the American courts of admiralty over all executed maritime contracts, for the jurisdiction is confined to executed contracts, and all cases of a maritime nature has been equally asserted in the circuit courts of the United States at New York and Philadelphia, founded on the language of the Constitution and the Judiciary Act of 1789. This enlarged admiralty cognizance of civil causes was elaborately vindicated on principles of reason, as well as on the ground of authority in the case of the schooner Tilton. It was there held that the Admiralty had jurisdiction of all causes of a maritime nature, inclusive of questions of prize, whether they arose from contracts or from torts. The jurisdiction was clear in all matters that concerned owners and proprietors of ships as such. It was observed that suits in the Admiralty touching property and ships were either petitory suits, in which the mere title to the property is litigated and sought to be enforced, or they were possessory suits, to restore to the owner the possession which he had under a claim of title. The jurisdiction over both classes of cases was exercised by the Admiralty until some time after the Restoration in 1660, when the courts of law interfered and claimed the exclusive cognizance of mere questions of title, and the Admiralty jurisdiction over petitory suits has been, in England, abandoned for a considerable length of time, though it is constantly upheld as to possessory suits. The distinction does not appear to rest on any sound principle, for the question of title is necessarily involved in that of the possession, and it is admitted by the courts of law that the Admiralty possesses authority to decree restitution of a ship unlawfully withheld by a wrongdoer from the real owner. In the cases of illegal captures and of bottomry, salvage, and marine torts, the Admiralty courts in this country inquire into and decide on the rights and titles involved in the controversy, and where they have jurisdiction of the principal matter, it is suitable and according to the analogies of law that they should possess it over the incidents. Notwithstanding the English practice to the contrary, the Admiralty in this country claim to possess a rightful jurisdiction equally over petitory and possessory suits. With respect to the criminal jurisdiction of the Admiralty, we have already seen that the courts of the United States do not assume any jurisdiction which is not expressly conferred by an act of Congress, and the argument for the extension of the civil jurisdiction of the Admiralty beyond the limits known and established in the English law at the time of the formation of our Constitution is not free from very great difficulty. It has been made a question what were cases of admiralty and maritime jurisdiction within the meaning of the Constitution of the United States. It is not in the power of Congress to enlarge that jurisdiction beyond what was understood and intended by it when the Constitution was adopted, because it would be depriving the suitor of the right of trial by jury, which is secured to him by the Constitution in suits at common law. and is well known that in civil suits of admiralty and maritime jurisdiction, the proceedings are according to the course of the civil law and without jury. If the admiralty and maritime jurisdiction of the district courts embraces all maritime contracts, then suits upon policies of insurance, charter parties, marine hypothecations, contracts for building, repairing, supplying, and navigating ships, and contracts between part owners of ships must be tried in the admiralty by a single judge to the exclusion of the trial by jury, and the state courts would be divested at one stroke of a vast field of commercial jurisdiction. The words of the Judiciary Act of 1789, Section 9, are that the district courts shall have exclusive original cognizance of all civil causes of admiralty and maritime jurisdiction, including all seizures under laws of impost, navigation, or trade of the United States, where the seizures are made on waters which are navigable from the sea by vessels of 10 or more tons, burthen within their respective districts as well as upon the high seas. But the Act adds by way of qualification to this designation of admiralty jurisdiction these words, viz., saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. The Act of Congress is rather ambiguous in its meaning and leaves it uncertain whether it meant to consider seizures on tide waters, in ports, harbors, creeks, and arms of the sea as cases of admiralty and maritime jurisdiction, or as cases simply within the cognizance of the district courts. For the expression is including, that is, comprehending, either within the cognizance of the court, or within the class of cases of admiralty jurisdictions, all seizures under laws of impost, navigation, and trade on waters navigable from the sea by small vessels of 10 tons burthen. This act has, however, been construed to put a construction upon the words admiralty and maritime jurisdiction conformable to the claims of the civilians and in opposition to the claims of the common law tribunals, and there is a series of decisions in the Supreme Court of the United States to that effect. In the case of the United States versus La Vengeance, a French privateer was libeled in the District Court of New York for an attempt to export arms from the United States to a foreign country contrary to law. She was adjudged to be forfeited to the United States. The decree on appeal to the Circuit Court was reversed. On a further appeal to the Supreme Court of the United States, it was contended that this was a criminal case both on account of the manner of prosecution and the matter charged, and therefore that the decree of the District Court was final, and that it ought likewise to have been tried by a jury in the District Court, and that if it was even a civil suit, it was not a case of admiralty and maritime jurisdiction. To render it such, the cause must arise wholly upon the sea, and not in a bay, harbor, or water, within the precincts of any county of a state. But the Supreme Court decided that it was a civil suit not of common law, but of admiralty and maritime jurisdiction. The seizure was on the waters of the United States. The process was in rem and did not in any decree touch the person, and no jury was necessary. Afterwards, in the case of the United States versus the schooner Sally, the vessel was libeled in the District Court as forfeited for being concerned in the slave trade, and this was also held on appeal to be a case not of common law but of admiralty jurisdiction. So, in the case of the United States versus the schooner Betsy, it was held that all seizures under the Act of Congress suspending commercial intercourse with a foreign country and made on waters navigable from sea by vessels of 10 tons burthen were civil causes of admiralty jurisdiction, being proceedings in rem and not according to the course of the common law, and were to be tried without a jury. The court said that the place of seizure being on navigable waters decided the jurisdiction, and that the Act of Congress meant to make seizures on waters navigable from the sea civil causes of admiralty and maritime jurisdiction. In this last case, the counsel for the claimant contended that the seizure was made within the body of a county for a breach of a municipal law of trade, and that though it belonged to the jurisdiction of the district court, it was not a case of admiralty cognizance. All seizures in England for a violation of the laws of revenue, trade, or navigation were tried by a jury in the Court of Exchequer according to the course of the common law. And though a proceeding be in rem, it is not necessarily a proceeding or cause in the admiralty. In the case of the Samuel, where the vessel and cargo were seized and libeled and condemned in the District Court of Rhode Island for a breach of the non-importation laws of the United States, the same objection was made upon appeal to the Supreme Court, and it was again overruled on the authority of the preceding cases. The same objection was taken in the case of the Octavia, and it was contended that the word including in the 9th section of the Judiciary Act ought not to be construed cumulatively, and that a suit might be a cause of admiralty and maritime jurisdiction, and yet triable under the common law, proceeding by information instead of the civil law process by libel. The objection was again overruled. The last case that brought up the same point for review and discussion was the Sarah, and the Supreme Court there recognized the marked and subtle distinction between the common law and the admiralty jurisdictions of the district courts. In seizures made on land, the district court proceeds as a court of common law, according to the course of the English Exchequer, on information in rem, and the trial of issues of fact is to be by jury. But in cases of seizures on water navigable from the sea by vessels of 10 or more tons burthen, the court proceeds as an instance court of admiralty by libel in rem, and the trial is by the court. It may now be considered as the settled law of this country that all seizures under laws of impost navigation and trade, if made upon tide waters navigable from the sea, are civil cases of admiralty jurisdiction, and the successive judgments of the Supreme Court upon this point are founded upon the Judiciary Act of 1789. If the Act of Congress declares them to be cases of admiralty jurisdiction, it is apprehended that this is an extension of admiralty powers beyond the English practice. Cases of forfeiture for breaches of revenue law are cognizable in England in the Exchequer upon information, though the seizure was made upon navigable waters, and they proceed there to try the fact on which the forfeiture arises by jury. Informations are filed in the Court of Exchequer for forfeiture upon seizure of property, for breach of laws of revenue, impost, navigation, and trade. In the case of the Attorney General v. Jackson, the seizure was of a vessel lying in port at Cowes, for breach of the Act of Navigation, and the proceeding was by information and trial by jury, according to the course of the common law. Lord Hale said that informations of that nature lay exclusively in the Exchequer. Congress had a right in their discretion to make all such seizures and forfeitures cognizable in the district courts, but it may be a question whether they had any right to declare them to be cases of admiralty jurisdiction, if they were not so by the law of the land when the Constitution was made. The Constitution secures to the citizen trial by jury in all criminal prosecutions and in all civil suits at common law, where the value in controversy exceeds $20. These prosecutions for forfeitures of large and valuable portions of property under revenue and navigation laws are highly penal in their consequences, and the government and its officers are always parties and deeply concerned in the conviction and forfeiture. And if, by the act of Congress, or if by judicial decisions, the prosecution can be turned over to the admiralty side of the district court as being neither a criminal prosecution nor a suit at common law, the trial of the case is then transferred from a jury of the country to the breast of a single judge. It is probable, however, that the Judiciary Act of 1789 did not intend to do more than declare the jurisdiction of the district courts over these cases, and that all prosecutions for penalties and forfeitures upon seizures under laws of impost, navigation, and trade were not to be considered of admiralty jurisdiction when the case admitted of a prosecution at common law, for the Act saves to suitors in all cases the right of a common law remedy where the common law was competent to give it. We have seen that it is the competent to give it because under the vigorous system of the English law, such persecutions in rem are in the Exchequer according to the course of the common law, and it may be doubted whether the case of the La Vengeance, on which all the subsequent decisions of the Supreme Court have rested, was sufficiently considered. There is, however, much colonial precedent for this extension of admiralty jurisdiction. The vice-admiralty courts in this country, when we were colonies, and also in the West Indies, obtained jurisdiction in revenue causes, to an extent, totally unknown to the jurisdiction of the English admiralty, and with powers quite as enlarged as those claimed at the present day. But this extension by statute of the jurisdiction of the American vice-admiralty courts beyond their ancient limits to revenue cases and penalties was much discussed and complained of on the part of this country at the commencement of the Revolution. Whatever admiralty and maritime jurisdiction the district courts possess would seem to be exclusive, for the Constitution declares that the judicial power of the United States shall extend to all cases of admiralty and maritime jurisdiction, and the Act of Congress of 1789 says that the district courts shall have exclusive original cognizance of all civil causes of admiralty and maritime jurisdiction. It is certain, however, that the state courts take an extensive and unquestioned cognizance of maritime contracts, and on the ground that they are not cases, strictly and technically speaking, of admiralty and maritime jurisdiction. It is certain, however, that the state courts take an extensive and unquestioned cognizance of maritime contracts, and on the ground that they are not cases, strictly and technically speaking, of admiralty and maritime jurisdiction. If, however, the claim of the district courts be well-founded to the cognizance of all maritime contracts, wheresoever the same may be made, or whatever may be the form of the contract, it would seem that the jurisdiction of the state courts over those contracts could not be sustained. But I apprehend it may fairly be doubted whether the Constitution of the United States meant by admiralty and maritime jurisdiction anything more than that jurisdiction which was settled in practice in this country under the English jurisprudence when the Constitution was made, and whether it had any retrospective or historical reference to the usages and practice of the Admiralty as it once existed in the Middle Ages before its territories had been invaded and partly subdued by the bold and free spirit of the courts of common law, armed with the protecting genius and masculine vigor of trial by jury. End of section 29.
Section 30 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1 by James Kent, of the District and Territorial Courts of the United States, Part 3, Jurisdiction of the Instance Courts. The extensive and superior claims of the American Courts of Admiralty as courts of civil maritime jurisdiction we have had occasion already to consider, but according to the English jurisprudence, the instance court takes cognizance only of things done and contracts not under seal made super altum mare and without the body of any county. This, of course, excludes all creeks, bays, and rivers which are within the body of some county, and if the place be the sea-coast, then the ebbing and flowing of the tide determines the admiralty. The cause must arise wholly upon the sea, and not within the precincts of any county, to give the admiralty jurisdiction. If the action be founded on a matter done partly on land and partly on water, as if a contract be made on land to be executed at sea, or be made at sea to be executed on land, the common law has the preference and excludes the admiralty. Footnote: in cases purely dependent upon the locality of the act done, the admiralty jurisdiction is limited to the sea and to tidewater as far as the tide flows. But in mixed cases, as where salvage services are performed partly on tidewaters and partly on shore for the preservation of the property, the admiralty has jurisdiction. United States v. Coombs, 12 Peters 72, in Peyreux v. Howard, the Supreme Court decided that New Orleans was within the ebb and flow of the tide, and that admiralty jurisdictions prevailed there, and that repairs done there by a shipwright upon a steamboat was essentially a maritime service, and gave a lien, notwithstanding the commencement of termination of the voyage of the steamboat might be at some place up the Mississippi, beyond the reach of the tide. It was held in Smith v. the Pekin, Gilpin 203, that a contract for wages on a voyage between ports of adjoining states and on the tidewaters of a river or bay is within the jurisdiction of the district courts, and may be enforced by a suit in rem in the admiralty. But if a vessel be engaged substantially in interior navigation and trade, not on tidewaters, the admiralty has no jurisdiction, though she may have touched at one terminus of the voyage on tidewaters. The steamboat Orleans v. Phoebus, 11 Peters 175. End of footnote. The Admiralty has cognizance of maritime hypothecations of vessels and goods in foreign ports, for repairs done or necessary supplies furnished. Footnote: Johnson v. Shippen, It seems to be also not only the better opinion, but the settled law that the Admiralty has jurisdiction in rem in the case of bottomry bonds creating a lien on a vessel, whether the bond was executed by the owner in a foreign or in a home port. Whenever the local law gives a lien on the vessel as a security, or there is an express hypothecation, the Admiralty has jurisdiction in rem to enforce it. End of footnote. And in the case of Menatoni versus Gibbons, it was admitted by the KB that the Admiralty had entire jurisdiction in the case of a hypothecation bond, charging a ship with money taken up in a foreign port for necessaries, though the bond was under seal and executed on land. The jurisdiction in such a case depended on the subject matter, for the contract was merely in rem, and there was no personal covenant for the payment of the money, and the Admiralty jurisdiction in such a case was indispensable, as the courts of common law do not proceed in rem. Footnote. In the case of the Atlas, it was admitted that the Court of Admiralty had an undoubted jurisdiction over bottomry bonds founded upon sea risks, and defeasible by the destruction of the ship in the course of the voyage. It was an original jurisdiction exercised upon the ground of authorized usage and established authority, but the jurisdiction would not attach upon any bond not dependent upon the accidents of the voyage. End of footnote. If the Admiralty has cognizance of the principal thing, it has also of the incident, though that incident would not of itself, and if it stood for a principal thing, be within the Admiralty jurisdiction. Upon this principle it is that goods taken by pirates and sold on land may be recovered from the vendee by suit in the Admiralty. Footnote. The Court of Admiralty has authority to entertain a civil suit entitled Causa Spolii Civilis et Maritima for the restitution of goods piratically taken on the high seas. End of footnote. Suits for seamen's wages are cognizable in the Admiralty, though the contract be made upon land, provided it be not a contract under seal, and this is intended for the case and benefit of seamen, for they are all allowed to join in the suit, and all the persons on board below the rank of master are comprehended in the description of mariners. Footnote. A contract for wages on board a steamboat plying between ports of adjoining states on a navigable tidewater may be enforced by a suit in rem in the Admiralty, Wilson versus the Steamboat Ohio, but to render a service on board a vessel even on tidewaters maritime, so far as to give Admiralty jurisdiction over it as for wages, it must contribute to the preservation of the vessel, or of those whose labor and skill are employed to navigate her. Musicians do not come within that description. Trainer versus the superior. The service must essentially be maritime. Labor on board a fuel or coal boat is not of that description. Thackeray versus the farmer. The service must concern transactions and proceedings relative to commerce and navigation, and to damages and injuries upon the sea, nor has the Admiralty any jurisdiction in matters of account between part owners, the steamboat Orleans versus Phoebus. It is limited in matters of contract to those which are maritime. Thus, in the case of the Thomas Jefferson, it was held that the Admiralty had no jurisdiction over contracts for the hire of seamen unless the service was substantially performed upon the sea or upon waters within the ebb and flow of the tide. Suits for seamen's wages on a voyage from a place in Kentucky up the river Missouri and back again were therefore not of Admiralty and maritime jurisdiction, but state courts under state laws have jurisdiction in rem in case of supplies and repairs to boats or vessels on river navigation in the interior, as well as under contracts for the carriage of persons or property upon navigable river waters. Statutes of Missouri, 1835, page 102. End of footnote. This case of seamen's wages, the courts of common law admit to be of Admiralty jurisdiction, and this is an exception in favor of seamen to the general rule that the Admiralty has no jurisdiction of any matter arising on land, though it be of maritime nature, as a charter party or policy of insurance. The District Court, as a court of Admiralty, possesses a general jurisdiction in suits by seamen and salvors, and by material men in rem and in personam. The courts of admiralty have a general jurisdiction to enforce maritime liens by process in rem, and there may be a maritime jurisdiction in personam where there is no lien and consequently no jurisdiction in rem. Seamen have an implied lien on the vessel for services rendered upon the high seas or upon tidewaters. They may proceed in rem and in personam, but the proceeding in rem is only maintainable by material men when there is a specific lien or for wages, or for repairs made, or necessaries furnished to a foreign ship, or to a ship in the ports of the state to which she does not belong. Footnote. If materials for a vessel be furnished in a home port and a note of hand given by the owner, a libel in the Admiralty in personam will not lie. Ramsey v. Allegre. In this last case, the extent of Admiralty jurisdiction in personam was much discussed and questioned by Mr. Justice Johnson, but in Willard v. Dorr and in Hammond v. Essex F. and M. Insurance Company, Mr. Justice Story considered it to be the settled jurisdiction of the Admiralty that the master could sue there in personam for his wages, and the seamen in rem as well as in personam for their wages. This appears to be a well-established distinction. End of footnote. The Admiralty jurisdiction is essential in all cases, for the process of a court of common law cannot directly reach the thing in specie. If the law raises a lien for a maritime service, a court of admiralty has power to carry it into effect. Footnote. No prior replevin or attachment of the property under any state court process can control the paramount jurisdiction of the Admiralty in rem for freight, or seamen's wages, or on a bottomry bond. End of footnote. The Act of Congress of July 20th, 1790, relative to seamen, Section 6, has given a specific and summary relief for seamen in the recovery of wages by authorizing the district judge, or in his absence a magistrate, to summon the master before him and to attach the vessel as security for the wages. Footnote. Material men and workmen having liens on vessels under state laws may enforce them in the district court as well as in a state court at their election, as the jurisdiction is in that case concurrent. Davis versus a New Brigantine. In the case of Hare and others versus the schooner Wave in the District Court of the Southern District of New York, the plaintiffs, as branch or deputy pilots, libeled the vessel for salvage in relieving her in distress within the harbor of New York, and salvage was allowed. On appeal to the Circuit Court of the United States for the Southern District of New York, the decree was reversed on the ground that the Act Congress of August 7, 1789, Chapter 9, had adopted the pilotage laws of the states respectively temporarily and had not since interfered, and that the remedy for the pilots was in the state courts, and that the district court had no jurisdiction in the case of pilotage arising within the waters of the states until Congress should give it, as they had the right to do. End of footnote. We have now finished a general survey of the Admiralty jurisdiction of the district courts in civil and criminal cases, and both as an instance and a prize court. It would not be consistent with the plan of these elementary disquisitions to give a detailed sketch of the course of proceeding and of the peculiar practice in the Admiralty courts. The proceedings are according to the course of the civil law and are remarkable for their comprehensive brevity, celerity, and simplicity. Nothing can be more unlike in its process, pleadings, proof, trial, and remedy than the practice of the courts of admiralty and of the courts of common law. Footnote. The Act of Congress of May 8, 1792, Chapter 36, Section 2, declared that the form of writs, executions, and other process except their style in suits of admiralty and maritime jurisdiction should be according to the principles, rules, and usages which belong to courts of admiralty as contradistinguished from courts of common law, subject to alterations and additions by the said courts and to regulations to be prescribed by the Supreme Court. For a knowledge of the Admiralty practice, I would refer the student to Clerk's Practice of the Court of Admiralty in England, which is a work of undoubted credit, and in 1809 a new edition was published in this country by Mr. Hall, with an appendix of precedents. I would also refer him to the second volume of Brown's Civil and Admiralty Law, and to the appendix to the first and second volumes of Mr. Wheaton's reports, where he will find the practice of the instance and prize courts digested and summarily explained. See also the case of Lane v. Townsend in the District Court of Maine in 1835. End of footnote. Civil jurisdiction of the District Court. 5. The jurisdiction of the District Court, when proceeding as a court of common law, extends to all minor crimes and offences cognizable under the authority of the United States, and which are not strictly of admiral cognizance, and to all seizures on land and on waters not navigable from the sea, and to all suits for penalties and forfeitures there incurred, and to all suits by aliens for torts done in violation of the law of nations or of a treaty, and to suits against consuls and vice-consuls, and to all suits at common law where the United States sue, and the matter in dispute amounts to $100. It has jurisdiction likewise of proceedings to repeal patents obtained surreptitiously or upon false suggestions. This is given by the Act of Congress of February 21, 1793, Chapter 2, and it is a jurisdiction that leads frequently to the most intricate, nice, and perplexed investigations respecting the originality of inventions and improvements in complicated machinery. It was made a question in the District Court of New York in the case Ex parte Wood, whether the process to be awarded to repeal the patent was not in the nature of a scire facias at common law, upon which issue of fact might be taken and tried by a jury. The district judge decided that the proceeding was summary upon a rule to show cause, and that no process of scire facias was afterwards admissible. But upon appeal to the Supreme Court of the United States, the decree of the district court was reversed, and the district court was directed by mandamus to enter upon record the proceedings in the cause, antecedent to the granting of the rule to show cause why process should not issue to repeal the patent. The district court was further directed to award process in the nature of a scire facias to the patentee to show cause why the patent should not be repealed. And upon the return of the process, the court was to proceed to try the cause upon the pleadings of the parties, and the issue of law or fact joined thereon, as the case might be, and that if the issue be an issue of fact, the trial thereof was to be by jury, according to the course of the common law. This was a just and liberal decision of the Supreme Court, and it was observed in the opinion which was pronounced that it was not lightly to be presumed that Congress in this class of patent cases, placed peculiarly within their patronage and protection, involving some of the dearest and most valuable rights which society acknowledges, and the Constitution itself meant to favor, would institute a new and summary process, which should finally adjudge upon those rights without a trial by jury, without a right of appeal, and without any of those guards with which in equity suits it has fenced round the general administration of justice. The Supreme Court then went into an analytical examination of the 10th section of the Act of 1793, on which the claim of summary jurisdiction rested, and vindicated the construction which they assumed in opposition to that taken by the District Court. The jurisdiction of the judges of the district courts in cases of bankruptcy has presented for consideration some important questions on the point of jurisdiction. We have no bankrupt system in existence under the government of the United States, but there are some lingering traces of business yet arising and undetermined under the Bankrupt Act of the year 1800, and we are in expectation at every session of Congress of a revival of that or some other analogous system and code of national bankrupt law. In the case of Comfort Sands, in the District Court of New York, it was observed that in England the sole power of directing the execution and controlling the administration of the bankrupt system in all its departments and in every stage of the proceeding resided in the Lord Chancellor. This jurisdiction of the English Chancellor is not in the Court of Chancery, but in the individual who holds the Great Seal, and it is exercised summarily upon petition, and his judgment upon the petition is without appeal, unless the Chancellor, in his discretion, allows a bill to be filed in order to found an appeal thereon. The judge then proceeded to examine the several provisions of the Bankrupt Act of the United States of 1800 in order to show that upon the principles of construction adopted in England, the district judge had the same jurisdiction in cases of bankruptcy as is exercised by the Lord Chancellor. The same course of reasoning which sustains the jurisdiction of the one would confer that of the other. He insisted that the jurisdiction was given not to the district court, but to the individual who happened to hold the office of district judge, and that, consequently, all his decisions in bankruptcy were without appeal, for appeals lie only from the decrees of the district court. But that extraordinary doctrine has since been overruled, and it has been held that the circuit courts of the United States had jurisdiction of matters arising under the bankrupt law, and the district courts had not exclusive jurisdiction over the entire execution of such laws. They could not remove the assignees nor compel them to account. An appeal lay in proceedings under the Bankrupt Act from the district to the circuit courts, and the state courts had a concurrent jurisdiction in matters of account between the bankrupt and his creditors, and which has been freely and extensively exercised. Territories belonging to the United States. 6. Of the Territorial Courts of the United States. With respect to the vast territories belonging to the United States, Congress have assumed to exercise over them supreme powers of sovereignty. Exclusive and unlimited power of legislation is given to them by the Constitution and sanctioned by judicial decisions. Congress was, by the Constitution, clothed with authority, quote, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as might, by cession of particular states and the acceptance of Congress, become the seat of government of the United States, end quote. The District of Columbia was created for that purpose under cessions from the states of Maryland and Virginia. The territorial jurisdiction of that district, known as the District of Columbia, and which embraces the city of Washington and throws its municipal protection over all the officers and agents of the government of the United States, is extremely important. Footnote. The powers of the Judiciary of the District of Columbia were ably discussed and declared by Chief Justice Cranch in the Circuit Court of that district on the 6th of June, 1837, in the case of the United States ex relatio Stokes-Stockton and Moore versus Amos Kendall, Postmaster General of the United States. It was decided that the court had authority to issue a mandamus to compel the defendant to credit the relators with the amount of an award made by the Solicitor of the Treasury in their favor under an Act of Congress of July 2, 1836. The defendant had refused to appear under a citation in that cause and claimed exemption from all personal responsibility as one of the heads of the departments to the jurisdiction of the court. The Chief Justice held that the Circuit Court of the District had all the jurisdiction that any Circuit Court of the United States could have under the Acts of Congress of 13th February 1801, Section 11, and of the 27th February 1801, Section 5, and it had more. It was inferior only to the Supreme Court. It had power to call before it any person found in the district from the highest to the lowest. No officer of government in the district was too high to be reached by the process of the court. The defendant in the case could not shelter himself under the authority or command of the President. There is no law establishing a relation between the Postmaster General and the President, nor any authority in the latter to prescribe his duties or control him in the exercise of his official functions. The Postmaster, in the exercise of his official duties, is as dependent of the President as the President is of him. If the President has any power to control him, it is only through the fear of removal, and no act done under such a control would be justified. This decision was affirmed on appeal to the Supreme Court of the United States in January term 1838, Kendall versus the United States. End of footnote. The general sovereignty existing in the government of the United States over its territories is founded on the Constitution, which declared that Congress, quote, should have power to dispose of and make all needful rules and regulations respecting the territories or other property belonging to the United States. Footnote. It was held in the case of the Canal Company versus Railroad Company by the Court of Appeals in Maryland that Congress acted in the government of the District of Columbia and other districts not as a local legislature, but as the legislature of the Union, and in the case of the State versus New Orleans and Company, it was held that the legislature of the Orleans Territory could grant a charter binding on the future state of Louisiana. So in the case of Williams versus the Bank of Michigan, the New York Court of Errors adjudged that the power to incorporate a bank was within the scope of the general powers of territorial legislation conferred upon the Michigan Territory by the Act of Congress of January 11, 1805. The government of the United States, which can lawfully acquire territory by conquest or treaty, must, as an inevitable consequence, possess the power to govern it. The territories must be under the dominion and jurisdiction of the Union, or be without any government, for the territories do not, when acquired, become entitled to self-government, and they are not subject to the jurisdiction of any state. They fall under the power given to Congress by the Constitution. This was the doctrine and decision of the Supreme Court in the case of the American Insurance Company versus Cantor. End of footnote. In the territories northwest of the River Ohio, and as separate territories were successively formed, Congress adopted and applied the principles of the Ordinance of the Confederation Congress of the date of the 13th of July, 1787. That ordinance was framed upon sound and enlightened maxims of civil jurisprudence. The organized territories belonging to the United States and governed under the superintendence of Congress at present consist of the territories of Columbia, Florida, Wisconsin, and Iowa. The territories of Michigan and Arkansas were admitted into the Union as states, and upon an equality with the other states, by acts of Congress of June 15, 1836, and January 26, 1837. In the organization of the territorial government of Florida, by the act of Congress of March 30, 1822, and March 3, 1823, the legislative power was vested in a governor who was to hold his office for 3 years, but removable by the president, and in a legislative council of 13 persons who were first to be annually appointed by the President and Senate of the United States, and afterwards in 1826 directed to be chosen by the people. No laws were to be passed inconsistent with the Constitution and laws of the United States. All laws to be annually reported to the President and laid before Congress, and if disapproved by Congress, to be of no force. The governor has a qualified negative on the passage of all laws. Footnote. The Legislative Council of Florida was reorganized by Act of Congress of July 7, 1838, Chapter 168, but in other respects the former laws respecting the territory were not disturbed. End of footnote. The judges of the superior courts of the territory are appointed by the President and Senate and hold their offices for 4 years. But writs of error and appeal lie from the decisions of the Court of Appeals to the Supreme Court of the United States equally as from the circuit courts in the several states. By the Act of Congress of May 15, 1826, the jurisdiction and powers of the Superior Courts and Court of Appeals of the Territory of Florida were again defined and regulated, and the powers of the Legislative Council restricted, and several acts granting divorces annulled, and by subsequent acts of Congress, the acts of the Legislative Council in certain other cases are declared void. Congress, in the organization of the territory, reserved and have continued the right to review and disapprove of the acts of the Legislative Council, and for the better security of personal rights, the Act of Congress of 1822 declared that the free exercise of religious opinion and worship and the benefit of the writ of habeas corpus should be secure, and fines and bail should not be excessive, nor ex post facto laws, or laws impairing the obligation of contracts passed, nor private property taken for public use without just compensation. By the Act of Congress of 20th April 1836, Chapter 54, the territorial government of Wisconsin was established. It was to consist of a legislative assembly composed of a council and House of Representatives to be chosen by the people. the council to consist of 13 members chosen for 4 years, and the other house of 26 members chosen for 2 years. All free white male citizens of the territory of 21 years of age were entitled to vote at the first election, and the Legislative Assembly were authorized to determine the qualifications of voters thereafter, providing that the right of suffrage should only be exercised by citizens of the United States. The legislature was not to pass any laws interfering with the primary disposal of the soil, nor to tax the lands of non-residents higher than the lands of residents. The executive power was vested in a governor, who holds for 3 years unless sooner removed by the President of the United States, and he has an absolute negative on all laws passed by the Legislative Assembly, and all laws are to be submitted annually to Congress, and if disapproved by them, to become null. The governor, secretary of the territory, judges of the Supreme Court, attorney general, and marshal are appointed by the President of the United States with the advice and consent of the Senate, and other judicial officers, justices of the peace, sheriffs, and militia officers are appointed by the Legislative Council on the nomination of the governor. The judges of the Supreme Court hold their office during good behavior, and they hold circuit courts, and the Supreme and Circuit Courts possess chancery as well as common law jurisdiction. The inhabitants of the territory are declared to have all the rights and privileges, and to be subject to all the conditions and restrictions granted and imposed by the Articles of the Compact in the Ordinance of the 13th July, 1787, and they elect a delegate to the House of Representatives to serve for 2 years. Writs of error and appeal lie to the Supreme Court of the United States from the final decisions of the Supreme Court of the Territory where the amount in controversy exceeds $1,000, and by the Act of Congress of June 12, 1838, Chapter 96, the Territorial Government of Iowa was created out of the territory of Wisconsin lying west of the Mississippi. The legislative power was vested in a council and House of Representatives, and the executive power in a governor. The judges, justices, and executive officers to be appointed by the governor and council, and the judges, attorney general, and marshal hold their offices for 4 years, and the territory elects and sends a delegate to Congress. It would seem from these various congressional regulations of the territories belonging to the United States that Congress have supreme power in the government of them, depending on the exercise of their sound discretion. That discretion has hitherto been exercised in wisdom and good faith, and with an anxious regard for the security of the rights and privileges of the inhabitants, as defined and declared in the Ordinance of July, 1787, and in the Constitution of the United States. Quote, "All admit," said Chief Justice Marshall, "the constitutionality of a territorial government." End quote. But neither the District of Columbia nor a territory is a state within the meaning of the Constitution, or entitled to claim the privileges secured to the members of the Union. This has been so adjudged by the Supreme Court. Nor will a writ of error or appeal lie from a territorial court to the Supreme Court, unless there be a special statute provision for the purpose. There is such a provision as to Florida and Wisconsin, and there was a limited provision of that kind as to Arkansas and Michigan, extending to cases in which the United States were concerned and not extending further. If, therefore, the government of the United States should carry into execution the project of colonizing the Great Valley of the Columbia, or Oregon River to the west of the Rocky Mountains, it would afford a subject of grave consideration that would be the future civil and political destiny of that country. It would be a long time before it would be populous enough to be created into one or more independent states, and in the meantime, upon the doctrine taught by the acts of Congress and even by the judicial decisions of the Supreme Court, the colonists would be in a state of the most complete subordination, and as dependent upon the will of Congress as the people of this country would have been upon the King and Parliament of Great Britain if they could have sustained their claim to bind us in all cases whatsoever. Such a state of absolute sovereignty on the one hand and of absolute dependence on the other is not congenial with the free and independent spirit of our native institutions, and the establishment of distant territorial governments ruled according to will and pleasure would have a very natural tendency, as all proconsular governments have had, to abuse and oppression. Footnote: Cicero, in his Oration for the Manilian Law, chapter 14, describes in glowing colors the oppressions and abuses committed by Roman magistrates exercising civil and military power in the distant provinces. End of footnote. End of section 30, read by Sandra near Montreal in Canada, 2026.
Section 31 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1, by James Kent. Section 31. Lecture 18 of the Concurrent Jurisdictions of the State Governments. The question, how far the state governments have concurrent powers, either legislative or judicial, over cases within the jurisdiction of the government of the United States, has been much discussed. It will be my endeavour, in the course of the present lecture, to ascertain the just doctrine and settled distinctions applicable to this great and important constitutional subject. Concurrent legislation of the several states. 1. As to the concurrent powers of legislation in the states. It was observed in the Federalist, footnote A, that the state governments would clearly retain all those rights of sovereignty which they had before the adoption of the Constitution of the United States, and which were not by that Constitution exclusively delegated to the Union. The alienation of state power or sovereignty would only exist in 3 cases: where the Constitution in express terms granted an exclusive authority to the Union, where it granted in one instance an authority to the Union, and in another prohibited the states from exercising the like authority, and where it granted an authority to the Union to which a similar authority in the states would be absolutely and totally contradictory and repugnant. Footnote 1. In the judicial construction given from time to time to the Constitution, there is no very essential variation from the contemporary exposition which was here laid down by the high authority of the Federalist. Judge Chase, in the case of Calder v. Bull, footnote B, declared that the state legislatures retained all the powers of legislation which were not expressly taken away by the Constitution of the United States, and he held that no constructive powers could be exercised by the federal government. Page 416, footnotes. A. Number 32. B. 3 Dallas 386. 1. C. Post. Pages 390, 395 et seq. Subsequent judges have not expressed themselves quite so strongly in favour of state rights, and in restriction of the powers of the national government. In Sturgis v. Crowninshield, footnote A, the Chief Justice of the United States observed that the powers of the states remained, after the adoption of the Constitution, what they were before, except so far as they had been abridged by that instrument. The mere grant of a power by Congress did not imply a prohibition on the states to exercise the same power. Thus, Congress are authorized to establish uniform laws on the subject of bankruptcy, but the states may pass bankrupt laws provided there be no act of Congress in force establishing a uniform law on that subject. Footnote B. Footnote 2. The states may legislate in the absence of congressional regulations. It is not the mere existence of the power, but its exercise, which is incompatible with the exercise of the same power by the states. It is not the right to establish these uniform laws, but their actual establishment, which is inconsistent with the partial acts of the states. But the concurrent power of legislation in the states did not extend to every case in which the exercise of it by the states had not been expressly prohibited. The correct principle was that whenever the terms in which the power was granted to Congress, or the nature of the power, required that it should be exercised exclusively by Congress, the subject was as completely taken from the state legislatures as if they had been expressly forbidden to act on it. In Houston v. Moore, c. the same principles were laid down by Judge Washington in delivering the opinion of the court. He observed that the power of the state governments to legislate on the subject of the state militia having existed prior to the formation of the Constitution, and not being prohibited by that instrument, it remained with the states, subordinate, nevertheless, to the paramount power of the general government operating upon the same subject. If Congress, for instance, did not exercise the power of providing for organizing, arming, and disciplining the militia, it was competent for the state to do it. But as Congress had exercised its constitutional powers upon the subject of the militia as fully as was thought proper, the power of the legislation over that subject by the states was excluded, except so far as it had been permitted by Congress. Page 417, footnotes. A. 4 Wheaton, 193. B. In Golden v. Prince, 3 Wash, Sir, Rep. 313, Judge Washington had previously held, in the Circuit Court of the United States for Pennsylvania, that Congress had the exclusive power to pass bankrupt laws. But this opinion was subsequently corrected and qualified according to the doctrine in the text. C. 5 Wheaton, 1. 2. See ante, page 244, note 3. The doctrine of the court was that when Congress exercised their powers upon any given subject, the states could not enter upon the same ground and provide for the same objects. The will of Congress may be discovered as well by what they have not declared as by what they have expressed. Two distinct wills cannot at the same time be exercised, in relation to the same subject, effectually, and at the same time be compatible with each other. If they correspond in every respect, then the latter is idle and inoperative. If they differ, they must, in the nature of things, oppose each other so far as they do differ. It was, therefore, not a true and constitutional doctrine that in cases where the state governments have a concurrent power of legislation with the national government, they may legislate upon any subject on which Congress have acted, provided the two laws are not in their operation contradictory and repugnant to each other. Judge Story, in the opinion which he gave in this case, spoke to the same effect, and defined with precision the boundary line between the concurrent and residuary powers of the states and the exclusive powers of the Union. a mere grant of power in affirmative terms to Congress, did not per se transfer an exclusive sovereignty on such subjects. The powers granted to Congress were never exclusive of similar powers existing in the states, unless where the Constitution has expressly in terms given an exclusive power to Congress, or the exercise of a like power was prohibited to the states, or there was a direct repugnancy or incompatibility in the exercise of it by the states. This is the same description of the nature of the powers as that given by the Federalist. Footnote 3. An example of the first class is to be found in the exclusive legislation delegated to Congress over places purchased for forts, arsenals, etc., and of the second class in the prohibition of a state to coin money or emit bills of credit, and of the third class in the power to establish a uniform rule of naturalization and in the delegation of admiralty and maritime jurisdiction. Page 418 footnotes. 3. See ante, page 387, and post, page 395. In all other cases, the states retain concurrent authority with Congress, except where the laws of the states and of the Union are in direct and manifest collision on the same subject, and then those of the Union, being the supreme law of the land, are of paramount authority, and the state laws, so far, and so far only as such incompatibility exists, must necessarily yield. In the application of these general principles to the case before the court, it was observed that the power given to Congress to provide for organizing, arming, and disciplining the militia was not exclusive. It was merely an affirmative power, and being not incompatible with the existence of a like power in the states, it might well leave a concurrent power in the latter. But when once Congress have acted on the subject, and carried this power into effect, its laws for the organization, arming, and disciplining the militia were supreme, and all interfering regulations of the states suspended. A state may organize, arm, and discipline its own militia in the absence of, or subordinate to, the regulations of Congress. This power originally existed in the states, and the grant of it to Congress was not necessarily exclusive, unless a concurrent power in the states would be repugnant to the grant, and there was no such repugnancy in the nature of the power. But the question was whether a state legislature had any concurrent power remaining after Congress had provided, in its discretion, for the case. The conclusion was that when once the legislature of the Union has exercised its powers on a given subject, the state power over that same subject, which had before been concurrent, was by that exercise prohibited, and this was the opinion of the court. These expositions of the paramount powers of the general government are to be received as correct and conclusive, for they proceed from the highest authority and are exceedingly clear and logical in their deductions. The same doctrines had been previously declared in the Court of Errors of New York, in the steamboat case of Livingston versus Van Ingen. Footnote A. Our safe rule of a construction and of action, as it was there observed, footnote B, was this, that if any given power was originally vested in this state, if it had not been exclusively ceded to Congress, or if the exercise of it had not been prohibited to the states, We might then go on in the exercise of power until it came practically in collision with the exercise of some congressional power. Page 419, footnotes. A. 9 Johns, Rep. 507. B. 9 Johns, Rep. 576. When that happened to be the case, the state authority would so far be controlled, but it would still be good in those respects in which it did not contravene the provision of the paramount law. A similar exposition of the concurrent jurisdiction of the states was given by the Supreme Court of Pennsylvania in Moore v. Houston, footnote A, and by the Chief Justice of Massachusetts in Blanchard v. Russell, footnote B. When the Constitution of the United States was under the consideration of the state conventions, there was much concern expressed on the subject of the general power of taxation over all objects of taxation vested in the national government, and it was supposed that it would be in the power of Congress, in its discretion, to destroy in effect the concurrent power of taxation remaining in the states, and to deprive them of means of supplying their own wants. All the resources of taxation might, by degrees, become the objects of federal monopoly. The states must support themselves by direct taxes, duties, and excises, and Congress may lay the same burthen, at the same time, on the same subject. Suppose the national tax should be as great as the article, whether it be land, or distilled spirits, or pleasure carriages, for instance, will conveniently and prosperously bear. And the state should be obliged to lay a further tax for its own necessities. The doctrine, as I understand it, is that the claim of the United States would be preferred and must be first satisfied, because the laws of the United States, made in pursuance of the Constitution, are the supreme law of the land. The author of the Federalist, footnote C, admits that a state might lay a tax on a particular article equal to what it would well bear, but the United States would still have a right to lay a further tax on the same article, and that all collisions in a struggle between the two governments for revenue must and would be avoided by a sense of mutual forbearance. He nowhere, however, meets and removes the difficulty in the case of a want of this mutual forbearance, where there is a concurrent tax laid on the same subject and which will not bear both taxes. Page 420, footnotes. A. 3. Serg and Roll, 179. B. 13. Mass Rep. 16. C. Number 32. See also numbers 31, 33, 34. He says only that the United States would have no right to abolish the state tax. This is not contended. But would not the United States have a right to declare that their taxes were liens from the time they were imposed? And would they not, as of course, be entitled to be first paid? And must not the state collector, in all cases, stand by and wait until the national tax is collected before he proceeds to collect his state tax out of the exhausted subject? Upon the doctrine of the federal courts and upon the doctrine of the Federalist himself, this must be the case. And though the state legislatures have a concurrent jurisdiction in the case of taxation, except as to imposts, yet, in effect, Though not in terms, this concurrent power becomes a subordinate and dependent power. In every other case of legislation, the concurrent power in the states would seem to be a power entirely dependent and subject to be taken away absolutely, whenever Congress should choose to exercise their powers of legislation over the same subject. I do not mean to be understood to question the validity or to excite alarm at the existence of this doctrine. The national government ought to be supreme within its constitutional limits, for it is entrusted with the paramount interest and general welfare of the whole nation. Our great and effective security consists in the fact that the constituents of the general and of the state governments are one and the same people, and the powers of the national government must always be exercised with a due regard to the interest and prosperity of every member of the Union. For on the concurrence and goodwill of the parts, the stability of the whole depends. My object is to discover what this concurrent power of legislation amounts to, and what is its value, and on what constitutional foundation it is supported. It was observed by Mr. Hamilton in the Convention of New York in 1788, footnote A, that if the United States and the state should each lay a tax on a specific article, and the individual should be unable to pay both, the party who first levied would hold the property. But this position must be received with some qualification. Page 421 footnotes. Debates in the New York Convention, printed by Francis Childs. Page 113. The United States have declared by law that they were entitled, in respect to their debts, to priority of payment, and when it was said that this claim would interfere with the rights of the state sovereignties, and would defeat the measures they had a right to adopt to secure themselves against delinquencies, the answer given in Fisher v. Blight, footnote A, is that the mischief suggested, so far as it can really happen, was the necessary consequence of the supremacy of the laws of the United States on all subjects to which the legislative power of Congress extends. It would seem, therefore, that the concurrent power of the legislation in the states is not an independent but a subordinate and dependent power, liable, in many cases, to be extinguished and in all cases to be postponed to the paramount or supreme law of the Union, whenever the federal and the state regulations interfere with each other. Footnote B. In Wayman v. Southard, footnote C, the question arose how far the judicial process of the federal courts could be controlled by the laws of the several states. It was decided that Congress had exclusive authority to regulate proceedings and executions in the federal courts, and that the states had no authority to control such process. And, therefore, executions by fieri facias in the federal courts were not subject to the checks created by the Kentucky statute, forbidding sales on execution of land for less than 3/4 of its appraised value. It was, in that case, further observed that the forms of execution and other process in the federal courts, in suits at common law, except modes of proceeding, were to be the same as used in September 1789 in the Supreme Courts of the States, subject only to alterations and additions by Congress and by the federal courts, but not to alterations since made in the state laws and practice. Page 422 footnotes. A. 2. Cranch 397. B. It has become a settled point, and I think it was a very clear one from the beginning, that in the construction of the power of Congress to lay and collect taxes, duties, imposts, and excises, it is not to be taken as an independent grant of power, without any defined limit or object, but that it is a power to be considered in connection with the words immediately thereafter, by which it is made subject to the qualification or limitation of being exercised for the purpose of paying the debts and providing for the common defence and general welfare of the United States. The purpose for which the taxes are to be laid is not of itself a distinct, substantial power, but a qualification of the power of taxation by restricting it to those great and specified purposes, though the application of it to those purposes does not undoubtedly admit, and necessarily requires, the exercise of a large and undefined discretion. The progress of this question, and the very weighty opinions upon it, are fully shown and forcibly illustrated in 2 Stories Com. 367 to 398. And see particularly Mr. Monroe's message on the bill respecting the Cumberland Road, May 4th, 1822. Ibid 445 to 456. That Congress possessed the power to appropriate money, raised by taxation or otherwise, for other purposes, in their discretion, than those pointed out in the enumerated powers, is a question that has given rise to very able and acute discussions, and the affirmative side of the question has been sustained and successfully vindicated by the practice of the government, and the weighty authority, among others, of Mr. Hamilton and Mr. Monroe, in celebrated documents under their official sanction. See Hamilton's report on manufactures and President Monroe's message above referred to. Stories Com, Volume 2, page 440 to 458. This distinguished commentator gives to the affirmative side of the question the sanction also of his decided opinion. C. 10 Wheaton 1. It was further observed that the laws of the several states were, by the Judiciary Act of 1789, Section 34, to be regarded as rules of decision in trials at common law, in cases where they apply, unless the Constitution, treaties, or statutes of the United States had otherwise provided. This, however, did not apply to the practice of the federal courts. As to that, the laws of the states were no rule of decision, and the direction was intended only as a legislative recognition of the principles of universal jurisprudence as to the operation of the lex loci in the trial and decision of causes. The law respecting final process was materially altered by the Act of Congress of 1828, footnote A, and that Act adopted into the national courts in each state respectively, Louisiana excepted, the existing laws and usages of the several courts, regulating the effect and operation of judgments and executions, and the proceedings for their enforcement. But where judgments were a lien in the state upon the property of the defendants, and the defendants were entitled to an imparlance thereon of 1 term or more, the defendants in the United States' courts, in such state, are entitled to an imparlance of 1 term. If in any state there were no courts of equity with the ordinary equity jurisdiction, The courts of the United States in such states might prescribe the mode of executing their decrees in equity. And the powers of the United States were also invested with power to alter, in their discretion, the final process in their courts, and to conform the same to legislative changes made for the states' courts. Footnote 4. Concurrent judicial jurisdiction of the states. 2. As to the concurrent power of the states in matters of judicial cognizance. Page 423 footnotes. A. Act of Congress of May 19, 1828. Chapter 68. Section 2, 3. 4. For later provisions relating to the matters mentioned above, see ante, page 342, note 5. In the 82nd number of the Federalist, it is laid down as a rule that the state courts retained all pre-existing authorities or the jurisdiction they had before the adoption of the Constitution, except where it was taken away, either by an exclusive authority granted in express terms to the Union, or in a case where a particular authority was granted to the Union, and the exercise of a like authority was prohibited to the states, or in the case where an authority was granted to the Union with which a similar authority in the states would be utterly incompatible. A concurrent jurisdiction in the state courts was admitted in all except those enumerated cases. But this doctrine was only applicable to those descriptions of causes of which the state courts had previous cognizance, and it was not equally evident in relation to cases which grew out of the Constitution. Congress, in the course of legislation, might commit the decision of causes arising upon their laws to the federal courts exclusively. But unless the state courts were expressly excluded by the acts of Congress, they would, of course, take concurrent cognizance of the causes to which those acts might give birth, subject to the exceptions which have been stated. In all cases of concurrent jurisdiction, an appeal would lie from the state courts to the Supreme Court of the United States, and without such right of appeal, the concurrent jurisdiction of the state courts in matters of national concern would be inadmissible, because, in that case, it would be inconsistent with the authority and efficiency of the general government. Such were the early and speculative views of the ablest commentators on the Constitution in relation to the judicial powers of the state courts. We will now examine a series of decisions in the federal courts, defining and settling the boundaries of the judicial authorities of the states. In the case of Martin v. Hunter, footnote A, Judge Story, in delivering the opinion of the court, seemed to think that it was the duty of Congress to vest the whole judicial power of the United States in courts ordained and established by itself. Footnote 6. But the general observation was subsequently qualified and confined to that judicial power which was exclusively vested in the United States. The whole judicial power of the United States should be, at all times, vested, either in an original or appellate form, in some courts created under its authority. It was considered that there was vast weight in the argument that the Constitution is imperative upon Congress to vest all the judicial power of the United States in the shape of original jurisdiction in the supreme and inferior courts created under its own authority. Page 424 footnotes. A. 1 Wheaton, 304. Vide supra, page 377. 5. C ante, pages 387, 390. 6. C ante, pages 314, 317 to 320. At all events, it was manifest that the judicial power of the United States is, unavoidably, in some cases, exclusive of all state authority, and in all cases may be made so at the election of Congress. No part of the criminal jurisdiction of the United States can, consistently with the Constitution, be delegated to state tribunals. The Admiralty and maritime jurisdiction is of the same exclusive cognizance, and it can only be in those cases where, previous to the Constitution, state tribunals possess jurisdiction independent of national authority, that they can now constitutionally exercise a concurrent jurisdiction. Congress, throughout the Judiciary Act, and particularly in the 9th, 11th, and 13th sections, have legislated upon the supposition that in all the cases to which the judicial powers of the United States extended, they might rightfully vest exclusive jurisdiction in their own courts. State courts may, in the exercise of their ordinary, original, and rightful jurisdiction, incidentally take cognizance of cases arising under the Constitution, the laws and treaties of the United States. Yet to all these cases the judicial power of the United States extends by means of its appellate jurisdiction. Footnote 7. In Houston v. Moore, footnote A, the same question came again under the consideration of the Supreme Court, and Judge Washington, in delivering the opinion of the court, observed that he saw nothing unreasonable or inconvenient in the doctrine of the Federalist on the subject of the concurrent jurisdiction of the state courts, so long as the power of Congress to withdraw the whole or any part of those cases from the jurisdiction of the state courts be, as he thought it must be, admitted. The practice of the general government has been conformable to this doctrine, and in the Judiciary Act of 1789, the exclusive and concurrent jurisdiction conferred on the courts by that Act were clearly distinguished and marked. The Act shows that, in the opinion of Congress, a grant of jurisdiction generally was not of itself sufficient to vest an exclusive jurisdiction. The Judiciary Act grants exclusive jurisdiction to the circuit courts of all crimes and offences cognizable under the authority of the United States, except where the laws of the United States should otherwise provide, and this accounts for the proviso in the Act of 24th of February 1807, C-75, and in the Act of 10th of April 1816, C-44, concerning the forgery of the notes of the Bank of the United States, declaring that nothing in that Act contained should be construed to deprive the courts of the individual states of jurisdiction under the laws of the several states over offences made punishable by that Act. Page 425, footnotes. A. 5 Wheaton, 1. 7. C. Ante, page 302, note 29. Page 303, note 36, and page 306, note 57. There is a similar proviso in the Act of 21st of April, 1806, C-49, concerning the counterfeiters of the current coin of the United States. Without these provisos, the state courts could not have exercised concurrent jurisdiction over those offences, consistently with the Judiciary Act of 1789. But these saving clauses restored the concurrent jurisdiction of the state courts, so far as, under state authority, it could be exercised by them. Footnote A. Footnote 9. There are many other acts of Congress which permit jurisdiction over the offences therein described to be exercised by state magistrates and courts. This was necessary because the concurrent jurisdiction of the state courts over all offences was taken away, and that jurisdiction was vested exclusively in the national courts by the Judiciary Act, and it required another act to restore it. The state courts could exercise no jurisdiction whatever over crimes and offences against the United States, unless where, in particular cases, the laws had otherwise provided. And whenever such provision was made, the claim of exclusive jurisdiction in the particular cases was withdrawn, and the concurrent jurisdiction of the state courts, eo instanti, restored, not by way of grant from the national government, but by the removal of a disability before imposed upon the state tribunals. In that case, the Supreme Court disclaimed the idea that Congress could authoritatively bestow judicial powers on state courts and magistrates. Page 426 footnotes. A. In the case of the State versus Tuff, 2 Baileys SC Rep 44, the state courts are considered as having jurisdiction, independent of the acts of Congress, to punish the uttering and passing counterfeit bank bills and coin of the United States, and on the principle that such a power is essential to the protection of the citizens. 8. For similar provisions of later acts, see ante, page 302, note 30. 9. The power of the United States to pass and enforce laws providing a punishment for the offence of counterfeiting notes of a foreign bank or corporation does not prevent a state from providing for the punishment of the same thing, for here, as in the case of counterfeiting the coin of the United States, the act may be an offence against the authority of a state as well as that of the United States. U.S.R. Arjona 120 U.S. 479 487 1886. It was held to be perfectly clear that Congress cannot counter jurisdiction upon any courts, but such as exist under the Constitution and laws of the United States, although the state courts may exercise jurisdiction in cases authorized by the laws of the state and not prohibited by the exclusive jurisdiction of the federal courts. Footnote 10. The Supreme Court, having thus declared the true foundation and extent of the concurrent jurisdiction of the state courts in criminal cases, proceeded to meet and solve a difficulty occurring on this subject of concurrent jurisdiction, whether the sentence of one jurisdiction would oust the jurisdiction of the other. The decision on this point was that the sentence of either court, whether of conviction or acquittal, might be pleaded in bar of the prosecution before the other, as much so as the judgment of a state court in a civil case of concurrent jurisdiction might be pleaded in bar of an action for the same cause instituted in a circuit court of the United States. There was another difficulty, so not easily surmounted, and that was whether, if a conviction of a crime against the United States be had in a state court admitted to have concurrent jurisdiction, the governor of the state would have the power to pardon and in that way control the law and policy of the United States. Judge Washington, in speaking for the court, did not answer this question, but contented himself with merely observing that he was by no means satisfied that the governor could pardon, but that if he could, it would furnish a reason for vesting the jurisdiction of criminal matters exclusively in the federal courts. The conclusion, then, is that in judicial matters, the concurrent jurisdiction of the state tribunals depends altogether upon the pleasure of Congress, and may be revoked and extinguished whenever they think proper, in every case in which the subject matter can constitutionally be made cognizable in the federal courts, and that, without an express provision to the contrary, the state courts will retain a concurrent jurisdiction in all cases, where they had jurisdiction originally over the subject matter. We will next see whether this state jurisdiction does not equally depend upon the volition of the state courts. Page 427, footnote. 10. Discussion of this subject is resumed post page 400. There are various acts of Congress in which duties have been imposed on state magistrates and courts, and by which they have been invested with jurisdiction in civil suits, and over complaints and prosecutions in penal and criminal courts for fines, penalties, and forfeitures arising under laws of the United States. We have seen a very clear intimation given by the judges of the Supreme Court, footnote 11, that the state courts were not bound, in consequence of any act of Congress, to assume and exercise jurisdiction in such cases. It was merely permitted to them to do so, as far as was compatible with their state obligations, and in some instances the state courts have acted in those cases, and in other instances they have declined jurisdiction, though expressly vested with it by the Act of Congress. In the case of Ferguson, footnote A, an application was made to the Supreme Court of New York for the allowance of a habeas corpus to bring up the party alleged to be detained in custody by an officer of the Army of the United States on the ground of being an enlisted soldier. And the allegation was that he was an infant and so not duly enlisted. It was much discussed whether the state courts had concurrent jurisdiction, by habeas corpus, over the question of unlawful imprisonment, when that imprisonment was by an officer of the United States, by colour, or under pretext of the authority of the United States. The Supreme Court did not decide the question, and the motion was denied on other grounds. But subsequently, in the matter of Stacy, footnote B, the same court exercised a jurisdiction in a similar case by allowing and enforcing obedience to the writ of habeas corpus. The question was therefore settled in favour of a concurrent jurisdiction in that case, and there has been a similar decision and practice by the courts of other states. Footnote C, footnote 12. Page 428, footnotes. A. 9 Johns, Rep. 239. B. 10 Johns, Rep. 328. C. Case of Lockington, before Tilgham, Chief Justice of Pennsylvania, November 1813, 5 Hall's Law Journal, 92. Same case, 5 Hall's Law Journal, 301 to 330. A similar case in Maryland, 5 Hall's Law Journal, 486, and in South Carolina, 5 Hall's Law Journal, 497. Commonwealth v. Harrison, 11 Mass. Rep. 68. Case of Joseph Almeida in Maryland and the case of Poole and others in Virginia, cited in Sargent's Constitutional Law, page 279-280. By the New York Revised Statutes, Volume 2, page 563, Section 22, a habeas corpus may be awarded unless the party be detained by process from a court or judge of the United States, having exclusive jurisdiction in the case. 11. Ante, page 399. See further post, pages 402 et seq. 12. Per contra, see Ableman v. Booth, 21. Howe, 506, 521. 1858. The Supreme Court of New York in the case of the United States v. Dodge, footnote A, held that they had jurisdiction and did sustain a suit on a bond for duties given to a collector of the United States Customs. The suit was authorized by the Judiciary Act of 1879, giving concurrent jurisdiction to the state courts in suits at common law, where the United States were plaintiffs. Afterwards, in the case of the United States v. Lathrop, footnote B, the same court discussed, very much at large, the question whether a state court had jurisdiction of an action in favor of the United States to recover a penalty or forfeiture for breach of a law of the United States, and when a suit for the penalty was by the act declared to be cognizable in a state court. It was decided that the court had no such jurisdiction, and that it could not even be conferred by an act of Congress. The difference between this case and the one preceding was that was a suit on a bond given to a collector of the customs for duties, and this was an action of debt for a penalty for breach of the excise law. They were both cases of debts due to the United States, but the one was a civil debt and the other a penalty for breach of a revenue law. And this slight difference in the nature of the demand was considered to create a most momentous difference in its result upon the great question of jurisdiction. It was the opinion of the court that Congress could not invest the state courts with a jurisdiction which they did not enjoy concurrently before the adoption of the Constitution, and a pecuniary penalty for a violation of an act of Congress was a punishment for an offence created under the Constitution, and the state courts had no jurisdiction of the criminal offences or penal laws of the United States. The Judiciary Act of 1789 was the true exposition of the Constitution with respect to the concurrent jurisdiction of the state courts, and the exclusive jurisdiction of those of the United States. And by that act, the exclusive cognizance of all crimes and offences cognizable under the authority of the United States, and of all suits for penalties and forfeitures, was given to the federal courts. Footnote 13. The Judiciary Act in no instance excluded the previously existing jurisdiction of the state courts, except in a few specified cases of a national nature. But their jurisdiction was excluded in all criminal cases, and with respect to offences arising under the Acts of Congress. Page 429 footnotes. A. 14 Johns, Rep. 95. B. 17 Johns, Rep. 4. 13. As to the exclusive jurisdiction of the federal courts under later acts, see ante, page 296, note 4. In such cases, the federal jurisdiction was necessarily exclusive, but it was not so as to pre-existing matters within the jurisdiction of the state courts. Footnote A, footnote 14. The doctrine seems to be admitted that Congress cannot compel a state court to entertain jurisdiction in any case. It only permits state courts which are competent for the purpose and have an inherent jurisdiction adequate to the case to entertain suits in the given cases, and they do not become inferior courts in the sense of the Constitution because they are not ordained by Congress. The state courts are left to infer their own duty from their own state authority and organization, but if they do voluntarily entertain jurisdiction of causes cognizable under the authority of the United States, they assume it upon the condition that the appellate jurisdiction of the federal courts shall apply. Their jurisdiction of federal causes is, however, confined to civil actions or to enforce penalty statutes, and they cannot hold criminal jurisdiction over offences exclusively existing as offences against the United States. Every criminal prosecution must charge the offence to have been committed against the sovereign whose courts sit in judgment upon the offender, and whose executive may pardon him. We find a similar doctrine in one of the courts in the state of Ohio, in the case of the United States versus Campbell. Footnote B. That was an information filed by the collector of the revenue to recover a penalty for breach of the excise law, and the court held it to be a criminal prosecution, and that one sovereign state could not make use of the municipal courts of another government to enforce its penalty laws, and it was not in the power of Congress to vest such a jurisdiction in the state courts. Upon the same principle, the Court of Errors in Virginia, in the case of the state versus Feely, decided that it had no jurisdiction to punish by indictment stealing packets from the mail, as that was an offence created by Act of Congress. Footnote C. And in Jackson versus Roe, the General Court of Virginia made the same decision precisely as that made in New York in the case of Lathrop. And it held that the Act of Congress authorizing such suits for penalties in the state courts was not binding. Page 430, footnotes. A. Ely versus Peck. 7. Con. Rep. 230. Davison versus Champlin. Ibid. 241. 8. P. B. 6 Hall's Law Journal. 113. C. Sargent's Constitutional Law. Page 272. Virginia Cases 321. 8. C. 14. See ante, page 306, note 57. It was decided, in another case in Virginia, footnote A, that Congress could not give jurisdiction to or require services of a state court or magistrate as such, nor prosecute in the state courts for a public offence. In Kentucky, it was held, as late as 1833, footnote B, that no state court could take cognizance of a penal case arising under an act of Congress. Such a jurisdiction would require an act of the state and the consent of Congress. After those decisions in Virginia, Ohio, Kentucky, and New York, the Act of Congress of 3rd of March 1815, EH 100, may be considered as essentially nugatory. That act vested in the state courts concurrently with the federal courts cognizance of all complaints, suits, and prosecutions for taxes, duties, fines, penalties, and forfeitures arising and payable under any act of Congress passed or to be passed for the collection of any direct tax or internal duties. And it gave to the state courts and the presiding judge thereof the same power as was vested in the district judges to mitigate or remit any fine, penalty, or forfeiture. Footnote C. And here the inquiry naturally suggests itself, can the state courts, consistently with those decisions, sustain a criminal prosecution for forging the paper of the Bank of the United States, or for counterfeiting the Court of the United States? These are cases arising under Acts of Congress declaring the offence. The state courts have exercised criminal jurisdiction over these offences as offences against the state, but it is difficult to maintain the jurisdiction upon the doctrine of the Supreme Court of New York in the case of Lathrop, and if it be entertained, there are difficulties remaining to be definitively cleared. These difficulties relate to the effect of a prosecution in one jurisdiction upon the jurisdiction of the concurrent court, and to the effect of the executive power of pardon of the crime under one government upon the claim of concurrent jurisdiction. Footnote D. Page 431 footnotes. A. Ex parte pull. Sergeant's Coast Law, page 272, 274. B. Haney v. Sharp, 1. Dana's Kentucky Rep, 442. C. The Act of Congress of February 28, 1839, Chapter 36, Section 3, notwithstanding the state decisions, authorized all pecuniary penalties and forfeitures under the laws of the United States to be sued for before any court of competent jurisdiction in the state or district where the cause of action arises or the offender may be found. To be sued for before any court of competent jurisdiction in the state or district where the cause of action arises or the offender may be found. D. In the case of the State v. Randall, 2 Aikens Rep. 89, the Supreme Court of Vermont decided, in 1827, that the state courts had concurrent criminal jurisdiction over the offences of counterfeiting and passing counterfeit bills of the Bank of the United States. And in the case of the State v. Wells, 2 Hills S.C., Rep. 687, it was held that the state courts had concurrent cognizance of the indictable offence of opening a letter contrary to the Act of Congress, and that Congress might constitutionally confer such a jurisdiction. On the other hand, it was decided in Missouri, in Madison v. the State, 3 Missouri Rep. 421, that their courts had no cognizance of the case of counterfeiting the current coin, and that a statute of the state providing for the cognizance and punishment of such crimes was void. The doctrine was that the states had no concurrent legislation on the subject, and that the power resided exclusively in Congress. So, the Constitution of the United States, Article 4, Section 2, having declared that persons held to service or labour in one state under the laws thereof and escaping into another should be delivered up on claim of the party to whom such service or labour might be due. The laws of New York, in furtherance of this duty, have provided for the arrest of such fugitives on habeas corpus, founded on due proof, and for a certificate in favour of the right of the claimant and delivery of the fugitive to him to be removed. But the fugitive is entitled to his writ of homine replegiando, notwithstanding the habeas corpus and certificate. N.Y. Revised Statutes, Volume 2, page 560, Section 6 to 20. See Volume 2D, page 32 on this point. And see in America Jurist for April 1837, page 96 to 113, the substance of the report of the Committee on the Judiciary in the Legislatures of Massachusetts, respecting the validity of the Act of Congress of February 18, 1793, providing for the seizure and surrender of fugitive slaves. It urges the right and duty of providing by the writ of habeas corpus or of replevin for the trial by jury of the question whether the person seized be a freeman or a slave. The Act of Congress authorizes the owner of the fugitive slave by himself or his agent to seize at once the fugitive slave and carry him before a judge of the United States or any magistrate of the county, city, or town in the state where the slave is seized, and upon satisfying the magistrate by proof that the person seized is such fugitive slave, he is to give a certificate which amounts to a warrant to remove the slave. This law is generally found to be insufficient to give the claimant the requisite constitutional protection in his property, or the fugitive due protection of his liberty, and its execution meets with embarrassment in the northern states, and several of them have endeavoured by local statutes to supply the deficiency. The Constitution of the United States and the Act of Congress evidently contemplated summary ministerial proceedings, and not the ordinary course of judicial investigation. Stories com on the Constitution of U.S. Volume 3, 677. Wright v. Deacon, 5s, and Rawle, 62. In the last case, it was held that the writ of homine replegiando did not lie to try the right of the fugitive to freedom, though on the return of the fugitive to the state from which he fled, his right to freedom might be tried. See further, Infra, Volume 2, 32, Notes C, D, Ibid, 257, Note 6. It seems to be an unsettled question whether statute provisions relative to the surrender of fugitives from labour in obedience to the Constitution of the United States be of exclusive or only of concurrent jurisdiction in the states. End of Section 31. Section 32 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1, by James Kent. Section 32. Lecture 19 of Constitutional Restrictions on the Powers of the Several States. We proceed to consider the extent and effect of certain constitutional restrictions on the authority of the separate states. As the Constitution of the United States was ordained and established by the people of the United States for their own government as a nation, and not for the government of the individual states, the powers conferred and the limitations on power contained in that instrument are applicable to the government of the United States, and the limitations do not apply to the state governments unless expressed in terms. Footnote 1. Thus, for instance, the provision in the Constitution that private property shall not be taken for public use without just compensation was intended solely as a limitation on the exercise of power by the government of the United States and does not apply to the state governments. Footnote A. The people of the respective states are left to create such restrictions on the exercise of the power of their particular governments as they may think proper, and restrictions by the Constitution of the United States on the exercise of power by the individual states in cases not repugnant to the grant of power to the United States are expressly enumerated. Quote, "No state," end quote, says the Constitution, footnote B, quote, "shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility." Page 433 footnotes. A. Barron versus the Mayor and City Council of Baltimore. 7 Peters U.S. Rep. 243. See also in the matter of Smith, 10 Wendell, 449. B. Article 1, Section 10. 1. Quote, that the first 10 articles of amendment were not intended to limit the powers of the state governments in respect to their own people, but to operate on the national government alone, was decided more than half a century ago, and that decision has been steadily adhered to since. End quote. Spies versus Illinois, 123, U.S., 131, 116. 1887. No state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, nor lay any duty on tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded or in such imminent danger as will not admit of delay. End quote. Most of these prohibitions would seem to speak for themselves, and not to stand in need of exposition. I shall confine myself to those cases in which the interpretation and extent of some of these restrictions have been made the subject of judicial investigation. Bills of Credit. 1. Bills of Credit. Bills of credit, within the purview of the Constitution of the United States, prohibiting the emission of them, are declared to mean promissory notes or bills issued by a state government exclusively on the credit of the state and intended to circulate through the community for its ordinary purposes as money redeemable at a future day, and for the payment of which the faith of the state is pledged. Footnote A. The prohibition does not therefore apply to the notes of a state bank, drawn on the credit of a particular fund set apart for the purposes. Footnote B. Through all our colonial history, paper money was much in use, and from the era of our independence down to the date of the Constitution, bills of credit issued under the authority of the Confederation Congress or of the individual states and intended for circulation from hand to hand were universally denominated paper money. And it was to bar the governmental issues of such a delusive and pernicious substitute for cash that the constitutional prohibition was introduced. Page 434 footnotes. A. Craig versus the State of Missouri, 4 Peters U.S. Rep. 410. In the case of Briscoe versus the Bank of Kentucky, 11 Peters, 257, the question what were bills of credit of which the emission was prohibited to the states was extensively discussed. They were defined to be paper issued by the authority of a state on the faith of the state and designed to circulate as money. And under this definition, it was adjudged that a bank of the state of Kentucky, established in the name and on behalf of the state, under the direction of a president and 12 directors chosen by the legislature, and the bank exclusively the property of the state and with a capital of $2 million, and with authority to issue notes payable to bearer on demand, and receive deposits and make loans, and the notes by a subsequent act were to be received on executions by plaintiff, and if refused, further proceedings to be delayed on the judgment for 2 years, was not the issuing of bills of credit within the prohibition in the Constitution of the United States. Mr. Justice Story dissented from this decision, and said that the late C.H. J. Marshall was of opinion with him when the same case was before the court, and argued at a preceding term, and he further said that he would not distinguish the case in principle from that of Craig versus the state of Missouri. It appears to me, with great submission to the Supreme Court, that this decision not only overrules the case of Craig, but greatly impairs the force and value of the constitutional prohibition. B. Billis adds the state to M. Cords, Rep. 12. The issuing of such bills by the state of Missouri under the denomination of certificates was adjudged to be unconstitutional, though they were not made generally a legal tender, but they were, nevertheless, made receivable in payment of taxes, and by all civil and military officers in discharge of salaries and fees of office. Instruments, however, issued by or on behalf of a state, binding it to pay money at a future day for services actually received, or for money borrowed for present use, were declared not to be bills of credit within the meaning of the Constitution. Footnote A. Ex post facto laws. 2. No state can pass any ex post facto law. In Calder versus Bull, footnote B, the question on the meaning of an ex post facto law within the prohibition of the Constitution was extensively discussed. Page 435, footnotes. A. Craig versus the State of Missouri. U.B. Sup. Mr. Justice Story, in his Commentaries on the Constitution, Volume 3, page 19, seems to be of opinion that, independent of long-continued practice from the time of the adoption of the Constitution. The states would not, upon a sound construction of the Constitution, if the question was res integra, be authorized to incorporate banks with a power to circulate bank paper as currency, inasmuch as they were expressly prohibited from coining money. He cites the opinions of Mr. Webster, of the Senate of the United States, and of Mr. Dexter, formerly Secretary of War, on the same side. But the equal, if not the greater authority of Mr. Hamilton, the earliest Secretary of the Treasury, may be cited in support of a different opinion, and the contemporary sense and uniform practice of the nation are decisive on the question. Bank paper, like checks and negotiable notes, circulates entirely upon private credit, and is not a coercive circulation. It is at every person's option to receive or reject it. The Constitution evidently had in view bills of credit issued by law, in the name and on the credit of the state, and intended for circulation from hand to hand as money, and of which our history furnished so many pernicious examples. The words of the Constitution are, that no state shall emit bills of credit. The prohibition does not extend to bills emitted by individuals singly or collectively, whether associated under a private agreement for banking purposes, as was the case with the Bank of New York prior to its earliest charter in the winter of 1791, or acting under a charter of incorporation, so long as the state lends not its credit or obligation or coercion to sustain the circulation. In the case of Briscoe versus the Bank of the Commonwealth of Kentucky, this question was put at rest by the opinion of the court that there was no limitation in the Constitution on the power of the states to incorporate banks, and their notes were not intended to be inhibited, nor were considered as bills of credit. 11 Peters, 257, 345, 349. B. 3 Dallas, 386. The legislature of Connecticut had, by a resolution or law, set aside a decree of the Court of Probates rejecting a will, and directed a new hearing before the Court of Probates, and the point was whether that resolution was an ex post facto law prohibited by the Constitution of the United States. It was held that the words ex post facto laws were technical expressions, and meant every law that made an act done before the passing of the law, and which was innocent when done, criminal, or which aggravated a crime, and made it greater than it was when committed, or which changed the punishment, and inflicted a greater punishment than the law annexed to the crime when committed, or which altered the legal rules of evidence, and received less or different testimony than the law required at the time of the commission of the offence, in order to convict the offender. Footnote 2. The Supreme Court concluded that the law or resolution of Connecticut was not within the letter or intention of the prohibition, and was, therefore, lawful. Footnote A. Afterwards, in Fletcher v. Peck, footnote B, it was observed that an ex post facto law was one which rendered an act punishable in a manner in which it was not punishable when it was committed. This definition is distinguished for its comprehensive brevity and precision, and it extends to laws passed after the act, and affecting a person by way of punishment of that act, either in his person or estate. Ex post facto laws relate to penal and criminal proceedings, which impose punishments or forfeitures, and not to civil proceedings, which affect private rights retrospectively. Retrospective laws and state laws, divesting vested rights, unless ex post facto, or impairing the obligation of contracts, do not fall within the prohibition contained in the Constitution of the United States, however repugnant they may be to the principles of sound legislation. Footnote C. Footnote 4. Page 436 footnotes. A. Strong versus the State. 1 Blackford's Ind. Rep. 193. S.P. B. 6 Cranch. 138. C. Calder versus Bull. 3 Dallas. 386. Satterley versus Mathewson. 2 Peters U.S. Rep. 413. Watson versus Mercer. S. Ibid. 88. 2. Quote, the terms ex post facto apply only to criminal laws which make acts innocent when done, criminal. Or, if criminal when done, aggravate the crime, or increase the punishment, or reduce the measure of proof. End quote. 3. Retroactive legislation is such as, operating upon matters previously established, changes their legal characteristics or effects. When regarded as contemplating such consequences, it may properly be called retrospective. Within it, as within a very general class, are included ex post facto laws, laws impairing the obligation of contracts, and some others. The phrase ex post facto, in its literal meaning, by an after act, would apply to all retroactive laws, but, as explained in the text, its application has been, by technical use, restricted to retroactive laws of a penal or criminal character. Kring versus Missouri, 107, U.S. 221, 227, 1882. In its restricted sense, it is obnoxious to constitutional prohibition. Laws impairing the obligation of contracts are described, and their unconstitutionality is shown. Post, pages 413 to 423. The other laws mentioned above as retroactive tend to neither the jeopardizing of offenders nor the impairment of contracts. On the whole, they present less odious features. Some are eminently just, as, for instance, acts to effectuate the real intention of parties to conveyances by curing and confirming defective execution, acknowledgement, and registration. On the other hand, some of them, such as acts divesting vested estates and other rights, are unjust in the extreme degree. The two aspects in which they are thus capable of presenting themselves probably account for the circumstance that while the federal constitution places no restriction upon them, they are prohibited by the constitutions of certain of the states. As to this description of retroactive laws, see farther, post, page 455, 456. State courts no control over the federal courts. 3. No state can control the exercise of any authority under the federal government. The state legislatures cannot annul the judgments nor determine the extent of the jurisdiction of the courts of the Union. This was attempted by the legislature of Pennsylvania and declared to be inoperative and void by the Supreme Court of the United States in the case of the United States versus Peters. Footnote A. Such a power, as we have heretofore seen, necessarily resides in the Supreme Judicial Tribunal of the nation. It has also been adjudged that no state court has authority or jurisdiction to enjoin a judgment of the Circuit Court of the United States or to stay proceedings under it. This was attempted by a state court in Kentucky and declared to be of no validity by the Supreme Court of the United States in M. Kim v. Voorhees. Footnote B. No state tribunal can interfere with seizures of property made by revenue officers under the laws of the United States, or interrupt by process of replevin, injunction, or otherwise the exercise of the authority of the federal officers, and any intervention of state authority for that purpose is unlawful. This was so declared by the Supreme Court in Slocum v. Mayberry. Footnote C. Nor can a state court issue a mandamus to an officer of the United States. Page 437 footnotes. A. 5 Cranch 115. B. 7 Cranch 279. C. 2 Wheaton 1. This decision was made in the case of M. Clooney v. Silliman, footnote A, and it arose in consequence of the Supreme Court in Ohio sustaining a jurisdiction over the Register of the Land Office of the United States in retrospective to his ministerial acts as register, and claiming a right to award a mandamus to that officer to compel him to issue a final certificate of purchase. The principle declared by the Supreme Court was that the official conduct of an officer of the government of the United States can only be controlled by the power that created him. If the officer of the United States who seizes, or the court which awards the process to seize, has jurisdiction of the subject matter, then the inquiry into the validity of the seizure belongs exclusively to the federal courts. But if there be no jurisdiction in the instance in which it is asserted, as if a marshal of the United States, under an execution in favor of the United States against A, should seize the person or property of B, footnote B, then the state courts have jurisdiction to protect the person and the property so illegally invaded. And it is to be observed that the jurisdiction of the state courts in Rhode Island was admitted by the Supreme Court of the United States in Slocum v. Mayberry upon that very ground. In the case of the United States v. Barney, footnote C, the District Judge of Maryland carried to a great extent the exemption from state control of officers or persons in the service of the United States and employed in the transportation of the mail. He held that an innkeeper had no lien on the horses which he had fed, and which were employed in the transportation of the mail. The Act of Congress of March 1790 prohibited all wilful obstruction of the passage of the mail, and a claim for debt would not justify the stopping of the mail or the means necessary to transport it. either upon principles of common law or upon the statute. The judge stated, in this case, that even a stolen horse found in the mail stage could not be seized, nor could the driver, being in debt, or having committed an offence, be arrested in such a way as to obstruct the passage of the mail. But in a subsequent case in the Circuit Court of Pennsylvania, footnote D, it was held that the Act of Congress was not to be so construed as to endanger the public peace and safety. Page 438 footnotes. A. 6 Wheaton, 598. B. Bruen v. Ogden, 6 Halstead, 370. Dunn v. Vale, 7 Martins, Louisiana, Rep. 416. C. 3 Hall's Law Journal, 128. D. United States v. Hart, 1 Peters, Sir, Rep. 390. The carrier of the mail, driving through a populous city with dangerous rapidity and contrary to a municipal ordinance, may be stopped and the mail temporarily detained by an officer of the city. So, if the officer had a warrant against a felon in the stage, or if the driver should commit murder in the street and then place himself on the mail stage box, he would not be protected from arrest, though a temporary stoppage of the mail might be the consequence. The public safety in the one case is of more moment than the public inconvenience which it might produce in the other. But while all interference on the part of the state authorities with the exercise of the lawful powers of the national government has been, in most cases, denied, there is one case in which any control by the federal over the state courts, other than by means of the established appellate jurisdiction, has equally been prevented. In Diggs and Keith versus Walcott, footnote A, it was decided generally that a court of the United States could not enjoin proceedings in a state court, and a decree of the Circuit Court of the United States for the District of Connecticut was reversed because it had enjoined the parties from proceeding at law in a state court. So, in Ex parte Cabrera, footnote B, it was declared that the Circuit Courts of the United States could not interfere with the jurisdiction of the courts of a state. Footnote 4. These decisions are not to be contested, and yet the district judge of the Northern District of New York, in the spring of 1823, in the case of Lansing and Thayer versus the North River Steamboat Company, enjoined the defendants from seeking in the state courts, under the acts of the state legislatures, the remedies which those acts gave them. This would appear to have been an assumption of the power of control over the jurisdiction of the state courts, in hostility to the doctrine of the Supreme Court of the United States. In the case of Kennedy versus Earl of Cassilis, footnote C, an injunction had been unwarily granted in the English Court of Chancery to restrain a party from proceeding in a suit in the Court of Sessions in Scotland, where the parties were domiciled. Page 439 footnotes. A. 4 Cranch, 179. B. 1 Wash, Sir, Rep. 232. C. 2 Swarst, Rep. 330. but in the subsequent case of Bushby versus Monday, 5 Mad CH Rep 297, the Vice-Chancellor granted an injunction under special circumstances to restrain proceedings in the Court of Sessions in Scotland. 4. It is no interference with the jurisdiction of a state court for a federal court to enjoin the assertion of a title fraudulently obtained by proceedings in such state court. Robb versus Voss, 36, Fed Rep. 132, 133. 1888. When the jurisdiction of a federal court has attached, such court may enjoin proceedings in the same manner subsequently begun in a state court. Sharon versus Terry, id. 337, 354 to 362. 1888. It was admitted that the Court of Sessions was a court of competent jurisdiction and an independent foreign tribunal, though subject to an appeal, like the Court of Chancery, to the House of Lords. If the Court of Chancery could in that way restrain proceedings in the Court of Sessions, the Sessions might equally enjoin proceedings in Chancery, and thus stop all proceedings in either court. Lord Eldon said he never meant to go further with the injunction than the property in England, and he, on motion, dissolved it in toto. No state can impair the obligation of contracts. 4. No state can pass any law impairing the obligation of contracts. We come next to a prohibition of great moment and affecting extensively and deeply the legislative authority of the states. There is no prohibitory clause in the Constitution which has given rise to more various and able discussion or more protracted litigation than that which denies to any state the right to pass any law impairing the obligation of contracts. I shall endeavour to give a full and accurate view of the judicial decisions defining and enforcing this prohibition. The case of Fletcher versus Peck, footnote A, first brought this prohibitory clause into direct discussion. The legislature of Georgia, by an act of the 7th of January 1795, authorized the sale of a large tract of wild land, and a grant was made by letters patent in pursuance of the act to a number of individuals under the name of the Georgia Company. Fletcher held a deed from Peck for a part of this land under a title derived from the patent, and in the deed Peck had covenanted that the state of Georgia was lawfully seized when the act was passed, and had good right to sell, and that the letters patent were lawfully issued, and the title has not since been legally impaired. The action was for breach of covenant, and the breach assigned was that the letters patent were void, for that the legislation of Georgia, by Act of 13th of February 1796, declared the preceding act to be null and void, as being founded in fraud and corruption. Page 440 footnotes. The New York Court of Chancery has disclaimed any such jurisdiction in respect to a foreign suit previously commenced, though it was in possession of jurisdiction over the person of the party. Mead versus Merritt, 2 page 402. A. 6 Cranch 87. One of the questions presented to the Supreme Court upon the case was whether the legislature of Georgia could constitutionally repeal the Act of 1795 and rescind the sale made under it. The court declared that when a law was in its nature a contract, and absolute rights have vested under that contract, a repeal of the law could not divest those rights, nor annihilate or impair the title so acquired. A grant was a contract within the meaning of the Constitution. The words of the Constitution were construed to comprehend equally executory and executed contracts, for each of them contains obligations binding on the parties. A grant is a contract executed, and a party is always estopped by his own grant. A party cannot pronounce his own deed invalid, whatever cause may be assigned for its invalidity, and though that party be the legislature of a state. A grant amounts to an extinguishment of the right of the grantor, and implies a contract not to reassert that right. A grant from a state is as much protected by the operation of the provision of the Constitution as a grant from one individual to another. The state is as much inhibited from impairing its own contracts, or a contract to which it is a party, as it is from impairing the obligation of contracts between two individuals. It was, accordingly, declared that the estate held under the Act of 1795, having passed into the hands of a bona fide purchaser for a valuable consideration, the state of Georgia was constitutionally disabled from passing any law whereby the estate of the plaintiff could be legally impaired and rendered void. The next case that brought this provision in review before the Supreme Court was that of the State of New Jersey versus Wilson, footnote A. It was there held that if the legislature should declare by law that certain lands to be thereafter purchased for the use of the Indians should not be subject to any tax, such a legislative act amounted to a contract, which could not be rescinded by a subsequent legislature. In that case, the colonial legislature of New Jersey, in 1758, authorized the purchase of lands for the Delaware Indians, and made that stipulation. Lands were accordingly purchased, and conveyed to trustees for the use of the Indians, and the Indians released their claim to other lands, as a consideration for this purchase. The Indians occupied these lands until 1803, when they were sold to individuals under the authority of an act of the legislatures, and in 1804 the legislature repealed the Act of 1758, exempting those lands from taxation. Page 441 footnotes. A. 7 Cranch 164. The Act of 1758 was held to be a contract, and the Act of 1804 was held to be a breach of that contract, and void under the Constitution of the United States. The Supreme Court went again, and more largely, into the consideration of this delicate and interesting constitutional doctrine in the case of Territorial versus Taylor, footnote A. It was there held that a legislative grant, competently made, vested an indefensible and irrevocable title. There is no authority or principle which could support the doctrine that a legislative grant was revocable in its own nature, and held only durante bene placito. nor can the legislature repeal statutes creating private corporations or confirming to them property already acquired under the faith of previous laws, and by such repeal vest the property in others without the consent or default of the corporators. Such a proceeding would be repugnant to the letter and spirit of the Constitution and to the principles of natural justice. But it was in the great case of Dartmouth College versus Woodward, footnote B, that the inhibition upon the states to impair by law the obligation of contracts received the most elaborate dissension and the most efficient and instructive application. It was there held that the charter granted by the British Crown to the trustees of Dartmouth College in 1769 was a contract within the meaning of the Constitution and protected by it, and that the college was a private charitable institution not liable to the control of the legislature, and that the act of the legislature of New Hampshire altering the charter in a material respect, without the consent of the corporation, was an act impairing the obligation of the charter, and consequently unconstitutional and void. The Chief Justice, in delivering the opinion of the court, observed that the provision in the Constitution never had been understood to embrace other contracts than those which respect property, or some object of value, and confer rights which may be asserted in a court of justice. Dartmouth College was a private eleemosynary institution, endowed with a capacity to take property for objects unconnected with government, and its funds were bestowed by individuals on the faith of the charter, and those funds consisted entirely of private donations. Page 442 footnotes. A. 9 Cranch 43. B. 4 Wharton 518. The corporation was not invested with any portion of political power, nor did it partake, in any degree, in the administration of civil government. It was the institution of a private corporation for general charity. The charter was a contract to which the donors, the trustees of the corporation, and the Crown were the original parties, and it was made on a valuable consideration for the security and disposition of property. The legal interest in every literary and charitable institution is in trustees, and to be asserted by them, and they claim or defend in behalf of the religion, charity, and education for which the corporation was created, and the private donations made. Contracts of this kind, creating these charitable institutions, are most reasonably within the purview and protection of the Constitution. This contract remained unchanged by the Revolution, and the duties as well as the powers of the government devolved on the people of New Hampshire, but the act of that state which was complained of transferred the whole power of governing the college from trustees appointed according to the will of the founder, expressed in the charter, to the executive of New Hampshire. The will of the state was substituted for the will of the donors in every essential operation of the college. The charter was reorganized in such a manner as to convert a literary institution, molded according to the will of its founders and placed under the control of private literary men, into a machine entirely subservient to the will of government. This was, consequently, subversive of that contract, on the faith of which the donors invested their property, and the act of the legislature of New Hampshire was therefore held to be repugnant to the Constitution of the United States. The same course of reasoning, and leading to the same conclusion, was adopted and expressed by some of the other judges. In the opinion given by Judge Story, he added some new and interesting views of the nature of the contracts which the Constitution intended to protect. He denied the power of the legislature to dissolve even the contract of marriage without a breach on either side, and against the wishes of the parties. A dissolution of the marriage obligation without any default or assent of the parties may as well fall within the prohibition of the Constitution as any other contract for a valuable consideration. A man has as good a right to his wife as to the property acquired under a marriage contract, and to divest him of that right without his default and against his will would be as flagrant a violation of the principles of justice as the confiscation of his estate. Footnote A. The prohibitory clause he also considered to extend to other contracts, beside those where the parties took for their own private benefit. A grant to a private trustee for the benefit of a particular cestui quae trust, or for any special private or public charity, cannot be the less a contract, because the trustee takes nothing for his own benefit. Nor does a private donation, vested in a trustee for objects of a general nature, thereby become a public trust, which the government may, at its pleasure, take from the trustee. Government cannot revoke a grant, even of its own funds, when given to a private person or to a corporation for special uses. It has no other remaining authority but what is judicial to enforce the proper administration of the trust. Nor is a grant less a contract, though no beneficial interest accrues to the possessor. Many a franchise, whether corporate or not, may, in point of fact, be of no exchangeable value to the owners, and yet they are grants within the meaning and protection of the Constitution. All incorporeal hereditaments, as immunities, dignities, offices, and franchises, are rights deemed valuable in law, and whenever they are the subject of a contract or grant, they are just as much within the reach of the Constitution as any other grant. All corporate franchises are legal estates. They are powers coupled with an interest, and corporators have vested rights in their character as corporators. Upon this doctrine, it was insisted that the trustees of Dartmouth College had rights and privileges under the Charter of which they could not be divested by the legislature without their consent. The act of the legislature did impair their rights and vitally affect the interest of the college under the Charter. Page 444 footnotes. A. In Maguire v. Maguire, 7 Dunners, K. Rep. 184. C.H. J. Robinson considered the contract of marriage to be sui generis and unlike ordinary or commercial contracts. It was publici juris and created by the public law, subject to the public will, and not to that of the parties who could not dissolve it by mutual consent. It was much more than a contract. It established fundamental domestic relations, and he did not think it was embraced by the constitutional interdiction of legislative acts impairing the obligation of contracts. This appears to be the soundest construction of the constitutional provision alluded to. If a grant of franchise be made to A in trust for a special purpose, the grant cannot be revoked, and a new grant made to A, B, and C for the same purposes without violating the obligation of the first grant. If property be vested by grant in A and B for the use of a general charity or private eleemosynary foundation, the obligation of the grant is impaired when the estate is taken from their exclusive management and vested in them in common with 10 other persons. I have thus stated the substance of the argument of the Supreme Court in this celebrated case, and it contains one of the most full and elaborate expositions of the constitutional sanctity of contracts to be met within any of the reports. The decision in that case did more than any other single act proceeding from the authority of the United States to throw an impregnable barrier around all rights and franchises derived from the grant of government, and to give solidity and inviolability to the literary, charitable, religious, and commercial institutions of our country. The same prohibitory clause in the Constitution came again under discussion in the case of Green versus Biddle. Footnote A. It was observed by the court that the objection to a law, on the ground of its impairing the obligation of contracts, could never depend upon the extent of the change which the law effects in it. Any deviation from its terms, by postponing or accelerating the period of performance which it prescribes, imposing conditions not expressed in the contract, or dispensing with the performance of those which are expressed, however minute or apparently immaterial in their effect upon the contract, or upon any part or parcel of it, impairs its obligation. Upon this principle it is, that if a creditor agrees with his debtor to postpone the day of payment, or in any other way to change the terms of the contract without the consent of the surety, the latter is discharged, although the change was for his advantage. The material point decided in that case was that a compact between two states was a contract within the constitutional prohibition. The terms contract and compact were synonymous, and a contract is an agreement of two or more parties to do or not to do certain acts. The court declared that the doctrine had been already announced and settled, that the Constitution embraced all contracts executed and executory, and whether between individuals or between a state and individuals, and that a state had no more power to impair an obligation into which she herself had entered than she had to impair the contracts of individuals. Page 445, footnotes. A. S. Wheaton 1. 4. Millers, Louis, Rep. 94, SP. Another case which led to a very extensive inquiry into the operation and effect of the constitutional prohibition upon the states not to pass laws impairing the obligation of contracts was that of Sturgis versus Crown and Shield. Footnote A. The defendant was sued in one of the federal courts upon 2 promissory notes, given in March 1811, and he pleaded his discharge under an Insolvent Act of New York, passed in April 1811. This Insolvent Act was retrospective, and discharged the debtor upon his single petition, and upon his surrounding his property in the manner therein prescribed, without the concurrence of any creditor, from all his pre-existing debts, and from all liability and responsibility by reason thereof. The Chief Justice, in the opinion which he delivered on behalf of the court, admitted that until Congress exercised the power to pass uniform laws on the subject of bankruptcy, the individual states may pass bankrupt laws, provided those laws contain no provision violating the obligation of contracts. Footnote 5. It was admitted that the states might by law discharge debtors from imprisonment, for imprisonment was no part of the contract, but only a means of coercion. It was also admitted that they might pass statutes of limitation, for such statutes relate to the remedy, and not to the obligation of the contract. Footnote B. It was further stated by the court that the insolvent laws of far the greater number of the states only discharged the person of the debtor, and left the obligation to pay in full force, and to this the Constitution was not opposed. But a law which discharged the debtor from his contract to pay a debt by a given time without performance, and released him without payment entirely from any future obligation to pay, impaired, because it entirely discharged, the obligation of that contract, and subsequently the discharge of the defendant under the Act of 1811 was no bar to the suit. Page 446 footnotes. A. 4 Wheaton, 122. B. In the case of Baumgardner versus Circuit Court, 4 Missouri, R. 50, it was decided that a statute directing a stay of execution on judgments was unconstitutional, both as it regarded the Constitution of Missouri and of the United States. 5. In this case, a bankrupt law is defined as, quote, a statute which, upon a surrender of the property of the bankrupt, discharges both his person and his future acquired property from the payment of his debts. End quote. Page 176. The court held that the obligation of a contract was not fulfilled by a cessio bonorum, for the parties had not merely in view the property in possession when the contract was made, but its obligation extended to future acquisitions, and to release them from being liable impaired the obligation of the contract. There was a distinction, in the nature of things, between the obligation of a contract and the remedy to enforce that obligation, and the latter might be modified as the wisdom of the legislature should direct. Footnote 6. But the Constitution intended to restore and preserve public confidence completely. It intended to establish a great principle, that contracts should be inviolable. The case in which this decision was made was one in which the contract was existing when the law was passed, and the court said that their opinion was confined to the case. A distinction has been made between the case of a contract made before and one made after the passing of the Act. Page 447 footnotes. A. 16 Johns Rep. 233. B. 13 Mass Rep. 1. 6. That a contract shall be binding is a part thereof. In contracting, the parties assume the obligation which the law provides. They may or may not have reference to the particular means by which of the time this obligation is enforceable, but they always have reference to the continued existence of the obligation itself. When, therefore, by an act subsequently passed, all means of enforcing the obligation is removed, or is so hampered by conditions or restrictions as to be rendered practically unavailable, the obligation, by ceasing to obligate, loses its legal existence, and the contract which embodied it is insofar impaired. But when an act altering, substituting, or abolishing a pre-existing means of enforcement leaves to the parties some such substantive and practically available means, it leaves the obligation in force, and the contract in that respect unimpaired. Hence is drawn the distinction between laws that impair the obligation of contracts through deprivation of the remedy, and laws that affect the remedy only. The former are in violation of the Constitution, while the latter are not. Sturgis v. Crowninshield. 4. Wheat, 122, 197, 1819. Ogden v. Saunders. 12. Id. 213, 234, 1827. Mason v. Hale. Id. 370, 378, 1827. Beers v. Horton. 9. Pitt. 329, 359. 1835. Bronson v. Kinsey. 1. Howe. 311, 319. 1843. McCracken v. Hayward. 2. Id. 608, 612. 1844. Planters Bank v. Sharp. 6. Id. 301, 325, 1848. Van Hoffman v. City of Quincy. 4. Wall, 535, 553, 1866. Gunn v. Barry. 15. Id. 610, 623, 1872. Walker v. Whitehead. 16. Id. 314, 317, 1872. Tennessee v. Sneed. 96. U.S. 69, 73, 1877. Edwards v. Kiersey. Id. 595, 599, 1877. Louisiana v. New Orleans. 102. Id. 203, 206, 1880. Antony v. Greenhow. 107. Id. 769, 778, 1882. Seibert v. Lewis. 122. Id. 284, 294. 1886. It was taken by the Supreme Court of New York in Mather v. Bush, footnote A, and by the Chief Justice of Massachusetts in Blanchard v. Russell, footnote B, and was relied on as a sound distinction by the Court of Chancery of New York in Hicks v. Hotchkiss, footnote A, footnote 7. The doctrine of these cases is that an insolvent act in force when the contract was made did not, in the sense of the Constitution, impair the obligation of that contract, because parties to a contract have reference to the existing laws of the country where it is made, and are presumed to contract in reference to those laws. It is an implied condition of every contract that the party shall be absolved from its performance if the event takes place which the existing law declares shall dispense with the performance. The decision in Sturgis v. Crowninshield is supposed to be consistent with that distinction, when it establishes the principle that an insolvent act discharging a debtor from his contract existing when the law passed, so that his future acquisitions could not be touched, is unconstitutional, and the discharge obtained under it void. But the Supreme Court of the United States in M. Millen v. M. Neal, footnote B, went a step farther and held that a discharge under a state insolvent law existing when the debt was contracted was equally a law impairing the obligation of contracts, and equally within the principle declared in Sturgis v. Crowninshield. This was a discharge under the insolvent law of a different government from that in which the contract was made. It remains yet to be settled whether it be lawful for a state to pass an insolvent law which shall be effectual to discharge the debtor from a debt contracted after the passing of the Act, and contracted within the state making the law. The general language of the court would seem to reach even this case, but the facts in the case decided do not cover this ground, and the cases decided are not authority to that extent. It will be perceived that the power of the states over this subject is, at all events, exceedingly narrowed and cut down. And as the decisions now stand, the debt must have been contracted after the passing of the Act, and the debt must have been contracted within the state, and between citizens of the state, or else a discharge will not extinguish the remedy against the future property of the debtor. Footnote C. Page 448 footnotes. A. 7 Johns. Ch. Rep. 297. B. 4 Wheaton 209. C. In Smith v. Parsons, 1 Hammond, Ohio, Rep. 236, and in Hempstead v. Reed, 6 Con. Rep. 480, the power of the states over contracts was understood and declared to be confined within the precise limits mentioned in the text. See also Volume 2, page 392-393. The result of the decisions, says Judge Story, 3 Const. U.S. 15, 256, is that state insolvent laws lawfully apply to all contracts made within the state between citizens of the state. 2. They do not apply to contracts made within the state between a citizen of the state and a citizen of another state. 3. Nor to contracts not made within the state, and the contracts so protected are equally so from the prospective as well as retrospective legislation. But if a creditor out of the state voluntarily makes himself a party to the proceedings under the insolvent law of a state and accepts a dividend, he is bound by his own act and is deemed to have waived his extraterritorial immunity. In Satterley v. Mathewson, 2 Peters, U.S. Rep. 380, the Supreme Court of the United States held that no part of the Constitution of the United States applied to a state law which divested rights which were vested by law in an individual, provided its effect be not to impair the obligation of a contract. It was further held that retrospective taxes were not within the constitutional prohibition, provided they did not impair the obligation of contracts or partake of the character of ex post facto laws. It has also been decided that a state government may tax state banks co-nomine at discretion, and that it would not be a violation of the contracts creating the banks. Providence Bank v. Billings, 4 Peters, U.S. Rep. 514. 7. Lehigh Water Company v. Easton, 121 U.S. 388, 391, 1886. End of section 32.